Send order for tunes, please hand over first. Then we'll take the other mentions.
My lord, raised to listen.
Application for substitution. Lordship, your of the appeal is 2000.
Applications and order for tunes, please hand over the slips. Other matters will take up after this is over. Yes, from that side. We're not adding appeals now. Not being able to touch the appeals. No, that's useless. Let us dispose of some appeals. Yes.
My lord, may I be permitted to mention my two matters for release, my lord.
Yes, please hand over. To be mentioned for release only.
This is hearing matter. These matters were taken on 2 occasions, but due to changes of determination, the matters.
Right now we cannot add. Yes.
Sometimes
Year of the appeal is 2016.
Let us see if you dispose of some appeals only.
Year of the appeal is 2016. Lower court record came. I'm praying for preparing paper book, Lordship.
Paper book, right, to be mentioned and hand over the slip. Oh, we don't have determination. Sorry. Ma'am, we don't have determination. কত থেকে আছে আমাদের? 19 onwards. We have determination only 19 onwards. 16 some other bench. Yes.
Hearing of one appeal, my lord, the paper book is very issue is there are 6 other matters which may come up, my lord. Similar issue.
Not now. For what?
Addition was in 2022 for supplying the paper book.
Well, may come back after 2 weeks.
To mention an appeal which is
After a year, please. Let us dispose of some appeals, then we'll definitely add. We don't have any fun in refusing appeal hearings. But you can't touch these appeals also. Yes, please.
specially assigned appeal, Lordship, is due to appear on 19th, Lordship. The problem is, Lordship, I am led by Mr. Dutt, Shumon Dutt. He is out of station
No
on
difficulty.
19th.
If it's already scheduled to appear on a date, let it appear on that date, renew your prayer on that date. And
Lordship,
inform your other
allow
side.
me, because we are appearing for the appeal.
Whatever, when it appears,
Serial
we'll take
very
up.
good.
Need not mention beforehand, but mention.
I've intimate
Intimate the other side.
Yes. We are the appeal, exactly.
May I have your lordship
Lordship's kind leave to mention a matter. My lord, by 2nd July 2025, direction was passed to file, my lord, for lower court records and for, my lord, filing paper book, 8 weeks time given. My lord, today itself it's not, my lord. We are suffering interim order. Let the matter be appeared as to be mentioned, my lord, so that further detection may be passed.
Yes.
I'm grateful.
I have to mention 3 connected mandamus appeals, specially assigned before your lordship. My lord, these appeals, my lord, arise out of an order.
Have they ever appeared before us?
Yes, your lordship had the occasion to take up, but due to some resolution, since the other side did not appear, your lordship said we'll take it up on the next day, but thereafter, my lord, it went down the list and the business did not progress.
Can't. Right.
Only difficulties, my lord, the writ petition was allowed, directing the bank to defreeze the account. In a disposed of writ petition, an application has been allowed for addition of party in a disposed of writ petition.
Right now, we
That will
appearing cannot.
in the contempt, and the contempt is also stayed because of the pendency of the appeal.
Pendency of the appeal does not operate as stay.
But court-
Cite those judgments before the court.
May I have your lordship kindly
As a
instant appeal without the certified copy.
We are short of days. We are taking up some matter or the other some particular days.
Leave to file this instant appeal without the certified copy, and it is
Yes.
very urgent.
Yes.
My lord,
Leave is granted, it will appear tomorrow.
may I have your lordship kindly leave to mention a matter for upgradation, your lordship, and
Forget
clarification.
it.
Your lordship kindly hang for 30 seconds, your lordship. This matter never,
Give you 30 seconds.
your lordship, this matter was filed just after the summer vacation, your lordship, and thereafter this matter came before lordship for once, and thereafter this matter was determined to the division bench of Justice Shromensen, and due to one of the judges being used to appear for one of the parties, the judge recused himself, and then your lordship, this matter came before your lordship, and it has never came before a
How
hearing.
does it make it special?
Your lordship, my client is facing an injunction since May.
So once we have refused, they are also suffering from something or the other. How does it make it special?
Your lordship,
Sorry, you have got your 30 seconds? No. Yes. Extension is on.
My lord's kind leave, my lord, it's an application connected to second appeal, my lord, not yet admitted during pendency. At order 41 state, during pendency, position has been taken, my lord, on this Friday, my lord.
That doesn't make the appeal infructuous automatically.
Doesn't mean, my lord, I tell your lordship, what is
You
that?
have 144 of the city.
No, my executing court has granted a stay, my lord. My second appeal is
What are you
pending.
mentioning? What are you...
But this is an application, my lord. I have stated everything, my lord.
The appeal has not been admitted under order 41.
Not yet admitted, my lord. It is pending.
Then it can appear under the admission.
Yes, my lord, it can be appeared
Mention
tomorrow,
as
my
order
lord.
41. I'll give
But
that
I give
number,
it a-
can number along
But
with
it's all, it has been affirmed, my lord. I have stated everything what has happened.
mention it as an order 41 matter tomorrow. under heading order 41. Along with that, the can
I'm
number
giving the
also
slip
mentioned in a
today,
bracket.
it will be appear on tomorrow, my lord.
Renewal application.
Cannot appear tomorrow.
My renewal application for the
Fine.
lease has been terminated, because of which around 400 people become unemployed. So I'm on that ground, I'm praying for upgradation. It is appearing as 57 and 58. There are 400 to 500 persons in that.
See the time we have lost already 15 minutes in mentioning. We could have decided at least 3-4 order 41 matters in this time. We are not adding up.
Inclusion in list under the heading admission of appeal.
Yes, by default we said you come in late and you don't follow the court's instructions. Yes.
May I pray for an upgradation of a matrimonial appeal?
Lordship, on 6th of August, it was directed to file paper books and that the matter would be returnable in 5 weeks. So, Lordship, I'm
No, sorry, no hearing.
Well, application, my lord.
Not applications.
Well, application for important.
Lordship, may I be permitted to mention, Lordship?
What?
Praying for restoration, Lordship.
Application.
Yes.
If the restoration has to be a restoration application for.
Yes, we have filed the condemnation along
You're
with the
mentioning the
restoration
application for inclusion in the list, restoration application.
Yes. But with
Get prepared, sir. Get prepared and come.
My lord, may I permit to mention matter, my lord? It's supposed to come today
What
for orders.
is-
The determination is by,
For orders?
yes,
Who directed? We.
Justice Showman Chen.
We don't know for what orders. We have to hear it afresh. Sorry, no.
My lord, this is a matter related to hearing of tribunal matter, my lord. The
We are not taking up right.
petition is extremely serious, my lord.
No.
The
Sorry,
suffering
no.
tribunal.
Call on the list, please. No further mention. দুটো দিন দেবো হিয়ারিং এর জন্য, দুটো দিন দেবো, তাহলে অন্য ম্যাটার শুনানি হবে না। অ্যাপ্লিকেশন অর্ডার ফর টেন করে করবো, সপ্তাহে তো 4টে দিন, একটা দিন 3 দিন না বসলে ওই ম্যাটার গুলো সেই দিন চলবে। সরি, accordingly FA 174/2010 is dismissed on contest without an orders to cause, thereby affirming the judgment and decree dated such and such. Formal decree be drawn up, interim orders if any stand vacant. ওটা বলে এসছে ফাইলটা। Yes.
On behalf of the respondent number 1.
You have written respondent number 1.
Yes, Lordship.
দেখি দাও আমাকে দাও। Yes. Your closing arguments, it has already.
And kindly excuse us, my lord, we have used 2 new judgments, which we
No,
have
you
not.
cannot.
Why?
No. After
Already it's there in the tribunal's order, also in the before the controller.
But you did not rely on those at the time of hearing.
And Money Square has relied both the judgments.
You know, we can't.
Then, my lord, I'm
Which are the judgments? Tell us.
my lord, one is 2001
You just check up. আপনার কপিটা দিয়ে দিন তো petition.
2004 once.
41. My lord, should we mark it or?
You just give a cross and.
Yes. Because they relied 2 new judgments to counter that.
They have relied on 2 new judgments. Which is not
Yes.
cited at the time.
Yes.
Yes, Mr. Basu, you have relied.
He's right, because I found out that's 2 judgments. He's right.
Then it cancels out each other. Give us. Written notes of arguments filed by the parties today be kept on record. Hearing is concluded and
Principle of
the matter is reserved for judgment.
আমারও তাই।
Principle of law is same.
Principal law is the same, Mr. Basu, but new judgments are not cited in written notes.
But I could not find it.
You cancel out each other. Both of you are equally guilty, so we take both. Next.
হয়ে গেছে।
Written note. Yes.
Yes, sir. One additional note, Lord, only on that prospective overruling point. Yeah.
Additional note. Where are the original notes?
Original note of that compilation along with the judgments and all. It's spirally bound. This point I had taken. Spiral bound note.
After that, also, we are not aware of what he is filing. We are additional what he's doing, giving it.
The
Additional
prospective
overruling
has
notes
already-
of arguments.
Notes of arguments.
Notes of arguments. But
Notes of argument was already filing with the compilation.
Yes,
perhaps.
yes. I took an additional point of
Yes,
prospective
filing
overruling.
no, you have argued these judgments.
Yes,
You
yes.
cited these judgments at the time of hearing.
Golaknath I cited. And
Whatever you are now handing up, Mr. Banerjee.
yes. All are cited.
these
Yes,
during
all are
hearing?
cited. Nothing new. Golaknath দেখিনি but cited, formally cited.
এটা একটু ওনাকে দিন তো রাজেশকে প্লিজ চেক আপ নো গিভ হিম রাজেশ
ওনাকে
প্লিজ চেক আপ whether there is anything new.
দিল্লি এয়ারটেক তো আমাদের আগে থেকে cited, ঠিক আছে, অসুবিধা
Because they argued orally,
yes,
so if they put that in, if they can, they are permitted. Prospective overruling was argued.
Yes.
Was argued. That we recollect. Judgments whether cited or not, we don't recollect.
Not on prospective. Oh, no.
You have given those
Only
copies
one
of the
Golaknath.
judgments also.
Yes.
Previously.
They are there.
With the compilation.
Yes.
No.
The three judgments which have been given are the iterations of that in the compilation. One is extra Golaknath. And Delhi Airtech is the tiebreaker. So Delhi Airtech has been cited by both of us.
Don't read the entire thing, please hand over. See the two judgments with the Golaknath was not cited.
We have noted the judgment.
Prospective overruling was argued.
Prospective I argued.
Will match with our notes what they have given.
Yes, right now you cannot.
Such. Let's say, can we have a copy of the same LH?
Yes. Supplementary written notes of arguments on behalf of the appellant and written notes of arguments on behalf of the respondent numbers 1 to 20 filed today be kept on record. Full stop. Next para. Learned counsel for the learned senior counsel appearing for the respondents for the appellant points out that one additional judgment on the proposition of prospective overruling has been incorporated in the written notes of arguments. Full stop. Next para. Learned counsel for the respondents 1 to 20 is granted a day apostrophes time to ascertain as to whether the said written notes of the additional written notes of arguments is in consonance with what was argued in court during oral arguments. Full stop. Next para. Let the matter be listed tomorrow under the same heading. Full stop. A copy of the additional written notes of arguments filed by the appellant be handed over to the learned advocate for the respondents 1 to 20 at the earliest during the course of the day.
We've handed it.
We hand.
Take up. If there is anything serious, only Golaknath, if that has been cited, Golaknath is well settled. Prospective overruling was argued by them. But please check up, we'll keep it as to be mentioned tomorrow. Yes, thanks.
May it appear day after.
No.
But tomorrow I have some personal difficulty.
No difficulty. You just check up whether there is anything new. Only that. No new arguments. If you say that it's absolutely new, then we'll score through.
Great.
Item 4, no, 4. Yes. Yes, Ms. Maiti, yes. You took time on the last occasion.
Yes.
Yes, what is the matter?
One very outset, I just submitted to your
Please take the microphone. Ms. Maiti, please take the microphone a bit closer to you.
Mr. Sukanta Das is for caveator, but it was file was not.
Order button, if you don't admit, then he doesn't get a copy.
Instantly, I can hand over the same.
Hand over a copy of the application. Why not? Give it. He had lodged a caveat. Afterwards.
Yes. No. On 2023, my lord, this is appeal of 2023. I have filed that.
Please hand over a copy, Ms. Maiti.
Only 9.
What are you waiting for? Hand over.
Only for 9 CD.
Take the copy.
Yes, ma'am.
Where is the copy?
Your lordship.
State you are handing over.
Not here, I shall. Yes.
Only application.
Yes.
Is entitled to Ms. Maiti know that. Yes, what is the matter?
Lord, the defendant number 1 is the only contesting defendant, my lord, who is the appellant before your lordship. First of all, I shall place before your lordship the Purchinama of the family.
What is the suit for? What was the suit for?
Suit for declaration, partition, and injunction.
Decreed by both courts.
No, judgment of reversal.
Reversal. Preliminary degree or final degree?
Final degree.
Final degree.
Final degree.
Preliminary degree was not challenged by any party.
At that time, my lord, it was not challenged because I was not a party there.
At that time means you have never challenged.
Yes.
So you are
now
challenging the
my
final degree.
two suits are there. One was filed by me in the year 1986. That was degreed, and
Your suit was for what?
partition.
Partition. Their suit also for partition.
This is also partition. That has been done by some other
In
family
this particular, you are challenging a final degree of a partition suit
Yes,
passed by the appellate court.
my lord.
Trial court dismissed the suit. Dismiss the suit.
This is the suit
Acha.
filed by other
Other part. Their suit was dismissed by the trial court.
This is by the trial court and
Appellate
allowed by
court-
the appeal allowed. Appeal was allowed.
Appeal was allowed, and what was done? Preliminary degree could have been passed. Appeal court could not have passed the final degree.
Your lordship, what I am submitting before your lordship, the partition and injunction, that was preliminary degree and final degree, both at the same time it has been passed, my lord. There is no such preliminary or final degree, my lord. Final already.
No, there is a preliminary degree of partition which has been passed.
My lord,
Preliminary partition degree which has been passed, which you are challenging now.
I am placing your lordship.
The appellate court decrees ordering portion says it is hereby declared that the shares are declared. Parties are directed to amicably divide within 3 months, failing which parties are at liberty to seek appointment of survey commissioner.
That was not
Preliminary degree.
dated.
How could the appellate court pass a final degree if the suit was dismissed by the trial court? Anyway, what is your law point, Ms. Maiti? What is your law point?
Well, point of law is this, my lord. The appeal was allowed on the ground that I have got no share there. I have got no share. That is why, my lord, I was submitting before also to place the, my lord,
First, tell us what is the substantial question of law.
my lord, point of law is this, my lord, the appeal has been allowed by dismissing by declaring the judgment and degree passed in earlier suit in 1986 is a nullity. And execution proceeding also was there. That has been, my lord, set aside by the
Nullity on what ground, Ms. Maiti?
on the ground that the degree which was passed there was not executed, and degree obtained by the petition, appellant superior lordship was also by practicing.
Please show us that portion of the judgment.
Fine.
Appellate courts.
Well, your lordship, can I come to page internal page 4.
Yes.
Decision with reason.
Okay, first, please let us know, Ms. Maiti, why was it dismissed by the trial court? On what ground? Their suit was dismissed. Why?
That no, when degree was passed there, has not been charged by the trial court, and it was also held that when the degree, they were not made party there, some of them were made party, but some of them were not made party.
Non-joinder.
Non-joinder.
And what other ground? That there's a previous decree.
Previous degree.
Decree of what? Declaration of your title.
Declaration of title and injunction. Partition. Partition, declaration of title and injunction.
There also partition degree was passed.
Yes.
Their final degree was passed in the
Yes,
previous suit.
that has been executed. I have annexed in my application.
Executed. So you took the point of res judicata.
Res judicata I have taken.
That was upheld by the trial court.
Trial court.
Let us see the appeal court now.
My lord. Appeal court order internal page 4, your lordship.
Yes. Please read out the relevant portion.
My lord.
You're reading for the first time, Ms. Maiti.
Your lordship,
Actually, you're not sure which one took place.
the lordship last person.
Yes.
I'm sorry, my lord.
No, no, it's all.
Indisputably, the properties under last paragraph. Properties under plot number 350353847 previously belonged to Haru Moldik. He was survived by 2 sons and 3 daughters. All of them inherited shares in the property on the strength of inheritance. The existence of previous suit for partition being title suit number 7 so, as well as executing proceeding following the degree in that suit are admitted fact on record. A written statement of the defendant, respondent number 1, reveal no whisper that the present appellant plaintiff have been imputed as parties to the proceeding. They are not, admittedly, they are not parties. In this context, exhibit A, B, and C are thoroughly perused. The exhibit A is the certified copy of the plain presented in title suit number 73 of 86. This document reveals that Riyazuddin Mollik, son of Samed Mollik, that is the respondent number 1, is the sole plaintiff. Defendant number 1 to 11 are found to be legal heirs of Guni Mollik, who is son of Haru Mollik. legal heirs of Rohim Mollik, who is another son of Haru Mollik, as well as legal heirs of Sattar, who is successor in interest of Goni. On scrutiny of the cause title of the plaint, title suit number 73 of 86, as well as cause title of the plaint of present suit, it is found that none of the plaintiffs, excluding Amir Mollik and defendant number 224, have been included as parties to the said previous suit for partition. There is no denial of the fact that the present appellant plaintiffs and respondent number 224 are co-sharers by way of purchase. It is apparent on the face of the record that all co-sharers of suit plot have not been included as parties in title suit number 73 of 86. In this context, it is pertinent to refer the judgment of the Honorable Calcutta High Court in AIR 1953-377 between Umapati and Subodh. In this judgment, Honorable High Court has been pleased to hold that prior partition is ineffective in as much as all the co-sharers have not been joined in the said suit for partition, or if the previous partition was on the basis of deed, but all the co-owners were made parties of the deed of partition. There can be no bar to a co-sharer filing fresh suit for partition, in order that a prior partition would debar the parties to file a fresh suit for partition. Such partition must be effective one. Again, in another decision reported in so it is observed that earlier partition would be no bar to a subsequent suit filed by the filed for partition made by a co-sharer, where other co-sharers were left out and all properties are brought within the hotspot of the suit. These judicial pronouncements clearly lay down the mandate that no effective degree of partition can be passed under law until all co-sharers are impeded parties and all joint properties are brought within the hotspot of the suit. It is evident in present appeal that the respondent number 1 obtained an ex parte degree, both preliminary and final, without including the plaintiffs as parties to the proceeding. On such legal principles, the preliminary and final degree passed in TS number are ineffective in law. The learned trial court has observed that plaintiff ought to have brought the proceeding under Order 21 Rule 99, 101 Civil Procedure Code entitled Execution 11 of 1999, because possession of the properties have been delivered in favor of the degree holder respondent of the present appeal. The previous suit was disposed of finally on 19/11/98, and the execution case was completed on 14/11/2000. After lapse of long time, that is beyond period of limitation, the plaintiff appellant brought this present suit. Therefore, the present litigation is barred by the law of limitation. In this context, it is pertinent to state that essence of Order 21 Rule 99 Civil Procedure Code is physical possession of any person other than a judgment debtor. The previous provision clearly lays down where a third party is dispossessed from the property can make an application. In AR 2004, it is upheld that an application order 21 Rule 99 CPC shall lie only if a third party has been dispossessed by degree holder. Without actual dispossession, a third party cannot take recourse of Order 21 Rule 99 Civil Procedure Code. This legal explanation amply clear that a party who has been physically dispossessed from the suit property can only bring such application in execution proceeding. In the present suit, it is not the case of the either party that suit plot number 350, 353 and 474 of totally allotted in favor of respondent number 1. That is the plaintiff of the previous suit. It is evident from Exhibit A that Riajuddin Malik has been declared to have 3/7 shares in the said suit. It means that he is never an absolute owner of the suit property. Only a portion of properties under suit plots have been allotted in his favor, but not the whole plot. Thus, by virtue of execution proceeding Exhibit B, there can be no actual physical possession of the remaining co-sharers for the suit who have not been made as parties to the previous proceeding. Furthermore, the content of Exhibit B does not show that other co-sharers of the suit have been physically dispossessed from their existing possession, and such
Ms.
person.
Vaiti, we find this a perfectly good judgment.
My lord,
Perfectly good judgment of the appellate court.
I am coming
Appellate
to-
court is absolutely
Yes.
correct. No interference in the court.
my lord, I shall.
No substantial question of forget substantial question of law. No question of law.
Question of law, I shall.
No question of law is.
Your lordship
involved.
kindly sees.
What is the even
Judgment
though even not
passed
even
earlier in the year 86 has been set aside by the
first
appellate
yes
court.
previous judgment was bad for non-joinder of all the co-sharers.
That is true, my lord, that is
Categorical
true.
finding. If that be so, there cannot be any two judgments have been cited aptly. One Supreme Court, one our division bench.
As your lordship.
Yes, partition suit subsequently can be instituted. There is no bar. Res judicata does not operate. Second ground of the trial court was that Order 21 Rule 99 ought to have been resorted to. Although this logic of the learned appellate judge is not correct, because even without disposition, third party can resist. But that is not the point here. This suit was instituted in 2005. Execution was over in 2000. It's a new suit is barred by Order 21 Rule 97 to 101 during pendency of
Suit was filed by the
limitation, and limitation does not apply to parties.
second suit filed by them.
Limitation does not apply to time.
I am coming.
I mean,
I said
but-
before your lordship, this report. In the previous suit, there are 6 plots, and there will be
Whatever, it was bad for non-joiner,
here. Those plots are not here.
maybe.
Blood entire.
Some of the, at least in some of the plots, in respect of some, if those plots are not here, there is no difficulty in that. You did not take the point of all the properties not being brought into the Hajj court. You have taken a point of non-joiner has been taken.
Blood, I have
In the suit, a point of non-joiner of your suit has.
here, blood, then it in the previous suit, this is also applicable in this suit.
Why do you say that?
Not made party here.
Have you taken that point? You have not even taken that point. You have not taken the point of non-joiner. How can you take it for the
Yes, I have taken this point.
where is it decided by the trial court? Trial court did not proceed on.
Not been decided. That has not been decided. Dealt with. That has
Not even in the narrative where your arguments have been recorded by the trial court. Show us.
They have been recorded certainly, my lord. But all of
Show us, Ms. Maiti. Show us, Ms. Maiti, from the narrative of the trial court that you argued this non-joiner of this suit. It's a new point you are taking for the first time in appeal. Not permissible.
and not all the plots are not here, my lord. The plots.
We cannot take this point for the first time here. Show us that you took this point.
Already you three.
Show us from the narrative of the trial court at least that in the trial court you took the point for the first time. Internal page 3 of the trial court records your arguments. Please show us from there. No, not page 3. After that, sorry, page 4. Hopelessly barred by limitation, multifariousness, hit by Order 22 Rule 9 and all these things. Your only main ground was previous suit, res judicata.
I have already annexed my
You have not taken the ground of non-joinder before the trial court. Non-joinder cannot be taken up at the second appellate stage for the first time. You know that.
No, it has been taken in the
No, page 4 to 5, you are saying it has been taken.
That has been dealt. I do not find here.
No question of dealing with.
It
The trial court where you won the suit recorded your arguments before the trial court. It is not even your entire written statement case has been recorded. Not a single point of non-joinder.
I have taken it. That has not been recorded. It's there. But
Mentally you have taken it.
I have taken.
And it was mentally dealt with by the court.
Your lordship, kindly have a look to my application.
You cannot fish out arguments where it is not there, Ms. Maitri. You have checked up your narrative before the trial court. Sorry, no. The present appeal has been, second appeal has been preferred.
Here was the previous suit has been.
We are dismissing, Ms. Maitri.
There are 6 plots. Here were only 3 plots have been made.
For the first time, you cannot take this.
That all the plots are not
The present second appeal has been filed against a judgment whereby the first appellate court reversed the dismissal of a partition suit by the trial court. The said suit was filed by the plaintiff stroke respondents. Next para, the learned trial judge dismissed the suit on several grounds, primarily in view of the suit being barred by the principle of res judicata, since in a previous partition suit, the present appellant had obtained a final decree which allegedly had been executed in the year 2000. Next para. Secondly, the learned trial judge proceeded on the premise that the current suit was barred by Order 21 Rule 99 of the Code of Civil Procedure, in view of the plaintiff's respondents herein having not raised the question of their title and sought partition in the execution proceedings of the earlier suit. Next para. Thirdly, the suit was dismissed on the ground that the same was barred by limitation. Next para. Learned counsel appearing for the appellant argues that the learned appellate judge erred in law in reversing the findings of the trial court, despite there being a previous decree of partition which was duly executed. Full stop. Next para, that apart, comma, the suit, comma, it is argued, comma, is barred by limitation. Full stop. Next para, learned counsel further seeks to argue that the present suit is bad for non-joinder of necessary parties as well as for non-joinder of all the joint properties between the parties in the hotspot of the present suit. Full stop. Next para. On a careful consideration of the judgments of both the courts below, comma, we find that the last above mentioned argument was not advanced either before the trial court or before the first appellate court by the defendant number 1 stroke appellant. Full stop. It was never argued, comma, as is evident from the narrative of the arguments of the defendant number 1 stroke appellant in the trial court, comma, that the present suit is barred by either non-joinder of necessary parties or non-joinder of all the common properties of the parties. Full stop. It is trite law that a factual argument or objection cannot be taken for the first time before the second appellate court. Full stop. Next para, as such, comma, we fail to accede to the contention of the appellants that such points should have been considered by the courts, both the courts below. Full stop. Next para. Insofar as the merits of the appellate court's judgment is concerned, comma, we must appreciate the way in which the judgment has been written, comma, taking into consideration all relevant law in the field and adverting to the relevant facts. Full stop. The learned appellate judge, comma, quite correctly, comma, came to the finding that since the previous partition suit was bad for non-joinder of all the co-sharers, comma, there is no bar in law for the left out co-sharers to file a fresh partition suit. Full stop. Next para, insofar as the point of limitation is concerned, comma, the learned first appellate judge rightly observed that the said issue does not arise. Full stop. We agree with such proposition, comma, since in a partition suit, comma, the cause of action is continuing in nature and it cannot be said that any particular point of time the cause of action froze, F-R-O-Z-E, or crystallized and limitation began to run. For some next para, thirdly, comma, since the present suit was filed in the year 2005 and the execution case arising out of the previous suit was concluded in the year 2000, comma, the present suit could not be said to be barred by the provisions of Order 21, Rules 97 to 101 of the Code of Civil Procedure, comma, having been filed subsequent to the conclusion of the execution proceedings and not during pendency of the same. Full stop. Next para. In such view of the matter, comma, we do not find any error, comma, let alone any substantial question of law involved in the matter. Full stop. Accordingly, SA 63 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Consequentially, Can 2 of 20. What was Can 1?
And one is in between filing of this appeal and after degree was passed, one defendant died.
Can 1 of 2023 is
disposed of.
Acha, Can 2 of 2023 is consequentially dismissed as well. No order to first.
2005 first suit. They filed a suit earlier also. 2000 they filed a suit that was dismissed for default. They did not proceed there. That is also.
That is also not barred by order. In case of a partition cause.
One thing, Lord, may I submit, Lord? The point your lordship has just now observed that regarding non-joiner of parties, it was already mentioned in the.
I think we won't reopen our order. We have passed our.
WS, it is taken. This point was taken in WS, but
it is not arguing your arguments before the trial court, Ms. Maiti. We have checked up. Without checking, we don't pass orders. Next.
Dear Lords.
Yes. Yes, Mr. Halda, what is your case?
Well, the defendants are the appellants before your lordship. Well, suit for partition. This appeal is directed against the judgment and against the preliminary decree.
Affirmance.
Affirm.
You are the defendants.
I am the defendants.
What is your question?
Well, there are two Khotians. Prior to arrest operation, two Khotians, 216 and 258. Well, yes. 216, my lord.
The CS Khotians.
CS. Well, it was settled between the parties. It was amicably, my lord, settled between the parties that plenty would get this plot entirely another defendant would get entire properly. It was admitted by the plaintiff in cross-examination that the co-sharers have same share in Malat Khotiar number 216, and they have also same share in Khotiar number 258. It has been admitted. Now Malat, he has paid for only partition in respect of 216, not 258. In view of Malat mutual partition, Malat, we did not claim so far as the 258 is concerned. Malat, we are Malat still Malat.
Say the arrangement was you get 216, they get 258.
They got 258 entirely 258 they got.
And entire 216.
216 Malat.
You relinquished each other's shares in the.
Yes, Malat. Yes, Malat.
But now the suit is filed in respect of 216.
216, not in respect of 258, and it has been admitted by the plaintiff. Malat, all the co-sharers have same have shared over the 258, same share.
So then it's barred by. I mean, you have 2 points. One is that. If we say that there was no oral partition, no mutual arrangement, then suit is bad for non-joiner of all the plots, joint plots.
Bad for partial partition.
That is your alternative, partial partition. And your first point is that there is an admission that there was a mutual arrangement.
Yes.
Show us how that admission was dealt with by either the appellate court or
no dealt. It has not been dealt with by either.
Have you got a copy of the evidence?
Yes, madam.
Show us that, Mr. Haldar.
These 2 pages, my lord.
This appeal will be heard on the following 2 substantial questions of law. Roman 1, whether the learned courts below substantially erred in law in granting a preliminary decree of partition in view of it being admitted by, this was PW1.
PW1, my lord.
By DW1. DW1. No, sorry.
Not PW1, my lord.
Cannot be DW. By PW1, Pradeep Thakur, that another joint property, that is the land of Khatian number 258, has not been brought into the hotspot of the present partition suit, thereby rendering it bad for partial partition. Roman 2, whether, in view of the specific admission of PW1 Pradeep Thakur in his evidence that there was a mutual family arrangement between the parties insofar as the plot in question being allotted to the present defendants is concerned, whether the learned courts below ought to have dismissed the suit for partition. Any application is there?
Yes, application for stay of all other proceedings.
Usual order. The petitioners, the appellants / petitioners shall serve copies of Can 1 of 2025 on all the parties, Mr. Haldar, because partition suit. On there are so many. On all the response.
So far only some parties contested. If you also kindly have a look at
which one.
We only contested. We only contested before
other defendants.
They are pro forma in the lower appellate court as well as before your lordship.
Serve copies of Can 1
respondents
of 2025 on plaintiff / respondent numbers 1 to 5, indicating that the application shall be listed before the appropriate learned single judge, having determination subject to being mentioned for enlistment by the parties.
Not single bench. This is first appeal. Division bench.
First appeal?
No, this is my first appeal, not before single bench. Oh, sorry.
The second.
Sorry, my lord.
That's subject to being mentioned for enlistment. Which of next para? There shall the service of notice of the application on the defendants / performance respondents is dispensed with in view of those parties having not contested in the courts below. Which of next para? The learned trial judge shall continue with the final decree proceedings, but shall not draw up any final decree without the prior leave of this court till disposal of the application. The appellant shall file an affidavit of service to the above effect before the learned single judge when the matter is taken up for hearing. Mr. Haldar, we are keeping this on record.
My lord, I'm giving a photocopy, my lord.
Photocopy, but do it. Don't forget to.
No, my lord.
Because you have relied on this
Yes,
specifically.
my lord.
Do it immediately. I mean, as soon as possible. ওটা দিলে এর মধ্যে ঢুকে ঢুকে যেন
সেলাই করবে করে জেরক্স করবে
কারেক্টেড হয়ে যায়
একটা
আচ্ছা
ম্যাডামকে দিয়ে
সার্টিফাইড ইয়েস আরেকটা লাইন অ্যাড করে দাও the certified copy of the trial court be sent down to the court below for the purpose of correction at the earliest and you file your this copy
Yes,
immediately এটা ঢোকালে এর মধ্যেই যেন ঢোকে অন্য জায়গায় না ঢোকে
অরিজিনালটা দেবো না জেরক্স করব
you are mentioning you have to move the matter no time otherwise it goes out both lost in both the courts or one court
Lordship, we are the defendant.
who is leading you in this matter
Lordship, Mr. Roy, Parthapati Roy.
he'll be coming he'll see the board and come both lost in both courts or
Lordship, we have lost in the trial court, my lord. Thereafter, appeal was preferred. They got the decree, my lord. Then we have preferred the second appeal, my lord.
so that's why lost in both the courts below. What is the suit for you are the defendant
Lordship, we are the defendant appellant, my lord.
what is the suit for
Suit for injunction and declaration and injunction, my lord.
declaration of title
Lordship, declaration, title, and injunction.
what is your point involved in this appeal
In this point, my lord, the plaintiff appellant has, my lord, transferred the share to the appellant, my lord, and it was the exclusive share. And thereafter, my lord, in the trial court, my lord, they have lost, and in the appeal preferred by us, my lord, appeal preferred by them, my lord.
once you're saying they lost you lost in both the courts below once
The plaintiff, my lord, we are the appellant, my lord.
is it a judgment of affirmance or a judgment of reversal
Judgment of reversal, my lord.
then they lost in the court
We
below
cannot ready this matter, my lord.
we are passing it for 10 minutes if Mr. Roy does not come you'll have to order 10 feet বাদে কল করবেন 500 বার you get prepared in the matter yes yes Mr. Roy
May it please Lordship, my defendant is the appellant before your lordship, suit for eviction on the ground of reasonable requirement and default. So far as default is concerned, my lord, they
lost in both the courts
yes, judgment of affirmance. My lord, default on the ground of default, my lord, suit was not decreed on the ground of reasonable requirement. The suit was decreed. Now, my lord, apart from that, my lord, the point which I am my lord, arguing before your lordship is this with regard to the notice. My lord, notice is the prime thing which ought to be served up on the tenant. Then, my lord, the other questions come. Now, my lord, kindly come to the appellate court judgment with regard to the service of notice. It was argued by the tenant before the lower appellate court with regard to notice. That is internal page 4 of the appellate court judgment.
Yes.
And 1.19, paragraph 19.
Yes.
Learned counsel for the appellant submitted that the learned trial judge failed to appreciate the evidence on record in its proper perspective and misplaced the relevant provisions of West Bengal Premises Tenancy Act 1997 while passing the impugned. It was specifically contained that plaintiff failed to establish lawful and effective service of the statutory notice of eviction upon the defendant. The only document relied upon by the plaintiff to prove service of notice is a postal tracking report which merely shows that the registered article was booked from UC Danga Post Office and reached Banpur Post Office. However, the tracking report is completely silent as to whether the article was actually tendered to the defendant, whether it was received, refused, or returned, and who, if anyone, accepted it. In absence of such crucial details, the presumption under Section 27 of the General Causes Act cannot be invoked, nor it can be said that the mandatory requirements under Section 106 of the Transfer of Property Act and Section 6(4) of the West Bengal Premises Tenancy Act were fulfilled. The plaintiff failed to prove that the notice dated 13th May 2018 was duly and validly served prior to 31st May 2018 as required by law. It was argued that mere marking of a postal receipt or tracking slips does not discharge the burden of proving the actual service. The learned trial court's reliance on a presumption under Section 114F of the Indian Evidence Act is misplaced in the absence of a foundational fact of actual tender of refusal. The tenant, having specifically denied receiving or refusing any such notice, cast a corresponding burden on the plaintiff to prove actual service which was not discharged. In support of the submissions, learned counsel placed reliance on the judgment of the Honorable Division Bench of the Calcutta High Court in AIR 1989, Calcutta, page 14, wherein it was held that the tenant denies receipt of notice and postal peon is not examined. The presumption of valid service cannot be done. The burden in such cases reverts to the landlords to produce cogent evidence, including the testimony of the postal officials. Then other judgments also cited in support of the same contention. Now, the kindly come to the arguments on behalf of the respondents, that is at page 6, paragraph 31. The respondents councils also argued that 6(4) of the section 6(4) of the West Bengal Premises Tenancy Act.
Sir, your primary point before us is notice.
My lord.
Then you can come to para 40 directly. Their
40.
argument on notice is in para 40.
My lord. My lord.
Other than that, it's reasonable.
My lord. On crucial issue number 5 relating to service of statutory notice under section 6(4) of the West Bengal Premises Tenancy Act 1997, the trial court placed reliance on the documents marked as Exhibit 1 series and also considered the ratio laid down in Mrityunjay Sheth versus Jadunath Bosak, applying the presumption under illustration F of section 114 of the Indian Evidence Act, and nothing in absence of the specific denial of service of notice in the defendant's written statement. The trial court held a valid, legal, sufficient, and binding eviction notice was duly served upon the defendant prior to institution of the suit. Now, my lord, I want to show whether actually I have denied the service of notice. Now, my lord, kindly, apart, I shall coming to the other part of the judgment afterwards. But before,
Exactly.
my lord,
the written statement first.
yes, my lord. And that is has been annexed in the application, my lord.
Yes.
And kindly come to internal page 15, paragraph 11. I will lordship kindly got it. My lord. With reference to the statements made in paragraph 7 of the plaint, the defendant specifically and categorically state and submits that no legal, statutory, lawful, valid, and proper notice has been served to the defendant as claimed by the plaintiffs by paragraph 7 and 8 of the plaint.
Clearly taken. Clearly taken.
Yes, clearly taken.
How is it dealt with by the appellate court?
Yes. Now, my lord, kindly come to my lord, internal page 10 of the appellate court judgment.
Yes.
Paragraph 53.
53.
With respect to the service of statutory notice under section 6(4) of the Act, the contention raised on behalf of the defendant is that the learned trial court erred in holding that valid notice was served. However, the record demonstrates otherwise. The notice dated 13th May 2018 was marked as Exhibit 1 with supporting postal receipts and tracking information exhibited as Exhibit 1/1 and 1/2 respectively. The postal receipt bears the correct address of the defendant, and tracking report shows that the notice was received at Banpur Post Office, the area where the defendant ordinarily
We have
resides.
seen para 53 and 54, the findings. Tell us this. Is this not one of the plausible views? Then can we interfere in second appeal? That is one question which is irking us.
Now, my lord,
Yes,
the notice.
this is arguable.
Yes,
Undoubtedly.
but my lord,
It is
notice.
one of the possible two views. One is that yes, presumption of service if it's sent at the right address.
My lord.
And the other aspect is that judgment that postal peon if not examined, there's a denial then. So there are two views prevalent. Court adopted one of the views and said no presumption of service can be taken.
But my lord,
why should we interfere in that?
Court proceeded on the basis previously that
no denial.
That there is no denial. Now, my lord, secondly, the court said that the since the Banpur Post Office received the notice, it presumed that the notice has been served. But my lord, track report is shown otherwise, which was exhibited. It is shown that Banpur Post Office has only received the
Will
notice.
admit this. This appeal will be heard. This second appeal will be heard on the following substantial questions of law. Roman 1. Whether the learned first appellate court substantially erred in law in arriving at the perverse finding that there was no denial of the service of notice of eviction under section 6 within bracket 4 of the West Bengal Premises Tenancy Act 1997, comma, which is palpably contrary to paragraph 11 of the written statement of the defendant appellant. Roman 2. Whether the courts below proceeded on a fundamental misconception of law in assuming that good service has been effected in respect of the notice under section 6 within bracket 4 of the 1997 Act on the defendant stroke appellant merely on the premise that the postal track report showed that the local post office of the residence of the appellant received the postal article, comma, without any clear service of notice on the defendant appellant having been established. Roman 3. Whether in view of the specific denial of service of notice of eviction by the defendant appellant in written statement, comma, the courts below proceeded on a substantial error of law in coming to the conclusion that due service was effected merely because the postal article was sent to the correct address, comma, without there being any examination of the postal peon. Execution has been levied.
Yes, my lord, I filed an application for stay before your lordship's court.
Opposition charges, Mr. Shah will give you opportunity to file opposition so that
That
you
your
can.
lordship can look to paragraph 46 of the appeal court.
Paragraph
46
of the
appeal court. If it is can be taken as a comparative unit, then your lordship can dispose of. Otherwise, my lord, direction. There are two rooms.
And I am in the tenant in respect of one shop room.
The adjacent shop room rent is this.
If the notice goes, everything goes, Mr. Shah.
That is true. But
everything
now,
goes. You have to start afresh.
But we do not know ultimately what will happen.
We do not know. So when we know, then we decide.
No. Your lordship can do one thing. If your lordship, to that effect, he deposit in court. I may not withdraw.
No, no. Right now, we won't direct anything. We don't know what is the occupation charges. They will pay to you, and you will.
Occupation charge. There are
we have to know what is the occupation charge.
500.
500, the last rate.
Yes,
rate
yes,
of rent.
yes.
So you agree to that?
No, no. I am saying the other room is 7,000.
That is why we require affidavits from you. File your affidavits, and it will be decided at the final hearing. For the time being, stay. Since we have admitted the appeal on the above substantial question of law, comma, a prima facie case for grant of stay of the connected execution case has been made out. Full stop. Accordingly, can 1 of 2025. Now, accordingly, there shall be stay of all further proceedings in title execution case number 27 of 2025 pending before the learned civil judge, junior division at Asansol, comma, district Paschim Bardhaman till disposal of the application. Push up, the plaintiff respondents shall file their written objection, affidavit in opposition to the 2 Can 1 of 2025 within 3 weeks from the date, comma, disclosing their version of the occupation charges which can be fetched for the suit property at the current rates. Full sub next para, reply if any shall be filed within a week thereafter. Full sub liberty to the parties to mention the stay application for inclusion before the appropriate learned single judge having determination after the timeline for filing affidavits is over. Full sub next para, we make it abundantly clear that the question of imposition of occupation charges and, comma, if so, comma, the quantum thereof is kept open for being decided by the learned single judge at the time of final disposal of the stay application. Stay application. Affidavit of service filed to be kept on. Next. Yes, Mr. Chatterjee, what is
I am for the apple.
Right.
If this appeal arises out of rejection of application under order.
Is a section 5.
There is a section 5.
No, so we have to direct service.
But it was served. We had tried to serve the plaintiff.
There was a direction of court.
Yes.
As per direction is of
My lord, my lord.
Asa then?
My lord, there is one plaintiff and the others, my lord, they are, I'm the defendant number 1 and there are other defendants. Upon the plaintiff, it has been served. But,
Suit for?
Suit for partition. Suit for partition and...
challenging?
I am challenging refusal of my application under Order 39, Rule 4 of the code. There was an order.
Only the plaintiff will be affected. We are
Only the
discussing with
plaintiff will be
service. Is it file affidavit with service? There was a previous direction of service, you said.
My lord, there was.
We had admitted the appeal, obviously.
Admission was not. No formal admission. What I understand is that on the last occasion, service was not affected. My learned junior made such submission, and accordingly, the direction was given to serve.
So we'll have to hear it for admission, but they're not appearing anyway. We are first miscellaneous appeal, then we'll admit formally.
But the section 5, my lord.
Section 5, right? Sorry. Section 5. What is the delay?
8 days.
What is the reason? Advocate's fault, miscalculation, or what?
Well, Lord, the fact remains is that I'll candidly submit is that the appellant was not in Kolkata. We filed that is why it couldn't be done. He was sick.
Who suffered leg injury?
Lord, the
petitioner. One of the petitioner.
One of the petitioner, the director. There are two directors. One of them.
Since this affidavit of service filed today be kept on record. First up, substantial service has been effected on the plaintiff stroke principal respondent. First up, in view of the appeal being directed against the refusal of an application under Order 39, Rule 4 of the Code of Civil Procedure, filed by the defendant number 1 appellant, comma, service on the other defendants stroke pro forma respondents numbers 2 to 25 is dispensed with. First up, next para. None appears for the respondent number 1 despite service. First up, upon a perusal of the grounds shown in the application for condonation of delay, comma, we are satisfied that sufficient explanation for the delay in preferring the appeal has been made out insofar as the delay of 8 days is concerned. Accordingly, Can 2 of 2025 is allowed, comma, thereby condoning the delay in preferring FMAT 321 of 2025, no arrest to cost. Yes, what is your ground? If you don't find anything, then we'll dismiss it in under Order 41.
Well, Lord, ground is that.
So generally, questions of fact are also involved, but 39.4 show us something strong. Otherwise, we won't keep appeals pending in High Court.
Before I make my submissions on the merits of the case, the initial order of injunction, it was status quo, was filed on 1st of October 2024.
Passed on.
Yes. 1st of October 2024.
Yes.
Thereafter, it was till 19th of November 2024. And what I find from record is that after that, it was never extended.
Then their appeal is infructuous.
After that, it was never extended.
Record it is infructuous.
And, my lord, but 39.4 was taken up for hearing and it was decided.
You should have pointed out.
But after going through the brief, my lord, I found out this.
No, not you. I mean, your counterpart in the trial.
Counterpart. Order number 2 is the order of injunction.
Yes, exactly. What is the ground for Order 39 Rule 4? Why should it be vacated?
Ground was that the plain case is that, my lord, I have prepared a family tree. My lord, may I hand over?
You are sure that subsequently it has not been extended? Then we'll direct the injunction application to
be kindly takes up, my lord, the order sheets for once, my lord. It was order number 2 says that it's till 19th of November
2024.
2024. In order number 4 is that 19th of November order. Here they make an application for extension, but it was not allowed.
Not allowed.
Consider the prayer for time and allowed. So I made a prayer for time to file the written statement. This is what appears from the order sheet.
Yes, you are right. Let the Vokalata be kept on consider the prayer for time and alert specified. You have filed your objection. That was granted to you. Time was
My
granted.
lord.
You have filed your objection. We'll add the injunction to be heard of. We'll say this is infructuous because it was never extended. Let us see the next order also. Let us be
Well.
sure. Otherwise, you will be in a false position.
Order number 5, my lord, only records that I file an application.
You have filed, yes, right.
But 9-4.
A comedy of errors.
And the next order, order number 6, is the impugned order, and which ultimately posts the matter from 26th of February 2026, almost after 1 year.
The present appeal has been preferred against an order rejecting the defendant number 1 stroke appellant's application under Order 39, Rule 4 of the Code of Civil Procedure for vacating an ex parte ad interim order of status quo dated October 1, 2024, passed in a suit for declaration and injunction.
My lord.
For
partition suit.
For partition and consequential reliefs. For the next para, however, comma, as rightly pointed out by learned counsel appearing for the appellant, comma, it transpires from the certified copy of the entire order sheet, comma, which has been annexed along with the memorandum of the present appeal, comma, that although by the order dated October 1, 2024, comma, the ad interim order of status quo had been granted for a limited period till November 19, 2024, comma, on November 19, 2024, comma, although an application for extension of the injunction order had been filed by the plaintiffs, comma, no order was passed allowing the same, comma, whereas time was granted to the defendant number 1 stroke appellant to file written statement and written objection. From the very next order dated January 24, 2025, comma, we find that such written statement and written objection was duly filed by the present appellant. However, comma, an application under Order 39 Rule 4 was also filed, comma, although in the meantime the interim order had not been extended. Next para, the same was disposed of by the present impugned order dated April 28, 2025. Next para, thus, comma, in view of the above narrative, comma, we find that the application under Order 39 Rule 4 of the Code of Civil Procedure was redundant ab initio, comma, since there was never any extension of the ad interim order which was sought to be vacated. The question of vacating an order can only arise when such order is subsisting, and in the present circumstances, comma, there was no cause of action for vacating any order, comma, since there was no subsisting interim injunction order at all. Since accordingly the present appeal is not is academic in nature, and accordingly FMAT 321 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. That is the only provision we have at this. Next para, consequentially, can 1 of 2025 is also disposed of. There will be no order as to cost. Next para, we request the learned trial judge to dispose of the main temporary injunction application as expeditiously as possible by positively taking it up on the returnable date, that is February 26, 2026, and disposing of the same within an outer limit of 3 weeks thereafter. This much. Needless to say, comma, the merits of the respective contentions of the parties in the suit or the injunction application have not been gone into by this court.
Yes.
Whatever we observe on merits, Mr. Chatterjee, unnecessarily will affect the court.
My lord.
Yes. Pass order degree. What is it?
Item number 5 এর এই কপিটা।
Yes, Mr. Rai.
The defendant is the appellant before your lordship. Suit for declaration of title permanent injunction.
Reversal. Judgment of reversal.
Judgment of reversal. Trial court dismissed the suit on the ground that the plaintiff failed to prove their position about the property in question, and the suit is barred under section 34 of this specific fact.
They sought for declaration and
injunction, declaration of title, permanent injunction.
That your lordship will
What
find.
did they not ask for? Why barred by 34?
Because they did not ask for recovery of possession. Because
They admitted that
no, they failed to prove their possession. Because our case is
failed
that
to prove their possession is subsequent. It's not barred by 34.
our case is that we are in possession, we are possessing the property, and these are the documents. We are also tracing title from a particular person.
It's now settled, Mr. Rai.
That declaration can be granted. Declaration to that extent, my lord, declaration can be granted. Whether the injunction can be granted or not. My lord is
The finding of the trial court was that you are in possession.
yes, my subject. If your lordship can turn to the portion page, internal page 4 of the trial court judgment, my lord. The relevant portion. This is the only point which I can place with your lordship.
Sorry, trial court judgment is you annexed it before the appeal court?
No,
no, rightly.
After the appeal court, my lord.
Yes, 4.
My lord will find from the middle, second paragraph, middle portion, but it is conspicuous that the plaintiff failed to prove any from the middle portion, second paragraph of the middle portion, my lord will find. Failed to prove any regularity in their name or their vendors, Shivani Shah, Marani Shah, such and such.
Mr. Rai, don't hurry. You, this is one of your problems. You must rectify that. We are saying this as your elder brother. You just hold your words, be specific on each word, and then, if necessary, be a bit slower. That may become a difficulty later. Yes.
But it is conspicuous that the plaintiff failed to prove any LR record of rights, either in the name of his vendor, Shivani Shah, Marani Shah, Bhim Chandra Shah, Nakul Chandra Shah, or Anandamai Shah, or in his name. In order to prove his chain of title over the suit property, the plaintiff should ought to adduce evidence that his aforesaid vendors inherited the suit property from Jagannath Shah. But in absence of any record of rights in the name of the aforesaid legal heirs of Jagannath Shah, it would not be just and proper to regard that on such and such possession of the suit property has been delivered to the plaintiff in the line of deed of Exhibit 2. Here the court thinks repetition the plaintiff did not approve LR record of rights to in his name to substantiate that he is in possession of the suit property. Per contra Exhibit A, certified copy Khatiyan number such and such, being documentary evidence of the defendant speaks that the suit property stands in the name of the mother of the defendants, Manohara Bibi. Thus, in absence of any record of names of the plaintiffs or his vendors, this court is declined to assert the plaintiff is in possession of the suit property. Accordingly, is not able to get any original exclusive owner of the property. This was the sub and successor charge.
Plaintiff proved title deeds.
Yes.
Title deeds were produced. Very. So let us come to the appeal court.
Appeal court, my lord, can you consider the appeal court judgment? The portion by which, if your lordship can turn to internal page 7 of the appeal court judgment. It starts from the line starts from now. Now is that the right hand corner so far as title of the defendant. My lord, from the middle portion, your lordship. So far, the line starts.
Page 7.
Page 7 of the appeal court judgment.
Yes, thank you. Now so far.
Now so far. Now is at the extreme right hand side. That's why I said. As the title of the defendant is concerned, there is no evidence to show that the mother of the defendant purchased the suit property from the said Jagannath Shah. The same is conspicuously missing without any breach showing passing of title from Jagannath Shah to Manohara Bibi. Defendants produced title is marked as Exhibit B to show that Manohara Bibi gifted suit property to the defendants. The intervening act of passing of title from original owner to the mother defendants had not been proved, where the existence of title in favor of the Manohara Bibi had not been established. Further, passing of title from Manohara Bibi to the defendants does not arise. The argument advanced from the side of the defendants that Jagannath Shah was shown as Korfa tenant in the CS record order is also not much relevant after coming to force of the Estate Acquisition Act. Right of the intermediary, my lord, kindly skip over the same because this is the admitted fact that Korfa tenant will be transposed as a riot after the Estate Acquisition Act came into. The LR, next page, my lord, the LR record of rights stands in the name of the mother of the defendants. My lord will find. Next page. The same is privacy proof of position, but at the same time it is a rebuttable one, where the defendant set up prior position as a defense and exhibited LR record of rights in support of them. It is the duty of the plaintiff to rebut the same. Now let us deal with the evidence from the side of the plaintiff. Regarding position of the plaintiff adduced evidence of one independent witness, Sirajul Islam, who has his property near the suit property. He deposed that Jagannath Shah was the owner of the suit property, and on his death, the vendors of the plaintiff became owners and were in possession of the suit property. Thereafter, the plaintiff purchased the suit property from them and has been possessing the same. Now, my lord, can you turn to the next page? I am drawing the credibility of the PW2, Sirajul Islam, page 9, my lord. Second paragraph. The person in newspaper the record of right stands, my lord, will find.
T.S. Sarwar was in the name of their predecessor, Jagannath.
Jagannath's predecessor. It is admitted Jagannath was the owner. That is not disputable the fact. I am claiming that my mother.
Sarwar, you have not explained how.
My mother got the property from Jagannath. Mother gifted to me, and their case is that Jagannath was the owner. Jagannath legally has transferred the property in favor of them. These are the
failed to prove the title.
From my mother to from Jagannath to my mother.
So therefore, Mr. Rai, there is no CS records. It carries a forward presumption also unless reverted. Now CS records were in the name of their predecessor. Your names are suddenly recorded in the LR records. Your names or your predecessor.
My mother's name is my predecessor name.
Mother's name. Mother's name. But how mother got the property is not explained. Then
I have explained, but I cannot.
This is one of the possible views, Mr.
There's a probability, my lord.
That CS Arward is their predecessor's name, and then LR Arward, there is no nothing to show, explain how you
both backward and forward. I cannot. Yes, is both backward and forward.
CS, in the absence of anything to show
that the bridge.
Explain the recording of the LR Arward in your mother's name.
Yes, what is
one of the plausible views?
Yes,
in second appeal,
only one thing, my lord. So in absence,
then it will be at the drop of a hat. We would be interfering in second appeal, which is the reason why we have so many second appeals.
No, my lord, I'm not inviting. This is the
not that if there is a genuine point. Definitely, we are admitting matters today also, but
only at the credibility of the PW2. Your lordship will find page 9, last 4 lines.
Yes.
One, two, three.
As per instruction of the plaintiff, this something is lost in translation. We are telling you, he might have been called by the plaintiff, and as per instruction does not mean necessarily mean as per instruction, because
this is the only thing I can say. So, what the basis of this witness,
whether as per instruction he deposed means that he came to depose as per instruction of the. Actually, he will bring his own witness. So, as per his instruction, he came and deposed. But what is the deposition, the content of the deposition as per instruction, that it does not prove that.
Where he admits as per the instruction of the plaintiff, deposed it is a neutral admission on his part as acquittance of the plaintiff for only this evidence, personal plaintiff cannot be disregarded as altogether. The court is of the opinion that rebuttable presumption, the deed which for this fundamental preponderance probability that they have at least they can tie the chain.
Sorry.
As the
present appeal has been directed against yes. The present second appeal has been directed against a judgment of reversal. Full-stop. The learned trial judge dismissed the suit for declaration of title and permanent injunction filed by the plaintiff stroke respondent primarily on the ground that possession could not be proved by the plaintiff, and as such the suit was barred in law, going by the principle of the proviso to section 34 of the Specific Relief Act 1963. Whose next para, the appellate court, on the other hand, reversed such findings and came to the conclusion that since the link deed, showing transfer of the suit property in favor of the mother stroke predecessor in interest of the defendant stroke appellant could not be produced by the defendant stroke appellants, the title deed executed in favor of the plaintiff withstood scrutiny, and as such on the basis of the same declared the title of the plaintiff in respect of the suit property. For the next para, with regard to possession, the learned first appellate court took into consideration two aspects of the matter, first, the entry of the name of the predecessor in interest of the plaintiff stroke respondent in the CS records of rights, and secondly, comma, the oral evidence of the oral evidence of the plaintiff apostrophe S witness. Full stop. Next para. Learned counsel for the appellant before us seeks to impress upon this court that the credibility of the plaintiff's witness was at stake, comma, since he admitted that he was deposing on the instruction of the plaintiff. Full stop. Next para. However, comma, we are unable to accept such contention. Full stop. Next para. It is often seen that when the deposition is recorded in Bengali vernacular, comma, the true import of the nuances of the words used by the witness are lost in translation. Full stop. Next para. The word within double inverted instruction, double inverted clause, is somewhat ambiguous and may mean both that the witness came to depose upon being so asked to do by the plaintiff on the one hand, comma, and comma on the other, comma, that he was deposing at the behest and as per specific instruction of the plaintiff. Full stop. Next para. There is no reason why the second view should be chosen over the other, comma, in the absence of any other corroborative evidence to shake the credibility of the witness otherwise. Full stop. Next para. Moreover, comma, CS records of rights and entries therein carry both forward and backward presumption of correctness, comma, subject to rebuttal. Full stop. Next para. The conspectus of the facts in the present case is that the CS records of rights stood in the name of the predecessor in interest of the plaintiff, whereas the LR record of right stood in the name of the mother stroke predecessor in interest of the defendants. Full stop. Next para. In such circumstances, comma, in the absence of any link deed showing the transfer of title in favor of the mother of the defendants, comma, it was the initial onus and the burden of proof of the defendants stroke appellants to explain how and why the entry in the records of rights was changed in the name of the defendant's mother. Full stop. In the absence of such explanation, comma, one of the plausible views on facts was arrived at by the learned appellate judge. Full stop. It is well settled that the second appellate court does not readily interfere with the views of the courts below if such view is plausible in law. Full stop. Following such principle, and since even otherwise, comma, the learned trial judge erred in law in holding that the suit is barred by the proviso to section 34 of the specifically act, because at the time of filing of the suit, it was the plaintiff case that the plaintiff was in possession, and as such, no prayer for recovery of possession was required to be made, and even finally, the plaintiff was held to be in possession. Full stop. Next para. Accordingly, we do not find any substantial question of law involved. Full stop. Essay 81 of 2025 is dismissed under order for Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2025 stands dismissed as well. No address to cause certain certificates. Sorry. Next.
Item number 9.
Yes.
Lordship, I'm appearing for the appellant.
Lord, I am appearing for the
Mr. Chaudhary was appearing for the appellant on the last occasion on the prayer of the respondent. The matter was adjourned till today.
Yes, I appear for the bar.
Yes, Your Lordship.
I am for the proposed added defendant.
Yes, there was direction to serve upon the proposed defendant. We have already served. But Your Lordship, today Mr. Chaudhary is little inconvenienced. He is not in Calcutta. So if it can be fixed tomorrow.
My Lord, Wednesday in that case, I will also get proper instructions then, my Lord.
On the prayer of the appellant, the matter is adjourned and shall next be listed on November 19, 2025.
Great.
Affidavit of service filed to be kept on.
Yes.
Yes.
I beg to appear on
For the
behalf.
respondent.
Right.
As the caveat has already been filed by the defendant.
Reduce of the court. This is against injunction.
Lordship.
Suit for?
The suit for declaration, permanent injunction, partition, and recovery of khas possession.
Why was refused? Injunction refused?
Lordship, the refusal is made in the ground which your lordships can ascertain from the certified copy, lordship.
Yes, yes.
Para 12 of the impugn order.
Let us start from para 9.
Lordship. May I read out, lordship?
Please.
It is clear that the plaintiff...
The case of the plaintiff.
It is the case of the plaintiff that the suit property was purchased by both the parties to this suit jointly from one Ashit Baran Vishwas by virtue of a sale deed, vide number such and such of 2016 dated 20th July 2026. After purchasing the said entire plot of land by virtue of execution of the title deed, the defendant being the elder sister with an intention to grab the whole property did not mutate their name in the records of rights at that time. It is again contended that defendant being the elder sister being in full control over the plaintiff made her understand that mutation could be done later. Thereafter, plaintiff, under the pressure and influence of the defendant, executed and registered a deed of gift being such and such of 2019 dated 17th of April 2019 for the undivided and undemarcated half portion share of the suit property, hence this suit. So, plaintiff prayed for an order of injunction restraining...
Yes, you came after so many years. No. Your suit is of which year? This current suit. It's a 2025 suit.
Lordship.
So, court is right that first of all, there's a registered deed in their favor. You can prove your case in trial, and you are not illiterate, are you?
No, Lordship.
You don't have a case of being illiterate.
No, Lordship.
So otherwise also, I mean, you can substantiate, but after so many years, you are coming up.
No, Lordship. The one thing is that the residential property which was gifted by the father of both the parties in favor of the
your gift deed was of 2019.
2019, Lordship.
You waited for 6
I am
years.
admitting, Lordship. Lordship.
You are a signatory because your case is that misrepresentation sort of.
Lordship.
Or you are coaxed into doing it.
Lordship. Only prayer is that, Lordship.
It's not even fraud. It's under the pressure and influence of the defendant.
Lordship, I'm admitting that. I'm not disputing on that regard, Lordship. Only one prayer is that till the disposal of the suit, not to create any third-party interest, Lordship. Otherwise,
that's called an injunction, generally.
Or status quo, Lordship.
No.
Otherwise, Lordship, it will difficult for the plaintiff if the multiplicity of proceedings
First of all, you have not made out a prima facie case because you have made out a case that you were put under pressure and influence of the defendant.
Yeah, Lordship, in that regard, Lordship,
and influence
the mental and physical torture, I made GD, and till today, Lordship, also, I am submitting before your Lordship.
When was the first GD, after or before the gift deed?
My lord, may I submit one?
No, not yet.
No,
you will definitely submit, but we will give you your opportunity.
Lordship,
in 2025, probably before filing of the suit.
No.
The GD entry?
Yes, Lordship. But only one thing, Lordship, Lordship, may I submit, Lordship? Only one thing is that initially the father purchased this property in the name of both
We
the...
have seen that.
Both the sisters.
Don't repeat the things we have
No, Lordship. The father gifted the residential property in favor of two of us. The father now decided to withdraw that gift, Lordship.
You executed deed of gift in 2019.
19.
You were made to do it. And you challenged it in 2006, 2005, 2025.
Lordship.
After 6 years. No, sorry.
Lordship, only difficult is that, Lordship, at that point of time, I was not aware regarding...
You signed the deed.
Lordship, I am admitting this. But at that point of time, I attained just the age of majority.
So what? No.
Now, on
the
basis of the assurance made by my elder sister, that she will take care of all of my needs.
No interference.
Lordship.
Plausible view has been taken. Yes, you want to add something to it?
Just one thing.
Yes.
The GD they are talking about, that GD also got dismissed in favor of us.
GD cannot be dismissed.
I mean, upon a hearing before the Women PS, Barakpur. This was the
what
GD,
PS?
Women PS, Barakpur, because, my lord, this was a complaint which was filed by the appellant just the day before the title suit was filed. Now, my lord,
At the trial court also, it is in the stage of admission.
Anyway, we are
SRAD
not
stage,
going
my
into
lord.
this.
Unnecessary delaying the matter, my lord.
The present appeal has been preferred against the refusal of a prayer for temporary injunction made by the plaintiff stroke appellant in a suit filed by the plaintiff for declaration that a purported gift deed executed by her in favor of the defendant stroke respondent on April 17, 2019 is vitiated by fraud stroke misrepresentation stroke coercion. For sub next para, learned counsel for the appellant argues that due to the torture meted out by the respondent to the appellant, the appellant had to lodge a general diary entry with the police. For sub that apart, it is submitted that an arguable case has been made out in the plaint and the injunction application as to the gift deed being vitiated. For sub thus, it is contended that the learned trial judge erred in law in dismissing the application filed by the defendant stroke appellant, plaintiff stroke appellant under Order 39, Rule 1 and 2 of the Code of Civil Procedure. Push-up, it is also added by learned counsel for the appellant that unless injunction is granted, at least in the form of status quo, the property may be transferred and or may be altered. Push-up. Next para, learned counsel for the respondent points out that the GD entry has met with failure in as much as the same was rejected by the concerned judicial magistrate. For sub next para, be that as it may, we do not want to enter into the veracity of the complaint. For sub, however, fact remains that whereas admittedly the appellant signed in the deed of gift dated April 17, 2019, be it under duress or under coercion or misrepresentation, the appellant ought to have brought the suit within within a reasonable period thereafter. Full we take note of the fact, as did the learned trial judge, that the suit was filed only in the year 2025, that is 6 long years after the execution of the said deed. Next para, moreover, we also find that it is questionable as to whether particulars of fraud, stroke misrepresentation, stroke coercion, stroke misrepresentation have been pleaded in the plaint or the injunction application, for entitling the plaintiff to an order of injunction. Moreover, injunction being an equitable relief, delay defeats equity as well. Proceeding from such perspective, we do not find any error in the impugned order of the learned trial judge. Accordingly, FMAT 449 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. No address, Can 1 of 2025 is disposed of as well. No address to cause certain certificate copies. Affidavit of service filed today be kept.
Lordship, only one to your lordship. If any transaction will take place, lordship, that will be subject to the final outcome of that suit,
Why
lordship.
should you say that?
Lordship.
Section 52 operates, it operates.
Lordship, otherwise,
law says it.
otherwise the multiplicities of suit will be generated, lordship.
Maybe.
Only on that ground, lordship, kindly protect my right,
No.
lordship.
Section 52 is there for you. Argue that at the time of hearing. We'll come back in 10 minutes, but Yes.
Lordship, I beg to appear on behalf of the respondent number 1 to 6 and 8 in item number 11.
No, 11 and 12, I am for the petitioner appellant matter. And
what have you challenged?
But I have challenged the order passed by the learned tribunal, that is at page 81, my lord. The Thika property, my lord, the learned Thika controller has passed an order under section 5(3) of the West Bengal Thika tenancy 2001. My lord, declaring that Thika tenancy, my lord, respondent 8 is the Thika tenant. Challenging that order, my lord, the original applicant hearing, my lord, respondent 1 to 6 have moved one original application, and another application has been moved by the respondent number 8, my lord. Before that
So
tribunal.
who was held to be a Thika tenant? You.
Respondent 8. I have, my lord, decided, my lord, Thika controller. I have for the state, my lord.
Who has challenged it? Who is the appellant?
The state is the appellant, my lord.
The state has challenged.
Yes.
Very good. So respondent number 8 was declared to be a Thika tenant. Yes,
Yes.
then
Against
challenge
that order,
yes.
two separate original application has been filed before the tribunal. One by the original applicants, where that is 1 to respond 1 to 6, my lord. They are the original applicant in respect of one original application, and another original application has been filed by the respondent 8. That is another item number 12, my lord.
So
the matter is
11 and 12 against the same order then?
Same order, my lord.
Same order, disposed of by single order or two orders passed?
My lord, the same order but separate.
Similar but separate order.
Separate.
Two original applications.
No, you don't start arguing. We are just wanting whether these are two different orders.
Similar order.
Similar. Hey, পরেরটা 11 12 একসঙ্গে বোর্ডে দেখি পরের ফাইলটা দিই।
The only thing is there is a delay of 1 year 6 months, my lord.
1 year 6 months.
Yes, my lord. No sufficient my lord, reason has been explained in the read petition, my lord. It is I am praying, my lord, lordship may kindly liberty has to give my appropriate application, my lord.
Learned counsel for the state learned counsel for the state stroke petitioners submits that some time may be given to the petitioners to file a supplementary affidavit furnishing the reason for the delay in preferring the present petition. So accordingly, the matter is adjourned. How long?
2 weeks.
Till
But there's only one.
November 24th, 2025. Affidavit in leave is granted to the petitioners to file a supplementary affidavit on the returnable date with advance copy to the respondents.
If 1.5 year old matter
দুটো ম্যাটারে একসঙ্গে অর্ডার হবে, হ্যাঁ, ম্যাটারস করে দেন। Yes, yes.
Doesn't appear, my lord, 1.5 year old matter, my lord, is not a Thika on the face of it. It was declared as such by the tribunal.
Let us give the explanation, then we'll check.
We could give up the point of delay if your lordships give it up so that we can hear it today and finish it off. The moment we are going to apply now, we have got the tenants vacated, we are applying before RERA, state has awoken. I think because elections are there in 2026. Need I say more?
No, why, what is the reason for the delay? What?
The department,
then we are taking up the matter.
Yes, please take up the matter.
Kindly, my lord, I'm led by Mr. Somitra Bandyopadhyay.
Mr. Chondicharan is on the other side.
I am not in it.
We are regularizing his appointment. Mr. Somitra Bandyopadhyay is there.
Whenever, but my lord, I'll tell you lordship why. On the face of it, it's not Thika. Thika, our outer limit is if it's more than 12 years.
So that will go into, but if you give up the point, then you can record that and.
I wanted my lord it to proceed so that I know what fate will befall me, because I am before the RERA, I have cleared everyone.
On the prayer of the petitioner, the matter is adjourned for the day. Because Mr. Bandyopadhyay is there.
Let him come on that day, my lord. We will not take the point of delay.
Remind us?
Yes.
Yes. Tomorrow itself. Not today, থাকবে? আজকে একটা আছে। Next.
Lordship, I am appearing for the petition.
What is the matter?
Matter for shifting back the date of hearing before the tribunal.
When is the next date fixed?
2nd September, the order was passed. And next
23rd of June?
June, lordship. 23rd June 26.
Tribunal is insufficiently manned or something. The full tribunal is there. How many benches? 4 benches.
Four benches.
Members are not there.
All members are not there, but 4 benches are there.
Benches are functioning. The petitioner alleges that the learned tribunal, by its order dated September 2, 2025, postponed the matter for hearing till June 23, 2026. Full stop. Next para.
My lord, previously, my lord, your lordship will see what is considering the submission of both sides. It appears to us that the report shall be called from SDO Islampur in connection with that. For that reason, it was postponed.
For that 9 months are required.
9 months. As because, my lord, if they filed and one vesting order was there, my lord. After that, my lord.
9 months. SDO will give a report in 9 months.
As because, my lord, your lordship will
I'm
have.
from Malda.
এক মিনিট দাঁড়াও না তুমি বলো
না 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 বলো
দুজনের my lord he that vesting order was there. After that we my lord issue parta to the respective plots, my lord. After that, my lord, the order was when the order was they challenged the Supreme Court's order, that is the status quo, and my lord they filed one application before the SDO for cancellation of parta, annulment of parta. Now the annulment of parta is pending, my lord. Now they filed one application for the way, my lord. And that way, in that way, my lord, SDO was given time for that. Your lordship can shortcut some time, my lord, for the cause of the SDO. SDO will give the report. After that, my lord, we can, tribunal can start. Otherwise, it is not possible, my lord. There is a parta and cancellation of parta. There is a provision.
What is the report called for from the SDO? What will the SDO say in the report?
That is the cancellation of parta.
It's not even clear from this order, Mr. De.
My lord, your lordship clarified the order.
So we don't know why the report from the SDO was called for.
As because, my lord, there is parta. That parta was cancellation of parta was there. They filed application for cancellation of parta. And my lord, that is pending. And after cancellation, my lord, there is a provision of appeal. So I may not want to go.
14 and 15 are safe. 13.
We still don't understand, Mr. De. Report be called for from the SDO. What will the SDO do?
SDO order. SDO,
what will be there in the SDO?
SDO whether the cancellation of parta is
from the records, he'll ascertain what is the situation.
Yes, my lord. Is complete or not, my lord.
Lordship, SDO is the
that will require 1 month, 2 months,
your
9 months.
Your lordship can give that time, my lord. We have not, my lord, we may not want to.
Learned senior, যা বললাম সেই পর্যন্ত তারপর থেকে learned senior government advocate submits.
No, my lord, additional government. I'm sorry, my lord.
As there is no
Yes, sir,
representation from the private respondent, opportunity may be given to file the
learned
opposition. For the private respondent, my opportunity may be given to file opposition, my lord. On that date, my lord, there is no representation for the private.
Very. Learned additional government pleader appearing for the state submits that the long time granted was justified, since a report has been called for from the SDO, Islampur. Full stop. It is submitted that the subdivisional officer shall require some time to sift SIFT through the records and give a proper and complete report to the tribunal. Full stop. Learned counsel appearing for the private respondents seeks an opportunity to file written objection before the tribunal. Full stop. Next para. We find from the records that it is not clear as to what shall be the contents of the report called for from the SDO. Full stop. Be that as it may, since a report has been called for, as rightly submitted on behalf of the state, some time will be consumed in preparing such report. Full stop. However, the long period of 9 months seems to be inordinately long from all perspectives, even for filing a report by the SDO. Full stop. In our opinion, 2 months would suffice for the SDO to collect all materials to furnish a report to the tribunal. Full stop. Next para. Also, to expedite the matter, the respondents in the original application ought to have been permitted to file their respective objections. Full stop. Accordingly, WPLRT 173 of 2025 is disposed of by modifying the impugned order dated September 2, 2025, passed by the 4th bench, West Bengal Land Reforms and Tenancy Tribunal, to the limited extent that the respondents in the original application shall file their respective written objections to the said application within 2 months from date. Full stop. Next para. The SDO shall also furnish the report as directed by the said order by December 31, 2025. Full stop, next para. The concerned bench, the learned tribunal shall thereafter proceed to shift back the date as fixed earlier and make all endeavor to dispose of the proceeding original application as expeditiously as possible, comma, preferably within June 30, 2020, preferably within August 31, 2025. Full stop, no orders to cause urgent certificate copy. প্রথমে হচ্ছে affidavit of certificate. Mr. Dev and all of you, objections within 2 months from now, report by 2 months from now, because we are passing the order now. And by August, 8 months, tribunal will dispose.
No, August 2026.
25 to 26. By default, that is done by. By now, they have become accustomed to this. Thank you.
And next one is same.
Same.
Same, Lordship.
Mr. Dey has turned around, so his name won't be recorded.
No, my lord, I am not here.
I beg to represent the state in
Oh, acha. So give the names properly. In which matter who is appearing?
Yes, Lordship.
Same order.
Certainly.
Same date is same. Date of the order is same.
Yes. Only way will be different.
Way number ta different hobe. To dekhe niyo.
2196. Way number ta.
196.
2196 of 2025.
Thank you. Give separate lists of names. Thank you.
15 minutes back to represent the state, Lordship.
Yes, yes, Mr. Dhar.
I am for the petitioner, I'll be seeking time because in the petition I have mentioned the way along with supplementary affidavit, but inadvertently that supplementary affidavit is not been annexed. So I would like to.
That may be necessary for this.
That may be necessary.
When?
Kotodin.
This is the supplementary affidavit.
No, this is affidavit of service.
order to annex order.
You can bring a copy of the supplementary affidavit straight away, hand over to us.
I have just only one copy.
Pick out copies, give one advance copy to Mr. Khalid so that he can ascertain whether that is he has any objection to.
There is an NGT order also which has not been annexed.
That is annexed in the yes.
Oh.
So where will hand over a copy? Learned.
I have just only one. I'll in
the learned senior advocate appealing for the petitioner submits that the petitioners have omitted to annex a supplementary affidavit referred to in the writ petition.
Yes.
Full stop, next para. Accordingly, the matter is adjourned till November 19, 2025, when it will be listed under the same heading. Full stop. Leave is granted to the petitioner to rely on copies of the said supplementary affidavit upon handing over advance copies thereof to the learned advocate for the respondents during the course of the day.
Well, I'll do that.
Good. Affidavit of service filed to be kept on record protocol. Take out 2 copies for us, 1 copy for him, and thank you.
I'm deeply obliged.
Thank you.
This time for the petition.
Yes.
The evidence service.
Yes, Mr. Chakraborty, what is good service?
Yes, my good.
Lordship, appearing on behalf of the private respondent number 4 and 5.
But here, my
The Mahata was yes, Mr. Dey is there. Yes.
petitioner has come before your lordship.
Take the microphone, Mr. Chakraborty.
Against the perverse finding of the learned tribunal, my lord, you have to kindly see page 7 of the order of the impugned order of the tribunal, my lord. Actually, my lord, title suit has been filed by the private respondent, and injunction application has been rejected against the private respondent. But the findings of the tribunal is that, my lord, petitioner has filed the suit and he.
What is the OF against, directed against?
Against.
What does it arise from, this matter? What did you want?
Well, my submission is that my lord, tribunal has not heard.
No, we understand your submission.
Yes,
this
my lord.
OA was filed by you.
OA filed by me.
Against what?
Against the order of the appellate authority, wherein I have prayed before the appellate authority that at the prayer of the learned prayer of the private respondent, he has applied for title suit before the trial court, and until and unless he has been accrued the right.
What was done by the first authority?
First authority has been
what
done.
Does it arise from? What is the root of this?
Root of this matter against the order of the appellate authority. We has been filed.
Was against what?
Against
make us ask question at every stage. What did all this start from? Some BLLR order or what?
Yes, my appellate authority was not against the order of the BLLR.
So what was the context of the BLLR order?
BLRO pass recorded my name, our name in the record of rights.
You applied for record, your names being recorded.
Recorded.
On the strength of what? Title deed?
On the no, my lord. On the state of, my lord, CS recorded tenant and our predecessor of the CS recorded tenant.
And it was previously recorded in their name, private respondent's name.
Previously, and they got a private another name, my lord, Harmony Dasi. My lord, she has never been. They have been proved their right.
On the basis of CS records, you wanted your recording.
Yes, my lord.
BLLR granted
Well,
that.
granted that. And
then why did you prefer
during period? They have preferred appeal.
They preferred.
They preferred appeal.
Appellate authority set
Appellate
it
authority
aside.
set aside.
Why? On what ground?
That, my lord, we are not entitled to that. And appellate authority has not entertained their file, their title suit, my lord, where their the injunction application has been rejected. I have annexed on that. That has
Appellate
not.
authority proceeded on the finding that what?
Finding on that, my lord.
Respondents have title.
Private respondent have title, and their previous occasion they have title, and their right is
On
established.
the basis of what was
on the basis of the one deed of 1931. 1931.
Very well.
And they have to prove, my lord, on whether the deed is the mortgage deed, but that's the deed of 31 is to be established their right on the basis of otherwise their right cannot be established.
Deed means it was not a title deed.
No, not a title deed. It is the mortgage deed. Mortgage deed.
Property was mortgaged to them.
Previous occasion, the property deed was mortgaged.
1931 property was mortgaged to them.
Mortgage to their predecessor, my lord. And on that respect, my lord, they have filed one title suit. I have kindly see.
Title suit was previous to the OA.
During pendency of the appellate authority. Previous to the way. Previous to
they filed a suit, their injunction has been refused. That does not mean there has been any conclusive finding on their title.
Yes, my lord. So they have to prove that their title, my lord, first on the basis of order of the 31. And my lord, the trial court has observed, my lord, without giving me opportunity to file any reply, affidavit in reply. They have observed, my lord, in page 7 as if at a moment, my lord. And page 7 is reverse finding, where that the applicant's claim also suffers from the vice of the res judicata and constructive estoppel. Their predecessor has earlier approached civil court by filing OC suit number 4021. But the OC suit number 4021 has been filed by the private respondents. But the findings of the tribunal is that seeking declaration of the title injunction over the same land, the said suit was dismissed after full trial, and prayer of injunction was rejected by the landed district.
Their suit was dismissed.
Their suit was dismissed.
You said injunction was dismissed.
No, my lord. Injunction was dismissed. Suit is pending presently. And now, last date.
You are confusing yourself as well as us.
Yes.
This says that OC suit number 40 of 2021 was dismissed. That is not the correct position.
No, correct position. They have some wrong some objection.
First of all, it was not filed by you.
Yes.
Secondly, it was secondly the suit was never dismissed.
Suit was never dismissed.
Injunction application.
In that only injunction has been dismissed of their application.
And on that premise, you have your.
And yes, man. And this next paragraph, the applicant having failed to before the civil court cannot be litigate the same. That full wrong objection.
Come to the next paragraph. Independently, also it is decided. Please read the next paragraph. Third paragraph onwards. The plea.
The doctrine of the finality of litigation.
No, the plea. Next paragraph.
That the appellate authority failed to consider the originality of the case is untenable. That is also wrong, my lord.
Please read.
Yes. The order dated 8/4/2024 expressly records examination in the title deed, RSR1, entries and mutation case sheets. The authority also noted that no credible documentary proof was produced by the applicants to substantiate possession of the inheritable after that. But so, my lord,
let us see the appellate authority's order.
Yes. Page 117.
Thank you.
Here, my lord, may I submit one thing, my lord? And my submission is that if you also kindly see for a moment, page, my lord.
No, first let us see the appellate authority's order.
Yes.
Then we'll go to whatever documents you want.
Here, my lord. Page 118. Yes, you kindly see.
The appeal was preferred by them because
Yes,
it
ma'am.
was mutated in your name.
Yes.
Respondent side claims that suit land to have inherited, page 119, from CS recorded tenants, means you are claiming. You are the respondent
Yes,
side.
I am the respondent.
Appellate authorities' findings are very elaborate. They have placed reliance on several deeds, 3 deeds at least.
So all are in,
recorded in their
before the title suit, they have claimed their right on by the filing one title suit on the similar self-claimed land or land.
Pendency of title suit does not debar the authorities from arriving at a finding.
Finding. And particularly the
Until and unless they have approved their right, or as they have
exclusive, and in fact the very act under which this exercise was done, the act debars the Supreme Court, the civil court exercising jurisdiction in matters which fall within the domain of the authorities under this act. This act confers the power regarding mutation, and that adjudication is prima facie as regard title is concerned.
Yes, ma'am.
So let the civil court do its own job by declaring the title.
But
and if it's otherwise, then they will have an opportunity to do.
Madam, trial court, tribunal has not
Pendency
given.
of a suit does not mean that because it was at the appellate stage only that the suit.
If you will say kindly see formal tribunal.
And they have filed the suit. They are not asking for this to be stayed till disposal of that.
So, my lord, if you will say kindly see.
Injunction dismissal does not mean any conclusive adjudication of anything.
So, my lord, they have concluded the decision. The injunction has been and suit has been dismissed against me. Wrong finding has.
That finding is wrong.
Yes, my lord.
But even without that finding, the next paragraph, the tribunal considers that the plea on merit.
Well, other than that, my lord, I have said
there is a second ground.
Yes, other than
that finding is perverse. We will hold that is perverse.
But no opportunity has been given.
That appellate authority failed to consider the originality of the case is untenable. Order expressly records examination of title deeds, arrest records, mutation case sheets.
But no opportunity has been given, my lord, to me to file affidavit in reply. But if you will see kindly see for a moment, my lord.
Reply is not a matter of right. We in High Court we have that practice, but it is not true.
We have filed opposition, my lord. So I have to file one
reply.
reply.
It's like a plain and written statement. In a suit, if you go and say that I did not have opportunity to file a rejoinder to the written statement, it's like saying that. It's not a matter of right. One affidavit in opposition is a matter of right, if there are factual questions. Further reply, there will be no end to it. It's not a matter of right for which deprivation of which an order will be set aside. And we don't find that you have asked for that prayer, made that prayer. And rather, you argued the matter.
Yes, no, my lord. Yes,
upon rival contentions.
Yes, my lord. Kindly see for a moment, my lord. Yes, kindly see page 123. Why the matter has come before the tribunal, my lord? I have before the tribunal, my lord, in 7 analogous appeal against the 7 analogous appeal, 1 original application has been filed, and in the first instance, page 123, where my lord,
one application, original application, maintainable against 7.
Against 7, that point is required to be heard on the first order.
We are deciding that here. We are saying that it is not maintainable.
As I have made one.
Your original application is not maintainable against 7.
No, as because my lord, I have cited one judgment, my lord, where one suit is there, one application is there.
But
where
you cannot say that question has to be decided first. That has been decided in your favor, deemed to have decided in your favor by entertaining your application and deciding it on merits.
On merit. Merits, but we have missed the job, to submit my before the tribunal.
The maintainability of your application has been deemed to have been held in your favor by deciding the application on merits. You cannot say that my maintainability point was not decided. That was their objection.
Their
They could have said that. Now the maintainability point has not been taken at all. It has been decided on merit by the tribunal.
My final hearing has not been done, my lord. So that's
This is the final hearing.
no,
What else?
my they have, my lord, only.
Let us see the previous order.
Go through the, my lord. Yes, kindly.
Please go through the order dated 10th of September 2025 at the first page of the certified copy.
On that day, my lord, maintainability point has been heard.
It does not say so. Heard all sides, hearing is concluded CAB.
Previous occasion, my lord, on 25th 7 2021, page 123. On that day, my lord, maintainability point should be heard. After that, my lord.
It is a second.
Yes.
123. This was next fixed on 19th of August.
Yes.
Then on 19th of August, what is that order?
19th of August, there is no record on the date, page 124.
You have not provided the certified copy of that order.
Yes, my lord, 124. 124, my lord. I have submitted.
Achha, let us see this. Liberty was given to file affidavit in opposition.
Yes.
Them. Let them appear on such and such.
Then 10th.
Yes. No, 1st of September, what happened?
First of September, record was not there. On that respect, matter has been adjourned on 10th of September. Record was not available.
Yes, Mr. Mahato, it was on 25th July. It was fixed for, you took an objection of maintainability. Affidavit was directed, but the maintainability point was still to be heard because it was directed to appear as a motion still, not for hearing. On 19th August also, motion, adjournment sought, motion. And then suddenly the tribunal says hearing is concluded. It was the maintainability point which was being heard. Nothing is recorded that on consent the hearing is taken up for hearing in the main matter.
But the order reflects that everything has been done. Order reflects.
Yes, but even the previous order never says.
That does not reflect that the
adjourn. Before the two adjournments, Mr. Mahata, the last order recorded that you have raised a point of maintainability. As prayed for, liberty is given to file opposition.
My lord.
Such as appearing for the content raises the. But Mr. Chakraborty, it was not said by the tribunal, recorded by the tribunal that the date is being fixed for maintainability. Rather, affidavits were directed and the main matter was fixed.
Yes.
You see the order dated 25th of July.
That has been reflected, but on the first order, 25th July.
25th July, we are there only. Please come to that. It barely says that learned counsel, your appellate decision, it is within time. Learned counsel appearing for the contesting private respondent raises the point of maintainability. But then, as prayed for, liberty is given to you to file affidavit in opposition. So they raise the question of maintainability. You are directed to file affidavit in opposition. Obviously, both would be hard together.
Affidavit in opposition against the private respondent, my lord. In respect to private respondent. And
waiver. And affidavits are directed. If affidavits are directed, they sought for
private respondents to file affidavit.
They prayed for filing opposition. Therefore, they were given opportunity. State did not.
Yes, my lord.
Therefore, state was not directed.
And no opportunity for filing affidavit in reply. So you have to kindly remand the matter, heard the matter on merit. And this is my submission.
Opportunity to whom? The state could take that point. You had preferred the original application. They are only private respondents and not the state. Only the private. Only the private respondents prayed for filing objection. That liberty was given. State did not ask. State was not directed. It is only recorded that maintainability point is also raised. But then affidavits were directed. And the matter was taken up for hearing and heard. It's recorded. Heard all side. Hearing concluded CAV. You have to go by this. But it was never fixed for hearing on the point of maintainability only by any of these orders. It's only recorded they raised the question of maintainability, which was heard along with the main application.
And particularly, my lord, the
Man, after
44 to a, my lord, page 119, there was a 44 to a proceeding. And there is a statutory appeal 44.3, that is the by the before the district judge. The petitioner did not avail that. A original application was filed and it was withdrawn. The second and third paragraph. The respondents side claim the suit lands to have inherited from CS recorded tenants and claims that RS Kotian number 216 was framed erroneously in the name of Horomoni Saha. It is understood that in order to get the said RS ROR recorded corrected,
Estate acquisition একটা দিন তো
section 44.3.
ওই উপরে
44.2.
উপরেরটা
And the district judge is the my lord, the appellate authority.
That appeal was never.
That appeal was never preferred by the petitioner. Subsection 3 of section 44.
To a tribunal.
Tribunal is the district judge. Not the land tribunal. And they went to the filed original application that was withdrawn on that ground. And he has not placed that order also. He has not annexed.
Thereafter, no 44.
Thereafter, no 44.3. But plain section 50 application before the revenue officer.
That is not the liberty.
That cannot be done. 44 order are passed under 44 2A have become final.
No, it's recorded that prayer not being considered by the ADM, appeal was preferred. There was no adjudication on merits by under 44 2A. Page 119, Mr. Mahata, the respondent side claims, this is the third paragraph,
My lord.
where 44 2A is written. You can come there. It is understood that in order to get the said RSRO recorded, a prayer under 44 2A was filed by the respondent. Yes, that prayer not being considered, an appeal being not that being turned down or being rejected. That was not being considered. Therefore, they went before the LRTT for an early hearing of that. But then they withdrew that. Even without that, the finding of the court is that because the appellate authority, Mr. Chakraborty, has considered all the documents.
All the documents.
Munila Saha deeds, 3 deeds have been considered.
All the deeds is under challenge, my lord. They have preferred, they have filed one plain manner. So that should be heard, my lord. If your lordship kindly remand the matter to the tribunal, my lord, tribunal to give an opportunity of hearing, my lord, to me. And on the immediately after there is no
opportunity of hearing was given to
no, my lord. I have not submitted my submission. I only want on the basis of analogous matter I have submitted.
No, 10th of September, Mr. Chakraborty, your name is recorded with such
Yes, recorded, my lord. On that day,
on behalf of the applicant.
on that day, I have argued, my lord, this 7 application against the order of the 7 appeal. 1 application is entertained. That argument has been done, my lord. I have submitted one. If your lordship kindly call for the record, I have submitted that one judgment, my lord, where specifically stated that one common question of law and common land and cost title is the same. Similar, this submission has been done. But my on the hearing has not been done on the.
But there in the before the tribunal also, maintainability was being heard. It appears so.
Lordship,
you are personally there in the
yes,
argument.
yes,
Very good.
Lordship.
Yes.
Lordship, before going through this case, it is a long series of cases.
No, first answer our question, then we'll go to the long series. Actually, was the maintainability point being addressed? Be truthful.
Maintainability point was addressed before the Honorable Tribunal in the very first day, Your Lordship. There was that time that was already hard. The very single line was there. 5 mutation cases, 5 appeal. Why they filed?
Nothing is recorded. It says
Your Lordship, on the date of order, that is page number 123.
Yes.
Dated 25th.
Learned Counsel for Contesting Private Respondent, you raises the point of maintainability.
On the very first
that is not decided on that date.
No. That is not decided on that, Your Lordship. I made a submission before the Honorable Tribunal on that day.
Yes.
They make an objection, and that's why the tribunal passed an order to give a evident opposition in our favor. Kindly, your lordship, come to our opposition. Now, this is the very
No,
important.
whatever is there, where is the adjudication? I mean, it was
Uh,
never fixed for final hearing.
No, your lordship, after
Did
that.
they argue what happened on 10th of September? Tell us, you are Mr. Chakraborty, Chaudhary?
Yes, yeah.
Mr. Ognishwar Chaudhary.
Yeah, exactly, your
Mr. Chaudhary, on 10th of September 2025, what happened? Did the parties argue on maintenance?
Exactly, each and every day that was argued.
10th of September, 125.
Yes, yes, yes.
Was there any
Not-
argument on merits?
Yes, your lordship.
Apart from maintenance?
Not only that, your lordship, on the
No,
very...
don't bypass our question.
No. On that day,
on 10th of September, was any argument advanced by them on merits of the matter apart from maintainability?
No, your lordship. Each and
Yes or
every
no?
point was heard on that day with the maintainability point. With the maintainability point, the judges asked them, "Do you provide any reply?" They said, "No."
Cross-examination is enough for us.
And kindly go to
demeanor of the
opposition,
witness is
your
before
lordship.
us.
They asked.
That's the advantage of the first court. Well, we'll remand it.
And lordship, kindly come.
We'll remand it. It has to be heard on merits. Let them get an opportunity of hearing on merits. We'll direct the tribunal on the materials which are on record within a month. Tribunal will dispose of upon hearing both of you on merits.
Lordship, only one submission. Kindly.
Will not enter into the merits.
No. Just kindly page 137. Once.
Yes. 137.
That's why in the very first submission before your lordship, I told you I have to
Yes,
give
yes,
some.
yes.
Each and every moment, they filed a case against us before the honorable tribunal. And this is the very first case.
There's a habit formation. After filing one or two cases, there's a habit formation.
And
Then you
that's
have a
why
habit every day. You want to file a case. You get up in the morning, want to file a case. In the
Exactly.
evening.
Your lordship, and
That's-
after
it's habit
7
formation.
years,
So
they
let them
fought.
be on that. Let
They
them spend their money
no,
in
the petition
litigation.
was wrong. Again, file in 2023.
It's a habit,
Then
sort of
25.
habit. It's a sort of recreation for some people also. Let them have their fun. You go on contesting.
Lordship.
Learned counsel for the petitioners submits that the learned tribunal committed a patent perversity in proceeding on the premise that a suit filed by the present petitioner seeking declaration of title and injunction over the self-same land, which is the subject matter before the tribunal, had been dismissed after full trial and prayer for injunction was rejected. Pushed upon such premise, the learned tribunal held that the petitioners having failed before the civil court cannot relitigate the same issue before the tribunal under the guise GUIAC of a mutation dispute, and the doctrine of finality of litigation squarely applies. Next para, from the records, learned counsel seeks to impress upon us that it is actually the private respondents herein and before the tribunal who have filed a title suit bearing OC suit number 40 of 2021, which is still pending. However, an application for temporary injunction made by the private respondents before the said court was turned down. Next para, as such, it is argued that the learned tribunal proceeded on a palpably erroneous premise. Next para, that apart, learned counsel for the petitioner submits that it will be evident from the order sheet before the tribunal that the matter was fixed for maintainability hearing on the ground that by the self-same original application, several appellate orders were challenged by the petitioner. Hence, arguments were advanced by all parties on the issue of maintainability and not on the merits. And, as such, the learned tribunal acted without jurisdiction in deciding the main original application itself on merits. Next para, learned counsel for the learned senior government learned additional government pleader and as well as learned counsel appearing for the private respondent submit that the learned tribunal was justified in observing that the appellate authority had entered into the merits of the case and considered title deeds, RS, records of rights and mutation case sheets and had come to a conclusive finding. Moreover, learned additional government pleader contends that a previous application filed by the present writ petitioners under section 44 within bracket 2 small a bracket close of the West Bengal Estates Acquisition Act 1953 was subsequently challenged before the concerned tribunal, but withdrawn. Full stop. Hence, comma, the issue has already attained finality. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we cannot say that the tribunal heard the matter either on merits or on maintainability. Full stop. No conclusive finding either way can be arrived at from the cryptic order dated September 10, 2025, which merely records that counsel for the parties were heard and hearing was concluded and the matter was made CAV. Full stop. Next para. However, comma, from the previous orders, it transpires that although the original application was not specifically fixed for hearing only on the point of maintainability, comma, fact remains that the issue of maintainability was raised by the private respondents who were directed to file their written affidavit in opposition. Full stop. In such opposition, comma, also the maintainability and merits were challenged by the private respondents. Full stop. Thus, comma, some doubt remains as to whether the parties only address the issue of maintainability and not the main original application on merits. Full stop. Even otherwise, comma, the tribunal ought not to have decided on merits the application without deciding the point of maintainability either way, comma, since a serious issue was taken as to whether a single original application can be preferred against appellate orders passed in different appeals. Full stop. Next para. Moreover, comma, insofar as the withdrawal of the previous challenge to an order passed under section 44 within bracket 2 small a of the 1953 Act is concerned, comma, we find from the recording of the appellate authority that a prayer under section 44 within bracket 2 small a of the 1953 Act was made by the respondent, which having not been considered, not been considered, double inverted, by the ADM and DL and LRO Malda, comma, an appeal was preferred, which was later withdrawn. Full stop. Hence, comma, it appears prima facie that the appeal had been preferred against non-consideration of the prayer under section 44 within bracket 2 small a and not dismissal of such prayer. Full stop. Thus, comma, the concept of res judicata cannot be said to be directly applicable at this stage without ascertaining the facts from the records. Full stop. Next para. Be that as it may, comma, the learned tribunal also proceeded on a perverse premise that a civil suit filed by the present petitioner was dismissed and the same issue could not be relitigated, whereas the suit is still pending at the behest of the private respondents and not the petitioners, and an injunction prayer made therein has been refused. Full stop. Next para. In such view of the matter, we are of the opinion that the learned tribunal, that the matter ought to be remanded to the learned tribunal for a complete adjudication upon giving adequate opportunity to the parties to adjudge, to address the issues on merits. Full stop. Hence, WP LRT 183 of 2025 is allowed on contest, comma, is partially allowed on contest, comma, thereby setting aside the impugned judgment dated October 31, 2025, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 1740 of 2025, bracket LRTT, and remanding the matter to the said bench of the tribunal for a fresh adjudication on merits as well as maintainability of the case. Full stop. It is made clear that the learned tribunal shall proceed first to decide the issue of maintainability, which has already been heard by the said tribunal. Full stop. Thereafter, comma, in the event the issue is held in favor of the original applicant, comma, the parties would be afforded an opportunity to address the merits of the original application, and only upon such opportunity being given on the materials on record, comma, the tribunal shall come to a final conclusion of the same. Full stop. It is expected that such entire exercise shall be done by the learned tribunal within 2 months from the date of communication of this order to the said tribunal. No address to cause, certain certified copy. It is made clear that the merits of the respective contentions have not been gone into by this court, and the tribunal shall proceed to decide the all issues without being unduly influenced in any manner by any of the observations made up.
Get full of factors.
My learned brother has another bench, so we have to rise. We'll sit after recess.
My lord, I am appearing for the appellant. My lord, the first
Yes.
tendering my apology
Right.
for in a hot haste, we have filed this matter, my lord. Due
Want to withdraw
to
it?
non-availability of Wakalatnama, we have to delete some name, my lord. There are four petitioners, and my lord, kindly grant me the leave to add their name as pro forma respondent. The years of Barendranath Giri.
Sir, can't you leave? You move the matter, no be difficult. Do it during the course of the day. Acta Dikita, on the prayer of learned counsel for the petitioner, leave is granted to add uh, 3 other persons as pro forma respondents in the present application. Yes, what is the matter?
But we have come here before for challenging the order of condonation of delay, my lord.
Delay has been condoned.
My lord.
What is the span of the delay?
According to us, 177 days, and they have written in their MA application 118 days. Court has not adjudicated that the days. What has happened, my lord?
Yes.
What has happened, my lord? On the first occasion, initially, the respondent Kanchan Giri, who claiming as a wife of Barendranath Giri, originally tenant, Thika tenant, has tried to inducted her name before the deputy Thika controller by filing a false affidavit. When we came to the know petitioner, we have objected. And after that, he has come up with a new plea by a suspicious 12 years old gift deed trying to induct her name, in which the Barendranath Giri was a donor who has died, and her son, Osim, he has also died, which is rejected by the deputy controller. Against that order of 9th October 2023,
Annexure P1. Annexure P1.
yes, came before
page 20.
This filing this way.
Annexure P1,
And
page 20.
that was
No,
rejected.
first the name was recorded, then you filed an appeal, you won that appeal.
Yes.
Against that, they have preferred.
My lord.
Very well.
And on October 9th, the order was passed.
Yes.
Before the deputy controller. Against that, they have filed this way on 4th April 2024.
Yes, he's a senior citizen, he says long elements. We are
No
looking at
elements, no scrap of papers he has
this
annexed.
is a judicial discretion, it has been exercised by a quasi-judicial authority.
My lord, kindly see their
One of the
conduct.
plausible views has been taken.
My lord, kindly see their conducts. How they have, how they have. My lord, kindly come to the opposition of my opposition, that is page 68. It's 68, sorry, 68. It starts from 64, starts from. They have filed that false affidavit first. Secondly, they have coming with a new plea with a document of 12 years old.
That is on the merits.
My lord. After that, they have served a notice.
Yes,
They have
only-
served a notice
Yes.
dated 11th May. That matter will appear on 20th. When we have appeared that scene, that matter was heard on 70th on their notice.
What matter was heard?
That
Section 5.
way, yes, my lord, we have annexed that order. Again, on
So how is that germane in considering the explanation in the condonation application?
they have admitted.
What admitted?
They have admitted that facts. Well, kindly
Subsequently, they gave notice about the OA or something that is post facto after filing of the section 5. We have to see the explanation for the period of delay from date of the order and the impugned order and the filing of the challenge.
No document. No. First of all, they have not annexed any medical documents in the MA application. Again, they have
affidavit that has been believed by the tribunal. If
again
this-
they have filed.
At the first forum, we could have argued that, but one forum has taken a view on this. One of the plausible
We
explanations
have
their averment is supported by affidavit that
we
has
have-
been believed, oath versus oath. It has been believed by the court, by the tribunal. Why should you interfere with that?
we have
the harm?
we have filed. We have explanation
This
was
is what I'm
there.
saying. Oath versus oath. You have filed
Explanation was there, my lord.
If the explanation was there, that
They
has
have
been
admitted that. And no, again, then in the reply, they have annexed some documents, but not on that dates. They have filed some documents up to 8th. 8th.
8th what?
8th August.
8th
August
8th August 2023. And then they have annexed page 96. And after that, page 97, they have annexed those document 29th/11/2024. In the interim period, no document they have annexed, which was our specific plea. And in their reply, they have admitted all the facts. Still, court have allowed this.
What facts have been admitted?
Entire facts, what I've said. Malak, kindly see. Well, kindly come to the page 83 once. Third paragraph from the bottom. It is a fact that appellant Kanchanagiri is not so qualified. She affirmed the affidavit, understanding the full contents thereof. That false affidavit they have filed.
That is on the merits again.
And again, my lord, kindly come.
Section 5 has been allowed.
And my lord, kindly
you argue on the merits.
My lord, kindly come. And page 85, paragraph 6. The statement, averments, and objection and the allegation as made in paragraph so and so, the said objection are not the fact. The said sequence happened due to the wrong communication of the clerk of the senior advocate of the applicant, for which the innocent applicant should not be blamed. They are the agent of the appellant, my lord. My lord, I am relying on my lord's judgment. The conduct of the
unreported হলে একটা
how they have dealt.
তাহলে কপি দিন একটা
এই রিসেন্ট জাজমেন্ট এটা কপি আছে আছে কপি একটা দিয়ে দিতে হবে ওর কপি আছে আর এক্সট্রা কপি তোমার কাছে এক্সট্রা আছে দিয়ে দেবে ওইটাই নাম্বার করে দিয়ে দেবে
Yes, which paragraph?
Paragraph 42. Paragraph 42.
42.
Paragraph 40. জাজমেন্টে চলে গেছে সেটা দিলে কেন কেন মামলা করতে দিতে হবে তো
And moreover, my lord, on that order, my lord, kindly see, the appeal has already been admitted. Before restoring its own position or for admission, matter has already been admitted. How can it be?
Where?
Without hearing us, my lord, kindly come to the
For admission, no,
last.
no, there is no admission hearing provision.
Yes.
If the
My lord, it is
condemnation
ordered.
application is allowed, automatically
Last paragraph.
yes,
it is
there is
ordered.
no provision for admission. There is no order 41. Admission means automatically it's registered and admitted, unless there is any flaw.
Without hearing us.
Without hearing you, there is no provision for hearing. Under which provision should you be heard? Under which provision should you be heard? Under which provision is there admission hearing before the tribunal, please? Yes. Which provision? Order 41. Heard learned counsel for the parties. Next para, learned counsel for the petitioner submits that the learned tribunal erred in law and without jurisdiction in allowing the condonation application of the private respondent herein on without there being sufficient explanation for the delay. Learned counsel points out that throughout the explanation sought to be given in the application for condonation and the affidavit in reply filed by the private respondent before the tribunal, the delay was mentioned to be about 118 days, whereas the delay was much more. Thus, it is argued that there was insufficient explanation for such delay. So next para, learned counsel for the petitioner next argues that certain documents were annexed to the affidavit in reply before the tribunal by the private respondent, which were of a different period than the period during which the delay was occasioned. Next para, learned counsel further submits that blame was sought to be cast on the clerk of the learned advocate for the private respondent dealing with the matter in the tribunal and in the before the appellate authority, which has been deprecated by this court on several occasions. Next para, learned counsel further adds that the tribunal, upon allowing the condonation application, admitted the original application of the private respondent without giving any hearing to the present petitioner, who was the respondent therein. Next para. Lastly, learned counsel for the petitioner cites an unreported judgment of a coordinate bench of this court in FAT 33 of 2024 within bracket Baxter bracket India bracket close private limited versus Srimati Devjani Bose বাইরে square bracket ওই ওটা ইন্ডিয়াটা এমনি. Next para. Learned counsel appearing for the state. What is your stand, Mr. Dey? Neutral stand or you oppose this?
I am permitted to modify only one thing.
Yes.
My lord, now according to 29(2), my lord, there is no provision for, but there is a provision in the West Bengal Land Reform Tendency Tribunal 1997, my lord, 10(2), that application should be 10(2). That misquoted of application, my lord, this petition should not be disturbed. So I may not want to do so.
No,
but he should file the application under section 10 subsection 2 of the West Bengal Land.
Caption of the way.
Yes, my lord. Caption of the section 5, that there is no provision of section 5, my lord, in that there is a specific provision of that West Bengal Land Reform.
Under 10(2).
Yes, my lord, 10(2).
We will record that.
Yes, only modify, only.
Learned senior government, learned additional government pleader submits that the caption of the condonation application was mentioned to be section 5 of the Limitation Act, whereas section 10 within bracket 2 of the West Bengal Land and Land Reforms Tenancy Tribunal Act is the relevant provision. However, serious objection is not raised by the state on such ground, and it is submitted that such provisions should have been modified. Next para, learned counsel appearing for the private respondent opposes the contentions of the petitioner and stands by the order passed by the tribunal condoning the delay on the ground that sufficient explanation was shown before the tribunal. So next para, in the cited, upon hearing learned counsel for the parties and going through the materials, comma, we find that the judgment which has been cited before us is a double-edged sword. Full stop. In it, comma, it was internally observed that the latest view taken by the Supreme Court is that in respect of condonation applications under Section 5 of the Limitation Act, comma, in order to advance substantial justice, comma, though a liberal approach, comma, justice-oriented approach is to be kept in mind, comma, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act, full stop. It was further observed that the courts are empowered to exercise discretion to condone the delay if sufficient cause has been explained, comma, but that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as, comma, where there is inordinate delay, comma, negligence and want of due diligence. Full stop. Next para. It was further held by the coordinate bench, comma, following judgments of the Supreme Court, comma, that delay condonation applications have to be decided on the parameters laid down for condoning the delay, and such condonation for the reason that the conditions have been imposed tantamounts to disregarding the statutory provision. Push up next para. In the present case, comma, we find that in the condonation application, comma, it was stated on oath that the applicant therein, within bracket private respondents herein, comma, respondents singular, is a senior citizen suffering long from various ailments and could not contact the advocate timely so that the subject appeal could be filed within stipulated period. Push up. Also, comma, it is mentioned therein that owing to her long suffering from various ailments and due to certain other reasons, comma, the certified copy of the order could not be collected from the within double inverted lower court in time. Push up. In her reply filed before the tribunal, comma, the private respondent stroke applicant therein stated that she contacted her advocate and the delay of contact with the advocate occurred due to her acute ailments from various oldness disease within double inverted oldness, double inverted disease and orthopedic problems for which the applicant had undergone intensive treatment from a renowned doctors and hospital. Full stop. Next para. It has further been stated that the necessary medical certificates and prescription of a long-standing treatment could not be annexed to the original application due to the wrong communication of the clerk of senior advocate of the applicant. Full stop. Next para. We find, comma, accordingly that sufficient and substantial explanation was given. Full stop. We also have to take into consideration the fact that the applicant, comma, who is a lady, comma, lost her only son and her only daughter is married and she is staying with her in-laws staying in her in-laws house. Full stop. Next para. Taking into context the social standing and position of the petitioner, comma, it is not entirely unbelievable that due to her ailments and due to communication gap with the advocate's clerk, comma, the delay was occasioned. Full stop. Proof to the hilt need not be given in respect of condonation applications, comma, since a condonation application is not a full-fledged trial. Full stop. The sufficiency of the delay and sufficiently of the delay. The sufficiency of the delay depends on the perspective on the concerned court stroke forum. Full stop. Next para. In the present case, comma, even applying the tests laid down by the Supreme Court and discussed in Baxter within bracket India Supra, comma, we find that the tribunal acted entirely within its jurisdiction in accepting one of the plausible views by condoning the delay in preferring the original application. Full stop. Next para. Although fact remains that all through the application and the reply, the private respondent reiterated that the length of the delay was 118 days, whereas the tribunal proceeded on the premise that the delay was actually 177 days, comma, the the erroneous mention of the number of days is irrelevant, comma, since taking into consideration the entire pleadings of the condonation application and affidavit in reply of the applicant stroke private respondent, comma, it is evident that the entire period of delay has been explained substantially. Full stop. It is well settled that delay need not be explained day to day, but the entire period is required to be explained. Full stop. Also, comma, the delay of 177 days is not so inordinate that it would take the span of delay into the periphery of absurdity or inordinate delay. Full stop. Next para. Hence, comma, we do not find any reason as to why the discretion exercised judicially by the tribunal in condoning the delay should be interfered with. Full stop. Insofar as the argument that the original application was also stated to be admitted in the impugned order, comma, there is no provision akin to Order 41, Rule 11 of the Code of Civil Procedure in the West Bengal Land Reforms and Tenancy Tribunal Act, comma, which requires any separate admission hearing to be given and or any right of hearing to the respondents at the admission stage. Full stop. The expression double inverted admitted double inverted clause used in the impugned order is equivalent to double inverted registered double inverted clause and was naturally used by the tribunal after condoning the delay and taking the original application on board. Full stop. Next para. Insofar as the argument of the state regarding the wrong caption being used is concerned, comma, it is well settled that mere erroneous mentioning of caption does not denude the forum stroke court of the jurisdiction to hear an application and grant relief if the said forum stroke tribunal stroke court is otherwise empowered in law to do so. Full stop. Thus, comma, the erroneous mention of Section 5 of the Limitation Act is immaterial inasmuch as the tribunal was empowered under Section 10 within bracket 2 of the said Act to condone the delay, and such exercise has been undertaken on merits. Full stop. Taking into consideration all the above factors, comma, we do not find any necessity of interfering with the impugned order. Accordingly, WPLRT 184 of 2025 is dismissed on contest without an order as to cause. Next.
লিভ দিয়েছে ওকে ঠিক করে কারেকশনটা করে
But I am appear to be of the applicants, my lord. These are application for restoration, my lord.
You have served a copy?
Yes, my lord.
With 2 and 3.
This is
one. What about one?
One, my
One
lord.
to my knowledge. And this is the online certified copy.
What does your affidavit of service say regarding one?
No, my lord. Hi, yes, my lord.
What no yes?
I served copy, my lord.
One has been served.
No, not received, my lord.
What is it?
Two received.
2 and 3 received.
2,
I am
3.
appealing on.
You have got some death certificate or something, Mr. Mishra? Oh, you have got a copy of the receipt?
Yes, for the online.
Respondent number 1.
Is the respondent number
2, 3,
one contested with you in the
no
in the trial court? No, separately.
2, 3, 4, 5, and 6 received the code.
No, this is a Section 5 application.
Yes, my lord. Coordination of deal number 970.
registration application.
With a
Oh, restoration because it was dismissed by division bench. That you have to substitute. If you know, please inform the heirs.
Yes, I have any of this certificate.
We are giving it back. You just hand over a copy of this
after allowing the restoration application.
in the name of a dead person.
No, my lord.
It cannot.
I just know, my lord.
learned counsel appearing for the respondent numbers. You file your affidavit of service filed to be kept on record. Push up, learned counsel having instruction to appear for the respondent numbers 2 and 3 submits that the respondent number 1 has died in the meantime. Push up. Learned counsel also places reliance on a photocopy of a death certificate in that regard. Push up, learned counsel, the learned advocate for the respondent numbers 2 and 3 is requested to furnish a copy of the death certificate of respondent number 1 as well as the particulars of the heirs and legal representatives of respondent number 1, if known to the respondent numbers 2 and 3, to the learned advocate for the petitioners, appellants, by tomorrow, if you know the particulars.
1 week time.
1 week, very well, very well. By November 24, 2025, in writing. Push up next para. The leave is granted to the appellants to file an appropriate application for substitution of such legal heirs. Push up. Let the matter go out of the list for the present with liberty to mention as and when such application is filed.
Allow me to receive a copy of the death certificate.
I will hand over the order is there, my lord, along with the details. I will hand it over.
Give a copy, you can give a copy.
And also,
Only one copy after making.
and also supply me the details of the.
Yes, already order is there.
applicant.
Order is
Did you hear when we pass the order?
Get
order is there.
Next matter, please.
My lord, I am appearing for the respondent number 1 applicant, my lord. Can
What is the application for?
my lord, application for my lord on 19th of September 2019, my lord, there was a direction to file the my lord, paper book. Since then, the paper book has not been filed.
They have not filed.
The applicants, my lord. Now, my lord, I am only seeking a direction to give upon me, my lord.
Your instructions are written on that paper.
No, no, my lord.
Yes, why haven't you filed the paper books?
The TCR was eligible. The TCR was
There
eligible.
was a
So
defect
we are
in the TCR, my lord. Defect has been cured. TCR has come back, my lord.
Was illegible, he says. That's why he could not be.
No, my lord, it was earlier.
No, we are working on the paper book. So it will take some time.
What do you exactly mean by working on the paper book?
I mean, my senior said that we need some time.
Yeah.
So the council
You are asking for preparation of the paper book.
Yes,
You are directing them. Your costs are saved. Since no paper books have yet been filed by the appellant till date, as per direction of the court, the present application has been filed by defendant number 16.
Well, respondent number 1, my lord.
Can 2 is yours?
Yes.
That's very well. Who has filed this application? This was, the respondent number 1 in the appeal has filed the present application for a direction on the said respondent to prepare and file the necessary number of paper books. What about service of notice of appeal? That has been
done, my lord. In my
those things have been
Yes,
completed.
my lord. In my
Only the
application-
paper books.
Yes, that
Very
will
well. In view of the nature of the application, we are of the opinion that in order to expedite the appeal, such directions may be granted. Accordingly, can 2 of 2025 is allowed, thereby directing the respondent number 1 to prepare and file the requisite number of paper books within
8 weeks.
8 weeks. Next para, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
My lord, affidavit of service be taken.
প্রথমেই একটা affidavit of service file to be kept. Next.
Respondent number 1.
Give your reference. Both of
Yes, your lordship, I am appearing on behalf of the petitioner, your
Yes.
appellant. Dutimoy Banerjee is leading me in your lordship. In this
That is the
matter-
ground for contempt.
No. I am just informing your lordship. On the previous
What is the
occasion,
delay?
there was delay on the previous occasion, your lordship was pleased to direct us on 11th November 2024 and grant leave is granted to the appellants to file supplementary affidavit to can 1 because the number of days were not there, your lordship. I am filing these
Not
applications.
number of days. Explanation.
Explanation to the dose.
Only 17 days delay, but the explanation was not.
Yes, your lordship. I am filing the affidavit in supplementary affidavit coupled with the affidavit service, your lordship. That at it has been.
No. 1 minute.
Yes, your lordship.
This is in respect of which appeal? Effective 106.
106 and 144, both of them, your lordship.
You directed the trial court records to be sent down and all.
Yes, your lordship, that has
So
been done.
supplementary affidavit
Yes,
can work.
yes, your lordship. In the meantime,
You had asked for that time.
yes, your lordship, I have asked for the time to file supplementary affidavit.
The delay is of only 17 days.
17 days, but as per
Report.
the delay is more than 17 days. It should be raised as
More than 17 can mean 1 lakh also.
no, 28 days. Your lordship, kindly takes page number 4.
Let us see the
Fact
stamp
num-
reporter's report first.
Yes, stamp report is 28 days. In the meantime, your lordship, the appellant number 2 has died.
Very good.
So we have to take out an application for
So
substitution.
you'll have a good practice in making several applications.
No. Your lordship, we have already filed that application, but formal or
Reporter says 28 days.
28 days, yes.
You say 78 or something?
17, we have filed section 5.
28 days delay.
28 days delay. We have, and for that reason,
You could not keep contact with your advocate because you are to prolong age-old diseases. Prolong age. What is age-old disease? 80 years old.
80 years old.
Why did you ask for a
106,
supplementary? You should have
106.
allowed it. You have given a copy to the other side.
No, your lordship.
Oh.
No, this has been done. This application has been done. For
Supplementary,
that
you have
reason-
given a copy.
Yes. For that reason, I have already from one affidavit of service, your lordship. It
So
has,
they have received
yes, your lordship.
both of them.
Yes.
But not both. There are several.
Yes.
All 10 have received.
Yes. They have received.
You're not sure.
But they
Your
have
yes
received
did not sound very solid.
They have received, your lordship, but some of them may not, because I am not sure about the address, your lordship. Few of them.
What do you mean you are not sure about the address?
Your lordship, let me check. As per affidavit of service, they have received it, your lordship.
But you are not sure of their address.
No. I have made the address as per the plaint.
It was your plaint or their plaint?
Our plaint, your lordship.
So as per your plaint you have sent.
Yes, your lordship.
They received in the trial court.
Yes, they received in the trial.
That address.
Yes.
So you have sent at those addresses.
Yes.
How long back did you send?
Yes, it was in the month of
November.
November, your lordship.
November means November 2024.
24, your lordship. After that, it is
Yeah,
appearing before this lordship.
What is the matter against appeal against?
Appeal against partition.
Achha, you have served copies of only can 1 and supplementary.
Canon 1 and supplemented, your lordship.
Partition.
Partition.
Preliminary or final?
Preliminary, your lordship.
You have asked for injunction.
Injunction.
Or stay.
Yes, your lordship.
What? Yes to which? You said
ABC
injunction or-
property, ABC property for C property, your lordship, because the C property has not been adjudicated properly, your lordship.
An application for addition of party has also been filed?
Substitution. It is for substitution, your lordship.
That has been
Can
allowed.
4. No, can 4.
You served copy of that?
No, your lordship. Can 4 was filed subsequently, your lordship.
You serve copy of all the applications on the respondents and come back. All applications.
All applicants stay.
Affidavit of service filed to be kept on record. Full-stop, it transpires that there, although the condonation application and the connected supplementary affidavit have apparently been served, comma, other applications, comma, including an application for amendment of cause title upon the death of plaintiff number 2, as well as addition of party, have not yet been served. Full-stop, however, comma, since the application for addition of persons and the other application mentioned above are required to be taken up along with the condonation application, comma, the appellants are directed to serve copies of all applications filed in connection with the present appeal on the respondents, indicating that those will be listed next on December 8, 2025, when an affidavit of service to that effect shall be filed by the appellant. Serve all and come back. There is no confusion. We can allow one by one. And please clarify for why addition then. Heirs are already on record.
Years are already few
Why
few
addition?
years. No, substitution should be.
So why addition?
No, addition has been
Substitution has been related and addition.
addition has been done. It was done as per instruction by the department, your lordship.
And department also told you what grounds you have to write.
No, no.
আমার দিচ্ছেন কেন?
This is the second, your lordship.
What second one? There are two appeals.
Two appeals, your lordship.
Same order can govern.
Same
both?
order will cover it.
Same order govern. both? Appeals করে দাও।
Will appear for the applicant.
Yes.
And on the last occasion, you also directed me to serve a copy of the memo and can 1 and can 2. I have served. My lord, I'm filing affidavit of service. My learned finish appearing. Well, today I've received at 141 opposition to the stay of application. Regarding condonation, he has nothing to say because nothing has been.
Can you please come to the microphone? Come to the microphone. Mic.
I have to take out the certified copy of the summons of the trial court suit. I have already applied for that. I have not taken out, so I could not file specifically regarding condonation of this. There is a 239 days delay.
8 days delay.
239 days delay.
13. Yes. You want to use an affidavit in opposition?
It was not. Yes, I want to file affidavit in opposition to it. I have filed today regarding stay application.
This was an ex parte degree against which the appeal has been preferred. That is why you want to take out the summons from the trial court to prove that they were served.
Yes.
How long would it take? We cannot delay
Fortnight,
this.
Your Honor, kindly give me fortnight.
Maximum fortnight we are giving you, file your opposition within that.
I said, try to.
You do whatever you have to do to get it early. Which court? Which district?
City Civil Court.
City Civil Court, you.
I have applied for that. I could not take out.
You exert your magic and get the certificate copy.
I am trying to.
Very well. Learned counsel appearing for the respondent seeks a fortnight's time to file affidavit in opposition to the condonation application. Full stop. Keep your affidavit in opposition to the stay with you. If you don't allow the condonation, then why should you file that? Taking that means we are condoning the delay. Next para. Learned counsel also seeks provisionally to use an affidavit in opposition to the stay application filed in connection with the appeal. Full stop. However, comma, since the condonation application has not yet been disposed of, comma, the affidavit in opposition to the stay application is not taken on record. Full stop. Next para. As per prayer of the respondent, comma, the respondent is directed to file affidavit in opposition to the to can 1 of 2024 within a fortnight from date. Stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed next. The applications shall be listed next for hearing on December 15, 2025. No, file it in the department. Leave is granted to the learned advocate for the respondent to file the vakalatnama in the department. You please, you have got a copy of the opposition of the stay also.
Lordship.
So you please keep prepared the reply copy and give an advance copy to them so that if we allow the condonation application, immediately we can take up the stay application and dispose of the same.
Lordship.
Thank you.
I am appellant, my lord. Last occasion, my lord, was
Please give the appearances in the previous matter. All of you. Please give the appearances.
Yeah.
Both of you. Yes, sorry. Mr. Nandi, you are saying something. Yes.
My lord, the last occasion, my lord was asked to submit bring plaint, copy of the plaint and petition. My lord, we applied for the certified copy in Alipur, my lord, it was not obtained. And prayed for 2 weeks' time, my lord, another.
Are you enjoying an interim order?
No interim order was there.
Why 2 weeks? More than that then? But this will not operate as stay.
No.
We'll make it, should I mention it in our order?
Plaint and
case also, the petitions that they
You
had.
could have obtained to expedite them.
No, I had it, Millet.
Plaint you have?
Yes, Millet.
Then we'll take from you.
Yes, Millet. Plaint and Millet, your lordship had
Case of
directed
miscarriage
them,
recorded.
Millet, to file the applications that they had filed in the miss case.
This
Millet.
case. So you have
Millet,
got
that
copies
also
of-
I have.
Please give copies to him today. We'll take it up tomorrow. To expedite the matter. Take out copies, give to
Very
him.
well. I have
and
only one copy. I will give a.
You take out 3 photocopies, 2 for us, 1 for him.
Very well.
Come back tomorrow.
Very well.
And give his copies today itself. Whatever copies you have.
Yes.
I'll make it day after tomorrow, my lord.
Why?
Day after tomorrow, my lord.
We'll give the copies today
Yes,
itself.
sir. I am taking up.
You take, read, and come back tomorrow.
Day after tomorrow, my lord. Make it.
Learned counsel for the appellant submits that he could not obtain the certified copies of the plaint and other miscellaneous application as directed previously by this court. Full stop. Next para, learned counsel for the respondent submits that he is equipped with photocopies of the said pleadings. Full stop. Accordingly, we request the learned advocate for the respondents to hand over copies of the available pleadings, the pleadings available with him, including the plaint and the miscellaneous application, to his counterpart appearing for the appellant during the course of the day. Full stop. The matters shall be listed next, shall be taken up next under the same heading on November 19, 2025. Day after tomorrow.
But I appear for the respondent wife.
And you appear for the appellant husband, obviously. What is the defect, Mr. Mukherjee? Have you checked up?
That was for the correction of the, your lordship granted us leave to correct the address for.
কট্টর শোনা যাচ্ছে হ্যাঁ এটা ডিফেক্ট নেই হ্যাঁ
Your lordship granted us leave. But the last order, your lordship has already, well, here is the affidavit of service, although they have appeared. This is good luck for us.
Why so many photographs have been annexed?
Yes, this is one of the photograph itself will speak. On 22nd, 2020, 22nd April, marriage was solemnized.
You have got copies of all the applications?
Yes, we have got copies of all the
And she went away around September 2022. In this context,
marriage happened when? Sorry,
22nd April 2022.
Acha, September she went.
September, that puja vacation, I
went away.
Malda.
Very well.
This is of Howrah. Right?
Then you filed a divorce suit for that.
I filed a divorce suit, and they did not appear. Even order 5 June 22 paper publication had to do. Ultimately, it was dismissed.
Ex parte dismissed. Ex parte but dismissed. Why?
Now, that was one of the
cruelty and desertion could not be. Desertion time was not there.
Naturally, not that only. Pleadings were not happy in this sense. Now, subsequently, from the Facebook, we find they exhibited some.
Yes, mother, please help him.
They displayed certain minor photographs, which will show that she is married.
Someone else,
somebody else, and the baby has
after leaving you. Or?
Yes, yes. And what happened also, this was not taken, unfortunately, for the learned advocate, when the mother went to bring her back at Malda.
Your mother?
Yes, and myself. Then we were surrounded with so many people that we were tortured, this thing, that thing, snatched our mobile telephone.
You lost even diaries also, complaints with
even they did not allow to go to the thanas.
You could come to your own thana and
yes, we then, my lord, that was not in the proper in the pleading, but everything is there.
not in the pleadings.
Anyway, now also they executed an agreement signed by us.
These are not there in the plain pleadings.
That was not.
Then,
but subsequently, in the Facebook it appeared.
That is after the decree was dismissed.
Yes.
You have filed an order 41 Rule 27.
Order 41 Rule 27.
An amendment of plaint.
Order 1 Rule 10 for we have got the name that
alleged adulterer.
Alleged husband
cannot be husband because you are still
that means subsisting during the subsistence of marriage, and order 41 was just photographs.
Unless an adulterer, he cannot be added.
Yes, that is why we have brought it an application for amendment.
Not exactly adultery. The different offenses. Can you add him, implement that person as a party?
No, in the sense, we have given that he actually living with her.
Maybe living with her, but does that make him a necessary party to your matrimonial suit?
Actually, my lord, I have brought particular adultery ground. On this ground, that already is
adultery or bigamy? Adultery ground, because he's
adultery, bigamy, whatever. Because we, my lord, kindly visualize the situation. I am at Howrah.
The photographs of
yes,
the other person.
Other person.
Where is your
even
photo?
Marriage.
We want to compare.
Even my marriage.
Your own photograph should also be here so that
Not,
we can
no,
compare
not
whether this is
that.
you or
My marriage is admitted because she's saying now also that I am wife. So if your lordship order for
some of the photographs look like your client.
No.
Your client is in court.
My client is here.
These are your client, page 10 of Can 1.
No.
T-shirt tower. Even the T-shirt is the same.
Very-
Page 10 of Can 1 and show him.
Page 10 of
Can 1.
No.
Probably there was a bona fide mistake on the part of the.
No. Certainly not. Because I have got a good photograph. Because my photograph is still not legible.
No, we rely only on the photographs.
This is the copy. This is the copy
Very
in my.
Only one thing.
Yes. Let us permit them to amend the pleadings.
I have an objection to it.
You have not married another person, so
No, I have not married.
let him go.
No, only one thing.
This is not
kindly see is the date of the ex parte decree. But the date of the ex parte decree is on 6th of November 2024. Now, over the same allegations, he had filed a complaint case before the learned.
No, you have not married another person.
No.
So who is this?
But I do not know from where has he got these photographs. I have not even put it on Facebook. And
this lady is not your client.
A lady is my client, but this gentleman, I do not know. Now, kindly look at the provisions of Order 41, Rule 27 once. Well, he had knowledge of everything when the suit was pending.
Exercise Order 41, Rule 27 BB. Although BB sounds very cliche, but here
he had knowledge of everything, every aspect of it when the suit was pending.
Come to page 11 of, come on, come to page 11 of Can 4. We are sufficiently
Please document these.
Come to page 11 of Can 4. Please see for yourself. She doesn't know him. If you say these are morphed, then we'll permit him to lead evidence on this.
But kindly, permits him to lead.
We'll remand the matter. We'll allow the order for 27.
One more thing.
Allow the amendment application.
One more thing. He is asking for divorce. Now, I have spoken to my client. Now, my lord, if it can be settled, lordship can send it for mediation.
Mediation, if it is agreed, we are ready to, my lord.
But because the marriage has broken down irretrievably, my lord, as on
it can only done through the route of mediation.
Yes.
Because otherwise,
the marriage has broken down.
Section 13 will come in.
At least some of
the mediation route you can agree.
Yes, your lordship made some observations.
We'll just
kindly, your lordship has already given in the last.
The specific allegations made in the present applications, comma inter alia for addition or for production of additional evidence, comma is that the photographs annexed to the said applications show beyond doubt that the respondent wife has married a third party. Next para. In view of such explicit photographs, comma, it is submitted, comma, the additional pleadings in that regard, as well as the photographic and other evidence to support such contention be permitted to be brought on record as additional evidence. Next para. Learned counsel for the respondent opposes the allegations made in the applications as well as the prayers. Next para. However, comma, in principle, comma, it is submitted on behalf of the respondent that the respondent is agreeable to the matter being mediated and some solution to be arrived at by such mode.
As the marriage has irretrievably broken down.
As the marriage has irretrievably broken down. Next para. In such view of the matter, comma, we direct the matter to be sent to the. We send the matter to be mediated to the Calcutta High Court Mediation Committee. Let the file be immediately sent to the said committee for exploring the avenue of mediation.
And matter to be, my lord, if it fails.
In the leave is granted to the parties to mention the matter for enlistment in the event mediation fails.
May I say something? This lady, my lord, lives in Malda. if your lordship kindly directs the mediation center to give me at least 7 days advance notice, because what the mediation center does is they send the notice day before, just a day prior to it.
Mr. Das, that has to be resolved by the committee. We cannot do that, but if that is done, you can always appear and
Now
say that.
communication is very fast. Anybody
Mediation
can
is
do
not
it.
adversarial.
Like,
So
but only thing
you
is,
can
she
send
wants to
anybody and
appear,
say that.
she has to travel all the way from Malda. If an advance notice
How
of
long
7
does it
days
take
can
from
be
Malda? Will you require a passport to come from Malda? Oh, the people are coming every day from Malda. Take Mr. Ray's advice and do.
Lord, I appear in this matter for the husband respondent.
Acha.
Lord, mediation before the Supreme Court is in progress.
Lordship, I led by Mr. Shottam Mukherjee is engaged in
Mr.
Shottam Mukherjee.
Oh, say that.
Ji page short pass over.
Why short password? Mediation is going on before the Supreme
And date
Court.
is fixed on 12th December before the Honorable Bench. Kindly have a look.
No, it's Learned Senior Counsel appearing for the respondent wife, respondent husband, submits that an exercise of mediation is going on before the Supreme Court Mediation Council, and the next date fixed is 12th.
Mediation date is 22nd November, and bench has fixed the matter on 12th December.
The next date of mediation fixed is December 22, 2020.
22nd November.
Sorry, November 22, 2025. First of next para. Accordingly, let the matter stand adjourned and be listed in the monthly list of December 2025. No, or we should put it after that.
January.
Adjourned till and be listed next in the monthly list of January 2026.
I appear for the petitioner.
Yes, mediation council, Supreme Court.
The application is not with regard to the mediation, but this is separate. May I just place the application, madam? I'm sorry, I'm just running from the court number 30.
Application for
providing basic amenities that has been denied.
No, you can take mediation and
no, my lord, we have in the mediation.
You make all the prayers before the mediation.
No, my lord, may I just for once we in the mediation, my lord, we have put in those facts. The
We would
mediator
not frustrate the mediation process by passing.
No, the mediator has directly instructed us to take out an appropriate application before this court.
Was that?
No, that is not in orders because the mediation order has not is finalized.
Appear in the monthly list of December 2025. Bring some order from the mediator.
My lord, in the meantime, my lord, I'm without electricity. This is our daughter, my lord. My lord,
electricity.
No, yes, my lord, that is only. My lord, kindly grants me 2 minutes of time. I'll show 2 annexes, my lord.
So, please take a seat in this. Yes.
My lord, kindly comes to page.
Page
number 11 for once.
Can 3.
Can 3. Can 1 and 2 disposed of.
Yes.
Page 11, my lord, will
this
find.
Is your appeal against a divorce decree.
Ex parte divorce decree. My lord. My lord, kindly keeps in mind, my lord, I am still in the matrimonial home.
With his parents?
With his parents and other family members. The husband resides where he teaches. He's a school teacher. He resides there in a separate accommodation. My lord, kindly, page 11, para 4. After passing of the ex parte decree, I was served with a notice for eviction from the matrimonial home.
In connection with the different, so the suit was instituted for that.
No suit. My lord, that is the order. My lord, I will find from page 12, para 6. From my lord, passed an order injuncting them from taking any effect with regard to that notice. Very well. My lord, after that, my lord kindly comes to, these are the Supreme Court orders I have annexed, my lord, in the meantime. Now, my lord kindly comes to page 20. What has happened, my lord, during the puja vacation, the husband came back to the matrimonial home. And this is what he did. Disconnected air condition, disconnected the bathroom light, disconnected the one of the 2 main lights of the bedroom, and the daughter is studying.
No, his family members are also residing there.
Only with regard to my room. And he has written down Onumoti chhara electrical kaj kora jabe na. And we have brought
whitewash it and engage somebody and
we have. He was rather thrown out.
Then
that's all I'm praying, my lord, with regard to only electricity. Water I can.
Has been thrown out, what remains? You have whitewashed this. You said yes. You add that you have thrown him out. And now
not thrown him out, not thrown him out. The electrician.
Electrician has
was
been
thrown out, rather.
Poor electrician. By him. He's not living there. How can he throw out the electrician?
No. By Lord, I said
bring him back.
During vacation, he came back to the house, and this is what he has done.
You are living there. You are living there
with a daughter.
With daughter, with whoever. He is not living there. He is residing elsewhere. That was your first sentence before us.
But he came back during vacation. That is his house. He came.
Have it restored again. How do you need a? Why do you need a
There
court
are,
order for
his
that?
parents are there and his other family member.
They are not restricting you.
They are. That is the premise, my lord. That is the
What
premise.
sort of an
Otherwise,
order do you want?
I only want an order. My lord, kindly comes to the order prayer, my lord.
Prayer, yes.
Page 8. This is quite peculiar. I understand, my lord, but still,
He is not living there. He is thrown out the
no, he
electrician. and all
comes
this.
on the weekends.
Whenever the electrician comes, he also comes and throws him away.
No, my lord, on the weekends he comes back to the home. On the
So
weekdays,
do
he
it on a
teaches.
weekday. Every weekend he will come and throw away the
Next weekend, I'll bring another electrician. I'll have to bring another electrician.
What
this
sort of
can't
order?
be.
We cannot implement these orders.
No, my
We
lord,
have to
kindly
post a policeman there.
No, my lord, kindly. That is his insurance. My lord, kindly sees the
See, we
prayer.
cannot pass orders of injunction which cannot be implemented.
But
That
this is another way of evicting me.
to ensure proper amenities. How do you ensure this? This is a vague injunction, sir. Just have your electricity restored.
My lord, I attempted that. That was rather refuted by the husband. That is the whole premise.
This is self-contradictory. He's not living there.
He's, my lord, I have stated. Kindly comes to paragraph number. One moment, my lord. Yes.
Do you want an injunction? This is councillor peculiar to ensure proper amenities be given. We cannot ensure anything like that.
But injunct him from disturbing my.
Injunct him from disturbing your possession along with user of the amenities.
That much. Kindly see paragraph 12. I've explained how this is culminated.
Mr. Rai, what do you say to this?
Lord, in that case, Lord, my instruction is very specific. Nothing has been done. What has been submitted
We'll
by my
record that and we'll pass the injunction nonetheless.
Only one thing, Lord. Since mediation is in progress, Lord, let him take all the pleas before.
Mediator does not have the power to pass an order. Toothless.
I understand, but
unless it's written down signed by both parties.
I understand, Lord.
Because the relevant provisions of the Mediation Act have not come into force.
But the matter is also fixed before the honorable bench, before the Supreme Court. Let him take all these pleas.
Supreme Court for the limited purpose of mediation only. This
Alimony
monitoring the mediation.
No.
What is pending before?
Alimony pendentility. That much.
That's correct, Lord. Your Lordship's order.
Alimony pendentility has been challenged by either of you.
Yes.
Him.
Whoever. I mean, but that is pending. That's on a different point.
No. The Supreme Court, Lord, while Lord granting Lord interim protection to the husband, Lord sent the matter to mediation.
Interim protection means from paying alimony.
From paying 40,000 was granted.
To an extent,
yes. So that has been reduced. Now, thing
that's
is,
on a different footing, Mr. Rai. It has nothing to do with this is a fresh cause of action.
But in that case, Lord, I would, since my instruction is different, what is being submitted by him, well, let me use an affidavit, Lord, in that case.
But till then, we'll pass ad interim injunction. You cannot disturb his enjoyment of electricity and his essential.
That is incorrect statement. If your Lordship passes such
it's
order,
incorrect, if it's
Lord, let me disclose what is Lord.
Disclose, but Mr. Rai, you can. Why are you shying away from the injunction then? If you're not doing it.
No, Lord,
it's not a stigma. It's not a stigma that you carry throughout your life or something.
No, that's correct. But Lord,
we are just injuncting
the submissions.
If you are already not doing that, Mr. Rai, your client is not doing that, then what is the harm?
Then the question of passing order does not arise.
Will you use an affidavit in opposition? This is or no, we have to go by this as sacrosanct. That is the principle of injunction, you know, Mr. Rai.
I understand, Lord.
At this stage, we have this only before us, which is on oath. So we go by this and pass an interim injunction. You file your opposition. We'll keep this pending. And we'll say categorically that this has nothing to do with the mediation and that will go on in its own momentum.
Lord, if the submissions, Lord, are found to be incorrect,
Lord, vacate the injunction, lift the injunction, dismiss the application.
Because that is my specific.
This is not a mandatory order we are passing against you, which could not be reversed. No, this is a prohibitory order. So we'll just dismiss the application if you fail to convince us otherwise.
I leave it up to you, Lord.
You just dismiss the application. The present application is for injunction, which has been filed by the appellant wife in an appeal preferred against a divorce decree obtained ex parte by the respondent husband. It was ex parte.
Yes.
Next para, learned counsel appealing for the petitioner submits that although the parties are in the process of mediation as per direction of the Honorable Supreme Court, the respondent husband is disrupting the electricity connection and essential services at the matrimonial premises of the petitioner, where the petitioner is still residing with her in-laws. It is submitted that although the husband resides elsewhere, he occasionally comes and ensures that the electricity connection and other facilities are disconnected. Push up. Certain photographs annexed to the application are also relied on, which apparently indicate literally a writing on the wall by the respondent husband, giving away that without permission, no electrical work can be done at the premises. Full it is submitted by learned counsel for the petitioner wife that due to such writing and the action of the husband, the petitioner, living at the said premises with her daughter, minor daughter, Mr.
Minor daughter,
minor daughter, is suffering from lack of essential amenities necessary for daily life. Who's the next para? Such contentions are seriously controverted by learned senior counsel appearing for the respondent husband. Full stop. Learned senior counsel contends that in connection with a special petition filed against an alimony order passed by this court, which is now pending before the Honorable Supreme Court, the Honorable Supreme Court has sent the matter for mediation, and the next date of mediation is fixed on November 22, 2025. Fusaf, it is submitted that during the pendency of mediation, the said process ought not to be disrupted by interference in any manner by the court, particularly since the Honorable Supreme Court is in season of the matter. Fusaf, next para. Having heard learned counsel for the parties, we find that the prayers made in the present application have no direct connection with the matters which is sub judice before the Honorable Supreme Court. The SLP filed before the Supreme Court by the respondent husband is against an order of alimony passed by this court, and the scope of consideration therein is such order. Next para. The cause of action pleaded in the present application is a fresh cause of action and on a different footing, inasmuch as the appellant wife contends that her essential services are being disrupted by the respondent husband, thereby virtually seeking to oust the appellant petitioner from the premises, where she is residing with her minor daughter. Next para. Unless and until an affidavit in opposition is filed by the respondent husband, it is the well-settled principle of law that the court has to proceed on the averments made in the injunction application on oath as sacrosanct. Next para. Hence, we find sufficient material from the averments made in the application to grant an ad interim injunction against the respondent husband. Next para. Hence, we restrain the respondent / opposite party from disrupting or disconnecting the essential amenities to the premises where the petitioner is residing with her minor daughter, including electricity, water and other facilities, till disposal of the application. Next para. On the prayer of learned senior counsel for the respondent, the respondent husband is directed to file affidavit in opposition within a fortnight, Mr. Opposition?
3 weeks.
3 weeks. Within 3 weeks. Reply, if any, shall be filed within 1 week thereafter. The matter shall next be listed on December 15, 2025. Next para. It is made clear that nothing in this order shall in any way affect the ongoing mediation process between the parties. This order has been passed only on an ad hoc basis to afford immediate protection to the petitioner on the basis of the averments made in the application, subject to the final outcome of the said application. Thus, the parties would be at liberty to proceed with the ongoing process of mediation before the mediation council without being prejudiced in any manner by any of the observations made here.
I'm extremely grateful.
One thing. I understand the winter is coming, but let the word air conditioner be included in the basic amenities. My lord, he'll say that the air condition is not mentioned there, so I will not allow. My lord, kindly that much.
I'm grateful.
I'm grateful, my lord.
Thank you. শিবাজি দিয়ে দেবেন শিবাজি
I'm for the appellant wife, your lordship.
Respondent husband, petitioner for the suit for divorce.
It has been said. Your lordship, this is from a decree of divorce, wherein curiously the wife wanted to reside with the husband. This was on application of the husband. The matrimonial suit was instituted. The wife wanted to restitute the conjugal rights. Despite that, the learned court took no inquiry or no effort to try to sustain the marriage, firstly. Second of all, your lordship.
Why is that peculiar? He filed a divorce suit, he succeeded on the grounds, got a divorce.
Let me narrate the facts to your lordship first. Your lordship, the facts were
The
that
divorce was granted on which ground?
on desertion.
Only on desertion,
Desertion
not
and cruelty.
Yes.
Principally on desertion, and the desertion was said to take place from.
Have you remarried? We are granting injunction restricting him from remarriage.
But only one direction may I seek, my lord. The court has gone extensively into the matter, my lord, and my lord, may I seek, my lord, the lower court records be put in by my client and my lord.
In any event, you have to pay otherwise, even if she does it. If she asks for alimony, that will
My
be
lord, let
covered.
the appeal be expedited, my lord.
You will do it, everything.
I'll do it.
Special
Everything.
messenger cost, paper
The
book.
informal paper books, everything, my lord. I'll do.
Grateful, your lordship.
Although the present application arises out of has been filed in connection with an appeal arising out of a divorce decree obtained by the respondent husband against the appellant wife. First of next para, since questions of fact as well as law are involved in the first appeal, a prima facie case has been made out for grant of interim orders. Full stop. Since the impugned decree is in the nature of a judgment in rem, we do not intend to pass an order of a blanket stay of operation of the decree, which would have larger ramifications. Full stop. However, we mold the relief made in the injunction, made in the stay application, and grant injunction restraining the respondent husband from contracting any remarriage during pendency of the appeal. Full stop. Can 1 of 2025 is accordingly allowed, dispose of on contest. Since no affidavits have been invited, it is deemed that none of the allegations made in the application are admitted by the respondent husband. Full stop. Next para. On the prayer of the respondent, the trial court record shall be brought by special messenger at the cost of the respondent, to be deposited by the respondent within a week from date. Full stop. The respondent shall thereafter prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the respondent. Full stop. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with, and it is deemed that the appeal is ready as regards service. Full stop. Next para. For the above purpose, for the purpose of preparation of paper books, the department shall serve notice of arrival of the trial court records on the learned advocate for the appellant as well as on the learned advocate on record for the respondent.
Liberty
to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
I'm for the appeal.
Yes.
Lordship, I'm appearing on behalf of the respondent. I'm praying for not today.
No, why?
Lordship, the
You do matters independently. Why?
Lordship, the advocate on record for the respondent is not present today.
You are present, we'll hear you.
Lordship, I am not versed with the matter, neither do I work with him. Earlier this morning, he called me to.
He has not come to court.
He's not well. Any date may be fixed. Tomorrow.
Tomorrow we are keeping it. Mr. Boral. On the prayer of the respondent, but you have to give your name first.
Okay.
On the prayer of the respondent, let the matter stand adjourned for the day.
Wednesday,
On the prayer of the respondent, let the matter stand adjourned and be listed next on November 19, 2025. Yes.
Number 28.
My lord, I am for the appellant, my lord. In this matter, my lord, this is the affidavit of service, my lord. I have served all the application with memorandum, my lord. There is a delay of 22 days, my lord. I have in Can 3, my lord, it is stated.
What is the reason for the delay?
My lord, I have stated from paragraph 4 onwards, my lord.
Tell us, what is the reason?
My lord, first of all, my lord, the petitioner that on 5th April 2025 came to know about the judgment and decree passed, my lord. Thereafter, my lord.
Expertise?
No, my lord.
Then?
My lord, the order has been passed on 26th
March.
Thereafter, my lord, the petitioner has, the appellant has come to know about the order
On 5th
on
March.
5th
5th
April, my lord.
Yes.
Thereafter, my lord, on 7th April, my lord, requisite has been filed for the certified copy, my lord. And my lord, on 13/5/2015, this requisite stamp has been paid, and 24/5, the certified copy judgment has been ready. But my lord, that has been collected by the appellant later on, my lord, because of his illness and his wife illness, my lord.
Where have you stated about the illness?
My lord, in
Statement
paragraph 6, my lord, the certified copy of the judgment and decree was received by the learned advocate of the petitioner.
What about the other defect?
Only, my lord, the delay, my lord.
Classification of appeal furnished in words is erroneous. You have stated in your memo, memorandum of appeal from the judgment and decree. It will be memorandum of appeal from original decree. Correct that during the right now?
My lord, and my lord.
From original decree, not the judgment and decree. From original decree. Do it right now. Yes, what about we are along this?
My lord, there is a application.
Wait, one by one. The learned advocate and record for the appellant is granted leave to correct the memorandum of appeal by introducing the correct classification of the appeal. Do it in both the judges' copies.
My lord.
What will you write?
Original decree.
Memorandum of appeal from original.
Original.
Yes. You will do that during the course of the day.
My lord.
Next para. Can 3 of 2025 is an application for condonation of delay of about 22 days in preparing the appeal. Upon hearing learned counsel for the parties and perusal of the averments therein, we find that sufficient explanation has been furnished for the delay. Accordingly, can 3 of 2025 is allowed, thereby condoning the delay in preparing FAT 278 of 2025. The appeal is deemed to stand registered and admitted. What is can 2 and 1?
My lord, can 1 is the, my lord, application under order 41 rule 27(1), my lord. My lord, the suit has been filed, my lord.
Order 41 rule 27, in any event, we cannot decide now. We'll direct it to be heard along with the appeal. We'll direct you to file your opposition.
But I shall file affidavit in opposition.
Yes, definitely. Can 1 of 2025 is an application for production of additional evidence in the nature of 1 under order 41 rule 27 of the Code of Civil Procedure, and comma by its very nature, comma is required to be heard along with the appeal. Accordingly, can 1 of 2025 shall be heard along with the appeal. Affidavits, if any, shall be exchanged by the parties in the meantime. What is can 2 and what is the appeal about?
My lord, can 2 is, my lord, for this stay, my lord.
This is against what degree?
Eviction.
You have got an eviction decree.
My lord, recovery of possession. My lord, it is very peculiar case.
Why?
But what has happened, my lord? The appellant, my lord,
yes,
on the one hand claim that he is the owner by adverse possession, and on the other hand, this application is filed that another co-owner, one document has been recovered in the drawer of late Manas Mitra, where it is said that in the year 2005, Ujjwal Mitra, one of the co-sharer, gave him permission to stay over there. Admittedly, he is a permissive
occupier.
Permissive possessor, my lord. And my lord, this is the
Permissive
undivided
occupier,
property,
kindly
my
see
lord.
the judgment, my
That
lord.
point
There
has
is no
been
error,
taken in
no
the court
mistake
below,
in
my
the
lord.
judgment, my lord.
And my lord, this document.
He was a licensed.
My lord, the document.
Wait, Mr. Karan, please take your seat. We'll just hear him. Yes. Yes, what do you say? First of all, contradictory plea of adverse possession and license.
My lord, admittedly.
Even if you go by license, then also he's entitled to get an eviction decree.
No, my lord. Kindly see, this is a undivided property. The property admittedly of Shobhan Gini Dashi.
You cannot say that any of the co-owners
No,
can sue
that is their plea, my lord.
You cannot take that as a defense. Even one of the co-owners can file a suit for
my lord,
eviction.
their co-owners has not been made party to the proceeding, my lord.
Not be there.
And my lord, if the co-owners, my lord, permit me to his possession, my lord, to stay there, my lord, I have been evicted from the premises.
How did you prove your license?
My lord, this is admitted fact. They have admitted.
Who have admitted? They have admitted nothing.
My lord, they have admitted in their plaint, my lord. In their plaint, my lord.
Show us. Plaint has been annexed.
My lord.
Show us, please.
My lord, our claim is that on the death of the Manush Mitra and
No,
Purnima
let us see. Let him complete.
Yes, ma'am.
Yes.
My lord, that the Somangini Devi, wife of the
Where are you reading? Which page?
My lord, page 10, my lord.
Of which can?
Can 2, my lord.
Yes. So,
Well, that one, paragraph 1, my lord. That one, Sobangini Devi, wife of Mohan Chandra Mitra, was the absolute owner of the premises number 22 Jugal Kishore Das Lane, Kolkata 6, PS Amar Street. She died intestate in year 1939, and after his death, the property devolved her 3 sons, namely Ramendranath Mitra, Naresh Chandra Mitra, Paresh Chandra Mitra, and the estate of her elder son Khagendranath Mitra, who died in the year 1938, that is before his mother's death. Subsequently, the names of the Ramendranath Mitra, Naresh Chandra Mitra, Paresh Chandra Mitra, and the estate Khagendranath Mitra were mutated in the role of Registrar of the Kolkata Municipal Corporation along with their mother's name. But at present, all the above noted persons died intestate. It is to be mentioned that the plaintiff number 1, Preeti Bose, is the daughter of Paresh Chandra Mitra, and plaintiff number 2, Moumita Ghosh, and Orpita
yes,
Basu.
they have stated in para 4 that Manush Mitra and Purnima Mitra died. On that death, the tenancy the license has come to an end, right? It's not
My
heritable.
lord, if the other co-owners of the property,
License is not heritable.
but my lord, the
licensee relationship finishes with the death.
My lord, kindly see, the appellant was admitted to inducted to the property by the
2 persons
father
who are deceased now.
father of the Manush Chandra Mitra, because he was working on their place, my lord.
No, in his evidence,
My
he
lord, I have
admitted
stated, my lord, in my written
Or
statement,
if you
my lord.
continue like this, we'll grant stay and just put it at that. There's a limit to everything.
I am extremely sorry, my lord.
My lord, I have stated in my written statement, my lord.
What is your written statement case? Let us see. We hope you have not denied that paragraph where he has stated that you are inducted a license.
My lord. My lord, I have stated, my lord.
You could not have stated my lord.
My
What
lord.
you have stated, we are reading. Yes. Oh, very good. Where is your written statement?
My lord, that start at page 42.
Right.
No, written statement and written statement at my lord, page 30, my lord. My lord, this is the specific case, my lord. The instant suit is bad for non-joinder and misjoinder of party with regard to the statement made in paragraph number 1 of the plaint 7, except the matter record of the defendant denies and disputed, raise the defendant further state that the Shubhangini Dashi since disease was the sole and absolute owner of the premises such and Shubhangini Dashi died behind 4 sons, namely Khagendranath Mitra, Ramendranath Mitra, Naresh Mitra, and Paresh Mitra. As her heirs and legal representative, the said Khagendranath Mitra died leaving behind 3 sons, Goni Mitra, Ambika Mitra, Amit Mitra, and 4 daughters, namely Shoilo Mitra, Chaya Mitra, Maya Mitra, and Mala Mitra, as his legal heirs as representative. These Ramendranath Mitra died leaving behind 2 sons, Ashit Mitra, Ashok Mitra, and 3 daughters, namely Bimala Mitra, Kamala Mitra, and Promila Mitra, as his heirs and legal representative. The said Ajit Mitra died leaving behind of Ujjwal Mitra as his heir and legal representative. Said Naresh Mitra died leaving him 2 sons, Sunil Mitra and Shubir Mitra, and 2 daughters, Meera Mitra and Reba Mitra, as his heirs and legal representative. The said Paresh Mitra died leaving behind 2 sons, Mukul Mitra and Manush Mitra, and 7 daughters, namely Dolly Mitra, Lily Mojumdar, Priti Bose, Bithi Bhattacharjee, Geeti Ghosh, Purnima Mitra, and Shefali Shaha as his legal heirs and representative. With regard to the statement in paragraph number 2 of the plaint, 7 except matter of the record, the defendant denies and dispute and the rest of the plaintiff to stick proof thereof. With regard to the statement in paragraph 3 of the plaint, the 7 except matter of record, defendant denies and dispute rest of the plaintiff stick proof. The defendant further submit that the Paresh Chandra Mitra had one office cum factory act.
In paragraph 12, we have claimed adverse possession. Adverse possession means you have to deny the title, you have to admit the title of the true owner.
My lord, kindly see, my lord. Actually,
How
my
can
lord,
you be an adverse possessor and a license?
my lord,
in
that
the
is
same-
that is the wrong advice of the learned advocate.
mutually exclusive pleadings.
No, my lord, that pleading has been made, my lord. The Forester, kindly see paragraph 7.
That wrong advice has ensured that
My
you've
lord,
been in
kindly see
possession.
paragraph
That
7.
wrong advice has ensured that you have been in possession for more than 6 years. I mean, from the suit even.
My lord, kindly see paragraph 7, my lord, once.
We have seen paragraph 7. That is
My lord,
contradicted with
actually, my lord, Paresh Chandra Mitra inducted, my lord. The appellant was
what cannot go with license.
my lord, in the judgment also, my lord, that has been stated that no evidence has been come from the other co-owners. That's why, my lord, the licensee can be evicted from the premises. My lord, since, my lord, more than 40 years, my lord, he is residing because the, my lord, he is working in their factory.
You had to show that any of the other co-owners are opposing the eviction.
My lord, that's why, my lord, I have filed the application for under Order 41 Rule 20.
What have you sought to introduce there?
My lord, there is a co-owners there is a declaration that if, my lord, the appellant stays in the premises, he has no objection,
Why
my
could
lord.
you produce it during pendency of the suit?
No, my lord, that is not with me. My lord, I have stated in annex can 1, my lord. Paragraph 6, my lord.
That is entirely contradictory to your case. It's a
No,
new
my
case.
lord, I have stated, my lord,
What
that Paresh Chandra Mitra inducted me, and my lord, kindly see.
That declaration is by Paresh Chandra Mitra.
Paresh Chandra Mitra, thereafter Manush Mitra and Purnima Mitra, they are the son and daughter. And Ujjwal Mitra is the other co-owners. My lord, in the past, my lord, so far my instruction, there is a quarrel between the co-owners of the property. At that time, my lord,
Could have brought one of the co-owners who inducted you.
That's why, my lord.
No.
That's why, my
as
lord.
Witness.
My lord,
As
that is the
witness.
case, my lord. My lord, the document has
Please
found.
stop your my lords for a minute. Let us ask the question. Why
My
did
lord.
you bring one of the co-owners who is supporting you as witness?
My lord.
That is also my lord.
No, that's
that
why.
be my lord. The
My
witness
lord,
is not my
no,
lord.
my lord. There was a witness, my lord, but due to her old age, my lord, she cannot come and deny it. And my lord, after the passing of the judgment, that document has been found from the drawer of the Manush Mitra, my lord. Kindly see.
Return it to the drawer. You don't have a case.
My
Adverse
lord,
person along with license.
my lord, kindly see
license.
page 3, paragraph 6, once, my lord, of annexure 1, my lord.
We will consider but not grant stay. We don't find any prima facie case. We are not dismissing the appeal. This is a first.
My lord, there is a execution case, my lord, filed.
You will file 144 and come back if you win the appeal. There is no prima facie case.
My lord, then my lord,
If
my
you
lord,
could, you dismiss the appeal under Order 14 Rule 11, but we don't do that because it's a first appeal. Yes.
My lord, this is the document, my lord. I have
the custom of our court. It's not
my
done.
lord, this is the document, my lord, the Xerox copy, my lord.
What? My lord, in examination in chief, my lord, what they have said.
My lord, that document has been received from the.
What is the original?
Original is lying with the.
In the drawer.
No, lying with the appellant, my lord.
Anybody could write that. This.
My lord, the signature is, my lord.
Not
my lord, signature can be verified, and the part.
And now another reopening of the entire
My lord,
signature verified, handwriting.
My lord, the person can be called for, my lord, for testimony.
He's alive.
He is alive, my
lord. Here, Ujjwal Mitra, he is claiming that Ujjwal Mitra has given him permission. Kindly see, my lord, I am sorry. I have.
You also have another handwriting.
No, my lord. In examination in chief,
What has he said?
What I am reading, my lord, if you lordship give permission.
Yes.
My lord. After death of Paresh Chandra Mitra, his son Manas Mitra and daughter Purnima Mitra allowed the defendant to reside at 22 Jugal Kishore Lane, the said Manas Mitra and Purnima Mitra used to reside at the said premises with the defendant. After the death of Manas Mitra and Purnima Mitra, their another sister Lily Majumdar, who is a co-owner of the suit premises, allowed the defendant to reside at 22 Jugal Kishore Das Lane, Kolkata 6. But in this application for production of additional evidence, he is claiming that Ujjwal Mitra has given him permission. Here in examination in chief, he is claiming that one Lily Majumdar has given him permission.
My lord, knowledge about this document.
You did not have any knowledge that Ujjwal Mitra has given you permission to?
My lord, that document is, my lord, I am found out after the judgment passing, my lord.
You were given the license by Ujjwal Mitra?
No, my lord. My lord, in the past, I have asked that question. So far my instruction in the sometime past, there is a quarrel between the my lord co-owners. At that point of time, my lord, the Manas Mitra may have taken from the.
You have never pleaded that Ujjwal Mitra.
My lord, I have no knowledge about that, my lord, at that point of time.
If Ujjwal Mitra gave you license by way of writing, you wouldn't have knowledge.
My lord, that is with the Manas Mitra drawer, my lord.
He would write it and put it in Manas Mitra's drawer.
At that time, Manas Mitra may have been taken, my lord. I have, my lord,
the present appeal has been preferred against an eviction decree. Full stop. Upon hearing learned counsel for the parties, we do not find any prima facie case for grant of stay having been made out. Full stop. Apart from the fact that mutually exclusive pleas of adverse possession on the one hand and licensee on the other were pleaded by the defendant stroke appellant, the defendant stroke appellant now seeks to introduce a document which is allegedly a writing by one Ujjwal Mitra, one of the co-owners of the premises, which is entirely beyond the pleadings in the written statement. Full stop. That apart, the learned trial judge proceeded on the premise that the defendant could not claim adverse possession and license in the same breath, full stop, even in respect of permissive occupation, the learned trial judge observed in the impugned judgment that no proof of grant of license has been produced by the appellant. Full stop. Next para. In view of the above, we do not find any justification of passing any stay order. Full stop. Accordingly, Can 2 of 2025 is dismissed on contest without any orders to cost. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. In view of appearance of the respondent you are for which of the respondents? Only respondent?
My lord, no, 3 respondent, my lord. There is no ground made out, my lord. Kindly see the memorandum of appeal, my lord.
You are appealing for which of the respondents?
1, 2, 3.
All. In view of the appearance of the respondents through their learned advocate, service of notice of the appeal on the respondents is dispensed with. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Next.
Your Lordship, I am appearing.
Yes. Yes,
But I am
Mr. Mitra.
appearing for the appellant. I have served on the last occasion, my learned friend appear. I have served the copies of the Section 5 memorandum of appeal along with the stay application. Now, my lord, so far Section 5 is concerned, there is a delay of 3 days. I have indicated in
view of sufficient explanation having been furnished, Can 1 of 2025 is allowed, thereby condoning the delay in preferring FA 295 of 2025. Full stop. There will be no orders to cost. The appeal is deemed to stand registered and admitted. Can 2 stay? What is the appeal against?
Yes, my lord, against the final degree in a partition suit. I am the defendant number 1 and 2. Now, 1/6 share of each of the parties.
Preliminary degree was not challenged, Mr. Mitra.
No, no.
So
Not
there is no
challenged.
doubt
Not
on
challenged. Not
that.
challenged. I must be candid before your lord.
No,
Now,
not be candid. You may.
No, no.
Yes.
1/6 share of the plaintiffs, 1/6 share of the defendants.
There's a flaw in the final degree.
But I'm coming to that.
Give in a sentence.
In a sentence, my lord, the shares are not correctly, my lord, assessed at the time of passing of the final degree, because after the preliminary degree, my lord, the defendant number 3 to 6
Allotment has not been made according
properly
to the
made,
shares.
because 3 to 6 already given their share by a consent petition to the plaintiffs.
Can it be done?
No, my lord,
Can it be a transfer of immovable property?
yes,
by consent?
and more so, I have the documents, certified copy.
Transfer of property requires a registration, registered deed.
Absolutely, absolutely. That is.
You
And
say they have given by consent. How can
my
that
lord,
be taken
my
note
lord,
of?
that is on record. And the commissioner.
Which one you are saying absolutely to what?
I'm coming
You are
to
saying
it. My lord,
contradictory
kindly give me one
If you
minute.
say absolutely to the proposition that transfer cannot be made by a writing on consent without a registered deed, if you say absolutely to that, then you don't have a case.
My lord, what I'm on, that after giving the consent petition, their share.
You cannot give a share by consent.
Absolutely, my lord, kindly hear me, my lord, for once. My
You are
lord,
doing that
that
only.
you know, that was taken account by the advocate commissioner. That point was not considered by the learned trial court. That point.
Advocate commissioner took into account that
Yes,
transfer.
yes, fifth,
What was
sixth,
that from
yes,
the advocate?
advocate commissioner, এটা দাও ওইটা বের করে দাও ভাই.
What is the report of the commissioner?
My lord, may I give the certified copy, my lord?
It should have been filed. This should be a part of the decree.
My lord, the
Final degree, it's a part of the final degree always.
yes, my lord, commissioner report, my lord. It is in the commissioner report. আরেকটা copy দেখুন. Kindly see the shares.
Report should be a part of the final degree if it is accepted.
Yes.
Anyway, give a copy to Mr. Pal also.
Which?
Which means nothing. Give it to him.
This is my copy I'm giving, my lord. I don't have.
Show us where it has been.
Yes, yes. Your lordship kindly comes to inner page 4, the last paragraph. May I please? Therefore, the total valuation of the suit properties is 69,000, 16,766 and 60 paise only, which will be allotted upon parties according to preliminary degree, having 1/6 share jointly upon the defendants, 1 and 2, and 5/6 share upon the plaintiffs and defendants number 3, 4, 5, and 6 jointly. Now, 1/6, 1/6, 1/6 was the preliminary degree. Now, it turns to 5/6 to the plaintiffs. After that, petition was filed and it was allowed by the learned trial court.
No, no, he says according to the preliminary decree.
Yes.
Preliminary degree says 1/6 share jointly.
Yes.
Upon the defendant numbers 1 and 2, 1/6 on defendant numbers 1 and 2.
Yes.
And the rest 5/6 jointly on the plaintiff and defendant numbers 3 to 6.
My lord, in the preliminary degree, subject to correction from your
That was
lordship.
not the
Not
show the preliminary
yes,
degree, please.
preliminary degree.
Yes.
Now, copy.
Nothing has been annexed, Mr.
My lord,
these are the two documents which are your grounds of appeal.
Oh, that's true, my lord.
You're handing up one copy at a time.
There will be several more documents, my lord, which I will also, my lord, want to
No,
cite.
that he has always. Kindly see. And this, your lordship got, my lord? 1/6 share. May I place the ordering portion? My lord? Ordering portion.
Wait, please.
I'm sorry.
You are who? Which
I'm 1 and 2.
plaintiff?
No, defendant.
Defendant number
1 and 2. And the sisters.
So you have been given allocated 1/6 share, which was given to you by the preliminary degree.
Yes.
So how are you bothered with what happened?
My
to
lord,
the rest?
bothered, my lord.
They can together.
My lord, these shares are controverted, my lord, because
you only have a right to 1/6 share.
Absolutely, I have 1/6 shares.
They together have 5/6, 1/6 each.
Yes, there is also contradiction.
What is the contradiction?
Yes, I'm coming to that. When the defendant number 3 to 6 have given their consent, in the consent,
So they have also been allocated the property, 3 to 6.
Yes, 3 to 6 stated that we don't want our share.
But they have been allocated shares.
That is the whole trouble, my lord. That is the whole trouble. Your lordship kindly see.
You cannot have a cause of action for that. Those defendants could say that this could not have been given effect. Our shares have not been allocated.
My lord,
How are you bothered? You
My-
get your 1/6, that is sufficient.
My lord, I'm coming to that, my lord. So far, when the consent petition was given by the defendant number 3 to 6, there was no signature of 6. That is also
Suppose
fraud.
there is no consent at all.
Yes.
Suppose there is no consent.
Yes.
Each of them should be allotted 1/6 share.
Yes, I'm
Right?
grateful. I'm grateful.
And you 1/6.
Yes.
You get your 1/6. 1/6 is allocated to you separately.
Yes.
And those people are allotted 5/6 share together.
Yes.
Now they can have a cause of action for that, not you. You don't have any local
My
standard.
lord, I have taken the grounds in appeal that, my lord,
You
after.
don't understand us.
No, I understand, my lord.
What?
What fell from your lordship,
What
that
fell
how
from
could
us?
I have grievance? Because I have been given my respective share. So I cannot have grievance
espouse their
against the
cause.
extra shares which has been.
You cannot espouse their cause.
Yes, I
They have been
understand.
given together. Let them be happy with it.
I understand that. The thing is that, my lord, after partition, it is not practically possible. In the petitioner commissioner, we have stated in our objection that, my lord, this mandatory space has not been allotted for rebuilding of the premises. That is near about 3 kata, 24 cheetahs. That has been stated.
Did you file a written objection?
Yes.
And you also cross-examine the commissioner?
Yes. Written objection, my lord, I have annexed in my stay application.
Well, we'll grant ad interim stay if you want to bring in, file an opposition. Mr. Paul, you can file your opposition. Or we can dispose of the stay application if you want.
First, my lord, what has fallen from
If
my lord.
this is implemented,
my
then
lord.
nothing remains in the appeal. There are arguable questions.
May I only say that. With respect to the other, my lord, 4 sisters, I have purchased, my lord, 2 of them shares, my lord. And my lord, my learned
Cannot
friend, my
alter
lord,
the preliminary degree in the final degree. The
yes,
commissioner cannot do that.
my lord, my learned friend cannot be, my lord, aggrieved by, my lord.
Understood, but he is saying that if total share, a chunk is allocated to all of you together, then there may be certain problems in ingress and egress and other issues.
But that, may I only say, my lord, instead of, my lord, calling for LCR and all, my lord, I believe, my lord, that can be decided on.
We'll send you to mediation then. Another fit case for mediation. Really, we are really speaking. I mean, because on principle, it has been allocated, shares have been allocated to you, you cannot have any grievance. The grievance, where is your written objection to the commissioner's report?
Yes.
Show us that.
My lord.
We cannot go beyond that also.
No, that's true. That's true. Your lordship kindly comes to my stay application. My lord, I have annexed that.
Page 21.
Yes, page 21. Possession is also wrong, my lord, which has been considered by the learned commissioner, my lord. Page 24, ground number 16. Commissioner report does not depict the correct position of the parties also. That also I have taken in my written objection.
We don't find any objection of that sort regarding common passage cannot be made and all these things. Nothing. And the only grievance is that they have been given jointly. Their choice.
No, that
they accede to that.
Well, that allocation has not properly made, my lord. At the time of rebuilding, my lord, mandatory
allocation intersave the other defendants and the plaintiffs.
Yes.
So you cannot have any objection to that.
No, when I will reconstruct as per the, my lord,
construct in your portion, your allocated portion.
my lord, that mandatory space has not been taken account.
That you have not taken that mandatory
my lord,
space.
my lord, I have stated.
Which ground?
My lord, I have stated.
Mandatory space has not been left. Which ground?
My lord, kindly see, my lord, page 24.
Yes.
Yes. First ground, my lord, for that the learned commissioner has not allocated the property according to the possession of the parties. I have stated to the suit which was shown to the learned commissioner at the time of drawing a field note and possession of the parties has
It is
also
not a
been...
mandate on the commissioner. Generally, existing possession is honored. But if you possess more than your share, why should it be honored?
My lord, I have taken the points, my lord.
No, this is not that point. You are taking out a completely different point before us. You are saying here you have taken that possession has not been honored by the commissioner. It's not an absolute proposition. possession is honored up to an extent. If you possess more than your share, why should it be honored? That's not a good ground. But you are now saying that mandatory space has not been left, this, that. Those who don't find in your objection, you cannot take a new ground in the first appeal for the first time. Sorry.
May I add one thing?
No, not now.
Very well.
Not a single ground appeals to us, Mr. Mitra. What you are saying and what is depicted in your objection are completely different. Not a single ground of
My lord, I have subject
mandatory space not being
My lord,
left.
mandatory.
Show us one ground on that. You're making it up from the bar during arguments. That is not acceptable, Mr. Mitra.
Total area of the land is also not, my lord, mentioned.
You're remembering something I'm telling. Show us from the grounds.
No. In the grounds I'm saying.
Which ground?
Page 26, my lord, your lordship kindly comes. Ground number.
Now you're fishing on grounds.
22, my lord.
22. 22 is not in page 26.
My lord, for that.
27 is in.
Yes, I'm sorry. 27. For that, the learned commissioner failed to mention the total area of land to be divisible between the parties to the suit.
22 or 27?
27.
For that, the partition commissioner has mentioned in the report directing to pay a sum of rupees 8,93,000.
No, last but 3, my lord, your lordship kindly see, my lord.
You can't read Roman numbers?
No, 32, I'm sorry, 32. For that, the learned commissioner, page 26. Page 26, your lordship kindly come.
Yes.
Page 26, your lordship.
Yes.
I'm sorry.
For
that, the learned commissioner failed to mention the total area of land to be divisible between the parties to the suit.
So this is not your ground that.
That comes, my lord.
You say mandatory space has not
been. Maybe in proper word it has not been mentioned, but
improper words also it is not mentioned.
But your lordship kindly appreciate.
This is not. This
and at the time of my lord passing of final degree, my lord, it was.
See, this is not a surreal poetry.
No.
That we'll have to read into the words and understand the spirit, and then imbibe that and give expression to that in a form of art.
I understand.
These are specific words.
Yes.
And objections are taken in specific words and letters.
Yes.
You have not taken this objection which you are now making before us. You cannot take it for the first time in an appeal, either first or second. This is our clear opinion. Show us that we are wrong, get an order.
My lord, field note and the...
You cannot have any objection as to their taking their properties jointly. They choose to do that. And they can have a grievance. If you were also put in that hotspot, then definitely would have a grievance.
I understand, but only one thing. Before a court of law, your lordship kindly appreciate one thing. Before a court of law, a petition is filed for giving consent of their shares to the plaintiffs, wherein one of the parties
their
did not
shares
sign
have
even.
not been given to the plaintiffs. You are fundamentally wrong there, Mr. Mitra.
Well,
your submission would be correct if their share was given to the plaintiffs exclusively. Their shares along with the plaintiff shares have been kept joint. That does not mean that the other defendant shares are given to the plaintiff.
And at the time of passing of the final degree, my lord, the commissioner report was not considered. Only one line order was there. That
what else would be there? The entire commissioner report will be produced.
My lord, something has to be looked into. My lord, nothing is there. Your lordship kindly sees.
They
don't appear even at the time of passing of the final degree.
Let us see the final degree.
Yes.
Final decree, the borrow judgment.
This application was rejected by an
judgment is never written in a final degree of
application.
Well, anyone there is no whisper.
Let us see.
Your lordship kindly sees. May I place?
Yes.
21st of February 25.
That you need not place. Place the order.
Yes, place the order. Plaintiff is found absent on repeated calls.
You're looking at us, please read on.
Yes, I'm learned advocate for the defendant. No, learned advocate for the defendant draws the attention of this court that the instead, I'm sorry, suit at present final degree to be passed in terms of the report of the learned partition commissioner. As a matter of fact, this is a suit for partition, which is a preliminary degree was passed on 9/4/13, where after a partition commissioner was appointed for effecting partition by meets and bounds. The record reveals that the learned partition commissioner already filed his report on such and such. It further appears to the court that learned partition commissioner was examined and cross-examined in full and discharged by an order dated 7 February 23. Thereafter, upon hearing argument of both sides, this court finds his order dated 594 has accepted the report of the learned partition commissioner.
Where is the order dated 5th of September?
5th of September order.
You have made it a ground in ground 5 of your memo. You have not annexed that.
This is what I wanted.
You go.
I'm sorry, my lord. I have only one copy, my lord. Sometime before only I got the visit, my lord.
Only one thing. Did not argue on the grounds of objection. I think. This is why we understand now why you have not annexed.
No. That is
That was not
You
challenged.
will understand when you see the second paragraph. Read
at
that
the time of hearing of the learned advocates for the defendants number 1 and 2. Argued only on the point that joint allotment made in favor of plaintiff and defendant number 3 to 6 is not correct. He did not argue on the other grounds of objection as has been enumerated in his objection. On perusal of materials in record, it appears to this court that by filing written statement, defendant number 3 to 6 admitted the contention of the plaintiff as described in the plaint. Learned advocate for the plaintiffs point out that defendant number 3 also filed an affidavit on behalf of 3 to 6, thereby suggesting that the allocation may be granted jointly in favor of plaintiff and defendant number 3 to 6. On the other hand, defendant number 1 and 2 had filed adjournment application during the commission work on 7 consecutive dates. In respect of allotment of shares in respect of plaintiff and defendant number 3 to 6, jointly these courts finds no valid ground of objection as no specific reason has been put forth by the defendant number 1 and 2 in this respect. Evasive objection without specifying the reason is not acceptable.
So I have not taken these objections at all. No space.
My lord, we have elaborately cross-examined the partition commissioner.
The cross-examination. Kindly cease. Nothing. My lord will not fund anything as such, my lord. A very short, my lord. My lord will not get anything, my lord, to such effect, my lord.
My lord, your lordship kindly consider whether the after final degree, whether the partition is practicable or not.
No stay. You have extra copies of this, so you have to retain copies. What can we do then?
I'll give a copy.
Submit during the course of the day.
Yes, within some time.
The day is not left much of the day.
Within some time.
My lord, only one submission. One submission.
You have made sufficient submissions. We have heard you for so long.
My lord, already, my lord, the plaintiffs are approaching so far the suit premises is concerned.
You have not asked for any injunction. You are asking for a stay.
Stay,
You
yes.
have not
I have
made any
yes,
allegation. They are
that-
approaching.
no,
They are-
That's
If they approach, then make an application.
Yes,
For injunction.
grateful, ma'am. Grateful.
The present appeal has been preferred against the final degree of partition. Full stop. Next para. For perusal of the court, comma, copies of the commissioner's report, comma, the written objection thereto filed by the present appellant. Present appellants within bracket defendant numbers 1 and 2 in the suit bracket closed, and the cross-examination of the commissioner are handed over by learned counsel for the parties. For sub next para, we find therefrom and from the arguments made before us, as well as the grounds taken in the appeal, that the primary contention in the appeal is that the partition commissioner's report, comma, which was accepted by dint of the final decree impugned before us, comma, allocated joint shares to the plaintiffs and the other defendants than the present appellants, whereas in terms of the preliminary decree, comma, separate 1/6 shares were given to each of the parties. For sub next para, however, comma, we do not find any prima facie case for grant of stay on such flimsy basis. For sub next para, even if separate shares were allocated to the other parties than the present defendant numbers 1 and 2, comma, if such parties, comma, at the time of allocation by the partition commissioner's report, comma, agreed to retain jointness of their position, comma, it cannot furnish any cause of action or grievance for the defendant numbers 1 and 2 stroke appellants to prefer the appeal. Full stop. Para, we could have still understood if the defendant numbers 1 and 2 were jointly allocated shares with others. Full stop. However, comma, the defendant numbers 1 and 2 stroke appellants, comma, exactly in terms of the preliminary decree, comma, have been allocated their separate share by the partition commissioner's report. Full stop. Thus, comma, prima facie, comma, it is not the lookout of the appellants as to how the rest of the parties choose to retain the jointness interstate with regard to their separate shares. Full stop. Next para. As such, comma, there is no scope of passing any order of stay. Hence, can 2 of 2025 is dismissed on contest without any orders to costs. Full stop. Next para. In view of the appearance of the plaintiff stroke respondent number 1 through his learned advocate, comma, service of notice on the said respondent is dispensed with, full stop. The appellants shall put in postal costs and requisite for service of notice on the pro forma respondent numbers 2 to 5 within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who have liberty to the parties to mention the appeal as and when the same is ready for mention the appeal for enlistment as and when the same is made ready for hearing. Affidavit of service filed to be kept on. Mr. Mitro, please keep this with you.
My lord.
This will be part of the paperwork, and
my lord,
please get copies of the other things also.
Yes, yes.
And today you please at least file the
I will do it within 10-15.
And my lord, only one thing, liberty to file any application, my lord.
That is always there.
But still, my lord, one line, my lord, because already.
No, 30, my lord, I am for the appellant, my lord. My lord, I am bringing apology, my lord. I did not able to comply the order, my lord. I have deposited the special messenger on 13th November, my lord. My lord.
My lord, this is my affidavit in opposition, my lord. I am for the
Ali.
respondent, my lord.
I did not get the copy.
The belated on the oral prayer of the learned advocate for the appellant, comma, the belated filing of special messenger costs is accepted. Full stop. The office shall take steps accordingly for bringing the trial court records by deeming the same, deeming the special messenger costs to have been deposited appropriately. Full stop. Can 1 of 2025 is now taken up for hearing. The affidavit in opposition filed by the respondent today be kept on record. What about your reply?
My lord, I will give it after 2 weeks, my lord.
Did we direct previous affidavits? Did you direct affidavits?
Yes, yes, my your lordship directed.
Then why aren't you prepared with the affidavits? When did you give the copy of the affidavit?
Just he is giving, my lord.
Since a copy of the affidavit in opposition is handed over to the learned advocate for the appellant here and now, comma, the time for filing reply is extended for a week from date. Full stop. The application shall be listed next for hearing on November 25, 2025. Okay, thank you. Tuesday week it will happen. You please give a copy before and don't do like him. Yes.
Number 31.
Yes, Lordship, I am on behalf of applicant, Lordship.
For the opposite party.
Can 3 for limitation, delay of 90 days under section 5 of Limitation Act, and can 4, it is a case of granting probate in favor of the respondent. So, Lordship, I come before this honorable court.
You are challenging the grant of probate?
Yes, Lordship. Yes.
What is your main ground?
Main ground is, Lordship, during argument, the trial court revealed that the issue of this case is not framed. Issue of this case is not framed. At the pair of the respondent petitioner, that trial court issue frame. Subsequently, the prayer of the respondent petitioner, the execution chief has allowed to adopt by the respondent petitioner, but the petitioner objector is not allowed to cross-examine.
Not allowed?
Not allowed, Lordship.
You wanted to cross-examine?
Yes, Lordship, yes. After adopting the execution chief, I have a statutory right to cross-examine.
Yes,
it is not allowed me, Lordship.
What is this application for?
Application
Early
for,
hearing of the appeal, the usual direction.
Lordship, can 3 is for limitation of 90 days delay. And
90 days.
I'll
90 days, 90.
Yes, 90 days. Can 1 is for calling for LCR. Can 2 is for expeditious disposal. All are for appropriate orders.
Except 3.
Can 3 is for limitation. No, I've called out the prayer.
That is not for condonation.
It is for condonation.
This is the only application with the inappropriate orders. And what is can 4?
Can 4 is for stay of a suit.
That is also for appropriate. Why have you captioned all the applications as appropriate order? What is the appropriate order? Other orders are inappropriate. It is contempt of court.
Subsequent of the probate, the respondent file a declared suit and recover a provision. I pray for Lordship to issue a direction upon this trial court.
No, there is no material, my lord.
order of
They have not, Lordship, all these things that they said that there is, I have, the objector did not get, these are
Mr.
beyond
Ali,
pleadings.
this cross examination opportunity was not given.
Lordship,
If
at
not
least
given,
from the
then
documents that have been served on me, it is not evident.
If it was not given, take instruction. We will dispose of the appeal and remand it for cross examination opportunity to be given. Take instruction. We rely on you. Take instruction.
Cross-examination
Come
of
back.
which witness?
Huh?
There
PW1,
are four
PW2, both now.
Both.
No, the two witness, PW1, PW2. I am the OPW. I am OPW in the trial court.
Oh, আমার cross-examination.
Both witnesses.
Lordship
Your
of the-
witnesses, one of your witnesses adopted the other witnesses.
One of the
chief.
distinct witness, Lordship.
But no opportunity was given to him to cross examine either of your witnesses. That is his allegation.
Yes, Lordship.
I shall take instruction on that, my lord.
Take instruction. Come back to. Can you come back tomorrow? Do you have contact with your
We'll
counterparts?
keep it after a week, my lord. Keep it after 2 days. That
After 2 days, we'll keep it on Monday. Wednesday, we'll keep it.
Wednesday.
Lordship, kindly issue direction of Lordship. This case is
On
Yes,
Wednesday,
yes.
we'll take up everything. We pass orders on all of these. Please come back on
I am
this.
very ill, sir, Lordship. There is a blood clot in my knees.
Oh.
I come from Asansol, Lordship.
Oh,
Lordship, kindly.
আপনার কবে সুবিধা বলুন?
No. Not a question of that. He had to come today also.
But the materials, all these things are beyond
No,
pleadings, beyond everything.
Section 5, where is the Section 5?
The section 5 may be allowed at this, my lord.
Which is that application? We are not finding any prayer for Section 5. Condonation of delay.
Can 3 is the one.
Which can is for condonation of delay?
Can 3, Lordship. Can 3.
They have never enjoyed any stay, my lord, throughout the suit.
What is the reason for the delay?
Dear Lordship, appellant is a senior citizen, Lordship.
That itself is not a ground.
I'm filing the medical treatment slip, Lordship, and suffering from.
Where have you filed it? You have not filed any medical
Lordship,
treatment.
can 3 I have filed, Lordship.
This document. Prescription.
Zinkovit.
Lordship, is he suffering from arthritis, Lordship? The appellant, Lordship.
So then how could he recover and come back? Come to from this evidence.
After 9, Lordship, in
71 years. Can 3 of 2025 is an application for condonation of delay of about 90 days in preferring the appeal. So we find from the averments made therein that the appellant is a septuagenarian suffering from arthritis and other ailments. Comma, leading to the delay in preferring the appeal. Next para. Upon hearing learned counsel, comma, we are satisfied that sufficient explanation for the delay has been made out. Accordingly, can 3 of 2025 is allowed, thereby condoning the delay in preferring FA 336 of 2025. The appeal be deemed to stand registered and admitted. Next para. All these other applications are for appropriate order. What is the appropriate order?
Lordship, it is a mistake by my law clerk, Lordship. So, apologize, Lordship.
Don't blame your law clerk. Law clerk has not written the cause settle.
But I submit.
And if you left it to your law clerk to write the caption of the application, that's your mistake.
The typist to make them.
Not the law clerk, the typist.
Law clerk and typist.
No, anyway. Any application for stay, we don't find any application for stay. That is our main concern about your application. What, Lordship? Which is the application for stay? No application for stay.
Can 4.
No, there is no
Can 4.
Yes,
Can 4. Let us see Can 4.
There is stay of another suit.
We cannot stay another suit. No.
No, this is not another suit, Lordship.
Title suit number. Probate suit is not title suit.
Huh?
Probate suits cannot be title suits. There must be another suit.
After getting forward, Lordship, the respondent filed the recovery of poison, Lordship, in the trial at Asansol trial court, Lordship. On the same
On the
property.
basis of this probate, if you continue with this, will
will
not stay this, will moot the prayer and grant stay of operation of this probate.
Lordship will kindly.
General don't, but
Lordship,
we have.
Lordship, they have. Lordship will kindly hear the appeal. Lordship, there is nothing.
That is
They
what
have
precisely
not-
what we said.
They have not.
That if you take instruction that it was actually no
I
opportunity.
shall
was-
take instructions, my lord. Keeps it tomorrow then, my lord.
Lordship,
Not lot.
Lordship, page 9.
My lord, whenever he wishes, my lord.
Asansol. Ground there.
No problem.
Lordship sees how many adjournments had been taken by them.
How many? Just curious.
2020 appeal, my lord. For 5 years, they have not asked for any stay.
Now we are proceeding with the suit eviction suit.
Lordship,
Now it's at an advanced
and
stage.
they have asked for adjournments. The Lordship sees the order sheets.
Obviously, they're asking for stay.
No,
It is in consonance with adjournments. Stay and adjournment are
stay
consonant.
in this appeal. They have not moved their appeal.
No, Lordship, I am the advocate record, Lordship.
This appeal is of 2020.
Lordship, I am the appeal. For that reason, my senior moved this before the Honorable Court. For that reason, it is not
I'm
allowed.
ready, my lord. Whatever document they have, the only document they have produced is the impugned order. And the impugned order,
Sir,
they have
you have taken out
brought
a
4
suit
witnesses.
during pendency of the appeal. If you proceed with an eviction suit, then that will render this appeal infructuous, sir.
My lord, let them. Lordship, there has to be something, my lord, on the basis of which they are saying that there are some prima facie case on the basis of which they have not enjoyed a stay from 2020. This proceeding was filed. The appeal was filed. They have not enjoyed.
That's
the probate proceeding was filed way back, my lord. Probate proceeding was filed in 2008, perhaps.
So you should
2007.
You should have brought a
From
copy.
2007, Lordship, they have not enjoyed anything.
You should have brought a copy of the order sheet so that we could understand that whether why it was closed. Evidence was closed.
Stanford, Lordship, I filed a copy of the
Order sheet.
No, of the case of this project.
Bring the certified copy of the order sheet because we want to ascertain why you are not given an opportunity to cross-examine. Might have been closed because of your adjournment prayers for several reasons. You might have said, don't want to cross-examine. Who knows? We have to look into the order sheet for that. The order sheet, at least after it went to the PH board. After their witnesses. When their witnesses was closed from that date.
No, my witness, he says that my witness was not, he did not get an opportunity to cross-examine my.
That is what we are wanting. When the date on which your witness was closed. That is what we are saying.
Okay.
That from that order we'll get whether what he did, whether he waived that.
Yes.
And from onwards.
And my lord.
And you also bring the order.
Lordship, I shall. My lord, my client, Lordship, is right now in Dinhata, Lordship.
No, Lordship, the client is at Bakura, Lordship. Another will forward case at Bakura.
Client's daughter, Lordship, contacts me. He is in
Another will forward, I make.
You made inquiries.
No. Lordship, I will go there after before
my prayer, Lordship, is Lordship I will not stand in the way if they ask for an adjournment for once, my lord. Next date of hearing.
For an adjournment,
No, my lord, I am not. Next date of hearing is the suit. If they ask for an adjournment, I won't stand in the way.
And the day after that?
Lordship, they have to move, my lord. It's their appeal.
Yes, your eviction suit.
My eviction suit, in my eviction suit, if they ask for an adjournment, Lordship, for once, my lord, I will let them first show any material.
No.
Trial court not allow, Lordship, any adjournment. If there is no order,
I will not stand in the way, Lordship. Lordship, kindly records my undertaking, my lord.
Can 4 of 2025 is an application, in essence, for stay of an eviction suit bearing title suit number 31 of 2022 pending before the first court of civil judge senior division at Asansol district Paschim Bardhaman, initiated by the respondents on the strength
framing of issue
of the probate which is impugned herein, seeking eviction of the present appellant. Full stop. Next para. Yes, what do you say?
Lordship, in that suit, the stage is framing of issue. So, well,
counsel
there
for
is
the
no immediate urgency of being evicted.
Learned counsel for the appellant submits that unless the said suit is stayed, the present appeal will be rendered infructuous, since the very premise of the said suit is the probate granted by the learned testamentary court. For the next para, learned counsel appearing for the respondent opposes such prayer and contends that there has not been a single scrap of paper produced before this court to substantiate the main ground urged by learned advocate for the appellant, to the effect that the appellant was deprived of the opportunity to cross-examine the plaintiff's witnesses. Of that apart, it is submitted that the present appeal was filed in the year 2020, but the appellant was sleeping over the matter. As such, due to the long delay of 5 years in even filing the stay application, the same ought to be dismissed, in view of the lack of bona fides on the part of the appellant, Full stop, next para. It is further submitted that the eviction suit is at the stage of framing of issues, and as such, there is no urgency in grant of stay. So next para, upon hearing learned counsel for the parties, we find that the plinth of the arguments advanced before us is that the learned testamentary court erred in law in refusing to grant opportunity of cross-examination,
And not,
opportunity to the appellant to cross-examine the plaintiff's witnesses.
that is not one of the grounds taken in the memorandum.
Full stop, next para, although it is submitted by learned counsel for the respondent that the same is not one of the grounds taken in the memorandum of appeal, uh, in view of the powers vested in the court to frame issues, particularly by the last court of facts, we accept such ground to be one of the possible arguments by the appellant prima facie. Full stop. Even going by the above, we do not have any paper before us to establish such contention of the appellant. Full stop, next para. Accordingly, we direct the appellant to furnish before us the certified copy of the relevant order sheet, incorporating all orders, at least from the stage when the testamentary suit reached the peremptory hearing board till the final disposal of the same, in order to examine as to whether there is any substance in the contention of the appellant, that the appellant was deprived the opportunity by the testamentary court to cross-examine the plaintiff's witnesses. Pushed up. How soon can we produce that certified copy?
Lordship, 2 weeks.
On the prayer of the appellant's advocate, the time for filing such the matter is adjourned till December 8, 2025, when the applications when can 4 of 2025 shall be listed for hearing next. Full stop. The learned advocate for the appellant, it is understood, shall furnish a certified copy of the order sheet as directed above, with an advance copy to the learned advocate for the respondents. Full stop. Next para. You are appearing for. There's only one respondent, sir. In view of the appearance of the respondent through her learned advocate, service of notice of the appeal on the respondent is dispensed with. Push up. Can 1 of 2025 and can
1, let's say, for transmitting the lower case.
Can 1 of 2025 and can 2 of 2025 are disposed of upon hearing learned counsel for the parties, thereby directing that the trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to liberty to the other. No liberty because it's appearing after 2 weeks.
Can I allow the stay for once, Lordship? Then I'll submit all answers.
Not at this stage.
Otherwise, it is
Not at this stage. At the issue framing stage.
It was already framed, Lordship. It is posted for evidence.
Not at this
frame
stage.
in earlier date.
Not at this stage. Come back with the certified copy. If you are not satisfied, we have to be satisfied that there is a prima facie case. You cannot just argue from the bar that you are not given opportunity to cross-examine. We have to be satisfied on the order sheet.
Item number 32.
Yes.
No cavity is lost, my lord, but on Friday, last Friday, my lord, one communication from Kartik Kumar Rai came in the office of the advocate on record.
Fair enough.
Copy of the application as a memo of appeal to be served, my lord. I'll serve on tomorrow, my lord. Day after, my lord, kindly fix the date, my lord.
We'll put it day after tomorrow?
My lord.
Or after that?
My lord, on by next Monday, it will be convenient for me, my lord.
Learned counsel for the appellant fairly submits that although no caveat has been lodged, a learned advocate of this court has written to the learned advocate for the appellant, intimating that the former wants to enter appearance on behalf of the respondent. Accordingly, in order to enable the learned advocate for the appellant to serve copies of the applications, only one application, to serve copy of the application on the said learned advocate for the respondent, the matter is adjourned.
Also asked for serving the memo of appeal, my lord. I will also serve, my lord.
Very well. Application as well as the memorandum of the appeal, let the matter stand adjourned till November 17, November 24, 2025, when it will next be listed under the same heading.
number 33.
But I'm the respondent number 1, my lord. Although I was initially on caveat, as on the date of filing, probably the caveat had expired by a flux of time. My lord. I was if
No
a
copy
copy.
then. You're not entitled to a copy.
I'm probably not entitled, but if I can come back, my lord, with the
Depends
instructions.
on Mr. Chatterjee. If he wants, he will give a copy. Other copy There's no caveat, no, but give a copy, please.
Yes, I will give him a copy.
What is the matter?
Matter is, my lord, tenant, appellant, eviction suit. My lord, the plaintiff filed the suit on the ground that the rent is 20,000. Initially, it was a license, but subsequently, on request of the tenant, it became a tenancy and the rent was 20,000. My case was that it is not 20,000, but it is 10,000. And the extra amount, that is 3 lakhs rupees, that I paid as security deposit. And as soon as that was completed, so naturally again 10,000, my lord. Initially, what happened for 10,000 as rent and 10,000 towards the security deposit. He accepted it, 20,000. Subsequently, it became 18,000. Naturally, my lord, after a certain period, it becomes 8. And as soon as, my lord, the entire 3 lakhs, it was completed, then, my lord, I started paying rent at the rate of 10,000. He accepted it. Even not only that, after filing the suit, he accepted 10,000. I do not know why, my lord, in the court below this ground was not taken, but I have the copy with me.
The decree is on the ground of default in payment of rent. Why
Yes,
10,000?
yes. Only because.
Why is that relevant? The quantum of rent?
Quantum of rent is according to.
No, why is it relevant? I mean, here.
Yes, it is relevant because it is under the Transport of Property Act.
Oh, this suit has been filed under
Yes, yes. According to plaintiff, it is under the Transport of Property Act. But according to us, my lord, since it is 10,000, not more than 10,000, so therefore it would have come under the West Bengal premises tenancy. We accordingly made an application that was rejected.
You are appearing for, there's only one respondent.
Only one.
No, two respondents.
2 respondents.
You are
I'm
appearing for both plaintiffs.
for one of them. I have instructions only for one of them. But
then we'll direct him to serve a copy.
Yes, yes, I will.
Another copy on the other person who is not appearing. We are granting stay right now.
Yes.
But only thing, my lord,
This is absolutely arguable.
Impugned order specifically states that the rate of rent has been enhanced to rupees 20,000 per month. That is a specific finding of the learned trial court. And
so you say that even if it was originally 10, 18, these things, then it was subsequently enhanced to 20.
This is a finding.
The cut off for premises tenancy, I forgot.
Well,
Above 10,000 for commercial.
Yes,
my lord.
I have, I am reading.
It is commercial, admitted.
Commercial matter. So if it's a specific finding that
if any premises let out for non-residential purpose which carries more than 10,000 rupees as monthly rent in the areas included within the limits of Calcutta Corporation and Howrah, in that case, well, exemption.
But it's 20,000 now, 18,000, 20,000. But these are including those amounts.
Yes, those amounts.
I gave evidence. You laid evidence on that.
Yes, yes.
Yes, my lord. Exhibit 4. That was not considered by the court below. And that is my humble submission before you. That is my main ground. It was not considered.
But you have to put in the occupation charges. If I grant,
this is
eviction suit.
In that case, my lord, if some, my lord.
What?
This is a.
You adjust it from the advocate's fees.
This is beside Charu Market Police Station.
At a rate of 2:1, 2 for you, 2 ratio 2 for you, and 1
and
for
it is Charu Market area. That.
We'll grant him adjournment for a day. You think over it. Charu Market, what should be?
Under the Transport of Property Act.
Whatever act.
I leave it upon your lordship, my lord.
Give him a copy, come back tomorrow, think
Yes,
over
yes,
it, have a
yes.
talk with your client, deal with your client.
Yes.
In the meantime,
it would be better, well.
Please take this back. We'll take this tomorrow. You are appearing for which respondent?
Respondent number 1, my lord.
Learned counsel appearing, the learned advocate appearing for the respondent number 1 seeks a copy of the application, although the caveat lodged initially had expired. For the sake, for the ends of justice, the learned advocate for the appellant is requested to serve a copy of the application on his counterpart appearing for respondent number 1 during the course of the day.
My lord, subject to my lord, one thing that is my lord.
Lunatic.
Lunatic. One is lunatic. And he is being represented by my lord.
That's why he has given you the Vakalat number by himself.
No, not that much.
Anyhow, I will give you
I,
the copy.
So if
he
the
has-
unsound gave you the wakalatnama, then
no,
it's not
no,
valid.
man. His
Check up who has signed.
Mr.
Dinesh or Rajesh?
Rekha Goel has signed it on behalf of Rajesh Bharati, and he has been Rajesh Goel. I'm sorry.
Bharati is them.
I'm sorry. Rajesh.
So Rekha Goel has signed.
Right, Rekha Goel has signed, and he has been adjudicated
যেখানে
to
যেখানে
be
বললাম
the guardian.
যেখানে যেখানে বললাম যে রেসপন্ড নাম্বার 1 ব্র্যাকেটে রিপ্রেজেন্টেড বাই হার legal guardian Rekha Goel. Yes, bracket close. Full next para. কোথায় শেষ করলাম যে a copy be given. During the course of the day. Full the matter shall be listed tomorrow under the same heading. Tomorrow under the same heading? Yes. Give a copy during the course of the day.
Right now I'm giving a soft copy. He's agreeing to take.
Yes, he is agreeing.
Right now I'm giving.
Item number 34.
All right,
I appear.
before my in this matter, my lord, your lordship direction, my lord, on
Yes, my lord, I'm in default.
15th of September 2020.
That's why she said
In terms of your lordship direction, I'm filing
what
my
was the direction? Opposition regarding opposition.
My lord, opposition as well as an
in terms of the,
assets and liabilities in
No,
terms
we-
of Rajneesh and
we
name.
have served, my lord,
So there is a default, my lord, I must.
and my lord, my application for alimony pendentiality for the minor daughter. And my lord, in specifically, I averred in my application that husband, my lord, is the software senior.
No, but
software-
you cannot stall the alimony application by.
My lord, may I just indicate what is the difficulty? My lord, the difficulty
My lord,
is, my lord, the difficulty is, my lord, the husband is a Dutch citizen now. So, my lord, we are having a difficulty in getting the affidavits affirmed. My lord, he
You
will
have to
be,
do it through the embassy, bro.
yes, now, my lord, there's a difficulty with the
They have a
embassy.
different law.
No, no, my lord, no different law, my lord. I'm not being able to actually understand what is the difficulty. What he has told me is that the Indian embassy over there is also having a difficulty with the persons who are with, there's an agency which gives appointments for all these apostle and all, my lord. That is also a problem. So, my lord, the difficult, now, my lord, the silver lining is, my lord, he will be coming and visiting India, my lord, towards the end of December. So, my lord, he
Cannot wait for this. Then we
Yes, my
direct some
lord.
amount to you.
Now, my lord, I have.
You are paying something.
No, my lord, may I just indicate what has
No,
happened?
this is against a divorce decree.
Yes, my lord, the decree has been granted, divorce has been granted.
What was there any amount being paid by you?
20,000 I was paying, my lord.
You directed to pay as an ad hoc basis till that date. For the time being, you'll pay at that rate. 20.
my lord, they are paying 20,000. I have
Yes,
stated
my
in
lord,
my
they have.
application.
We are
My lord, in my
Fair enough.
my specific my lord, averments that blue card holder, husband is blue card holder. I have obtained the my lord.
No, Mr. Datto will pass whatever orders.
Right, your lordship.
For the time being,
For
let
time
those
being, my
payments
lord,
be made.
Some
Whatever payment we may we direct, that will be adjusted.
my lord, paragraph 16.
That will
your
be
lordship.
adjusted with this 20,000.
Right, your lordship. Kindly paragraph 16, your lordship, kindly peruse.
Child's education.
No, my
Only
lord.
child is my lord.
Will kindly at
11.
least hear me out then
Yeah.
before your lordship.
Let me make my
No,
submission.
then we'll have to hear you out on the without the affidavit.
Yes, my lord.
Because you're in default.
My lord,
There are provisions, my lord, the power of attorney holder my lord, can represent.
my lord, there is. I know.
My lord, there was the matter came up the my lord, Lajima court. They did not file the Vokalatnama.
My lord, we were facing this difficulty. Now we have filed it through a
Through power of
constituted
attorney, they
attorney.
can represent.
Lord,
Paragraph 16.
Paragraph 16, your lordship, kindly consider paragraph 16.
Yeah, page 4.
11.
15 টা আমরা বলেছি কত পাচ্ছি?
My lord, paragraph 15, your lordship, kindly consider.
Paragraph 16.
You have already incurred these expenses, 30,000. School fees are paid quarterly generally in all schools.
My lord,
my lord, we pay the school fees.
my
You
lord,
pay the school fees.
That is what my instructions.
only 20,000 they are paying.
No, she's saying that.
15,000 for the minor daughter and 5,000 for the.
No, she's saying that the husband is
my lord.
paying the school fees.
Yes, my lord, and,
No, no, no.
and my lord, I have taken
Have you
instructions.
annexed the receipts or something?
No, no. They are
Or whatever.
in terms of the direction of the my lord, judicial magistrate 125 proceedings, they are paying. I have stated in my application. My lord,
He's in the Netherlands now.
Netherlands, my lord.
Even of the citizenship of India also. My lord, he's
My
a
lord,
Dutch citizen now.
Page 8, your lordship, kindly look into respondent husband from.
So we have to be practical also, Mr. Datto. We'll grant time as a last opportunity. If they don't file the opposition and the asset within that period, we'll record in our today's order that we'll proceed with the application
I am
without
not,
that
I am
opposition.
not opposing anything, my lord, but your lordship simultaneously consider some litigation cost may be awarded.
My lord, will kindly hear me.
20,000 is paying per month.
No, 20,000 per 1 month for 15,000 for the daughter.
she is
That is as per
prosecuting study class 11, 12, and is appearing for the NEET examination. That's why the extensive expenses is required. And my specific case, in the blue card holder, below 6 lakhs per month, no person can be stayed. Blue card holder must be earned rupees 6 lakhs.
You have stated that in paragraph
Yes, paragraph
11.
And presently, he is the SAP consultant.
Don't know his expenses.
Yes.
We don't know his expenses.
No.
The expenses there must be also high.
Right, Your Lordship. Similarly,
we don't know that. I mean, may or may not be high.
Right.
My lord, may I just
Your Lordship, kindly be sure. I am not saying anything. Your Lordship, kindly for the timing,
Give something at pay some ad hoc.
My lord, may I just indicate two things, my lord. My lord, firstly, my lord, I have taken instructions, my lord. My client at present is unemployed. My lord, he's looking for a job opportunity. He's saying that. At the same time, my lord, from whatever savings he has managed to make, my lord, I have inquired this personally. He said he's making all these alimony payments and whatever has been directed by the court. Now, my lord, he has to also maintain himself as well as his parents, my lord, who are undergoing cancer treatment. That is one thing. Second thing, my lord, is that my
don't know the coverage given by the government there. We have no idea.
My lord, those
so
treatments happen in India. Yes, my lord, we'll try and disclose.
Parents are in India.
Yes, my lord, the surgery and all the treatments are happening in Bombay Cancer Hospital, my lord, as I have
So
been
how
told.
is he paying for those
My
without
lord,
any income?
father is also there earning senior citizen, I'm told, but my lord, he's helping in all those payments.
So
now, my lord, the difficulty is, my lord,
your daughter reads in studies in class 11.
Yes, my lord.
Science stream in a CBSE school.
My lord, my client.
Expenses.
My lord, my client is ready to bear the expenses, whatever is required for the daughter as per actuals. My lord, he has given me this instruction. My lord, of course, I need that in writing, my lord. When I file the affidavit, my lord, that will be there in writing. My lord,
Mr. Datta, exactly what are the payments required right now? You have to, and we can direct him to reimburse when you pay.
In my application, with the affidavit, I stated that for the daughter 50,000.
No, not vague like this. You have to make the payments in the first place, Mr. Datta. You are already making the payments.
Yes.
So she's in school now, so you are making the payments.
Yes, my lord.
You just produce those receipts or whatever payments or the school receipts,
in the affidavit, we have enclosed all papers.
Yes. Now, what he has enclosed is, my lord, if I may.
I have served copy to them.
I have a copy.
Let us see.
My lord, there are two things that I would also like to point.
Yes.
My lord, she herself is also earning a substantial amount of
what
money.
amount?
My lord, she's a teacher, primary teacher.
I have stated.
She's earning, yes,
I am.
But I find it from her affidavit.
I have stated.
Your income per month?
46,000
per month.
And my lord,
I have stated.
So then it boils down to the expenses of the child,
in my
minor daughter only.
my lord, investments, monthly return from investments is 27,000 odd.
No.
My lord, if your lordship goes to the banks.
How soon can you file your opposition and your affidavit of asset?
My lord, I am making my prayer, my lord, and then I leave it to your lordship. My lord, I have been told he'll be visiting India in the last week of December.
We cannot be at his mercy. He has to come earlier.
Lordship, my lord, but what he has told me.
Learned counsel for the respondent submits that the respondent is in default in filing the affidavit of assets and the affidavit in opposition. Since the respondent is now a Dutch citizen and is at present in Netherlands. Full stop. Next para, it is further submitted that the respondent is out of a job and as such, but yet is paying an ad hoc amount of rupees 20,000 per month to the petitioner. Full stop. It is submitted that the petitioner also has a substantial income of her own.
May I interrupt?
From her calling as a teacher, as well as from a calling as a teacher, as well as from investments. Full stop. Learned counsel for the appellant submits that the respondent husband is a blue card holder and as such has a minimum income of rupees 6 lakh per month, which is hugely disproportionate with the payment being made to the petitioner wife for herself and the minor daughter of the parties. Full stop. The daughter of the parties is at present studying in class 11 in a CBSE board affiliated school and as such is having to incur and as such the petitioner stroke appellant is having to incur huge expenses on that count as well, comma, since the daughter is in the science stream. Full stop. Next para. Learned counsel for the respondent seeks an adjournment till the third week of December, when the respondent husband is due to come to India next for filing the affidavit of assets and opposition. However, comma, we cannot permit the application for alimony to linger indefinitely for so long, and the petitioner wife to be at the mercy of the husband for getting alimony, which is a legal right. Next para. Thus, comma, as a last chance to the respondent husband to file his affidavit in opposition to the alimony application as well as affidavit of assets of the husband. The time for filing the same is extended till November 30, 2025. Full stop. Reply, if any, shall be filed by December 5, 2025. Full stop. The alimony application shall next be listed on December 8, 2025. But you make an ad hoc payment apart from the 20,000. You make some ad hoc payment. We'll direct you to put in an amount of rupees 1 lakh or something like that.
My lord, a lesser sum perhaps, my lord.
99,999, like the price tags. Not of things we buy. Apart from going on paying the ad hoc amount of rupees 20,000 per month to the appellant wife, comma, the respondent husband shall pay an ad hoc lump sum one-time amount of rupees 1 lakh by November 30, 2025 to the petitioner wife to meet immediate exigencies, including the expenses for the minor daughter of the parties. It is made clear that the regular payments, monthly payments of rupees 20,000 being made by the respondent, as well as such ad hoc payment of rupees 1 lakh shall be adjusted with the quantum of alimony ultimately granted at the final disposal of the alimony application.
And my lord, one line, if you also kindly add. In my application, I have stated that he is not in service.
The affidavit of asset filed today by the appellant wife be kept on record.
In my application, I have stated that he is a SAP consultant, not in service. He is not a question of unemployment, does not arise.
You have just recorded her submission.
Right. Well, deep love, your lordship.
Thank you. Yeah. Application will check. Yes.
35, my lord. I should not interrupt. My lord,
then don't.
No, husband, my lord, in the puja vacation, my lord, he came India.
Whatever your client tells you, you have to come back and tell me.
That is, no. It is not time to make my submission.
Yes. What is your?
My lord, in this matter, my lord, I am appearing on behalf of the appellant, my lord. I am led by Mr. Parthapati.
What is the matter? Again alimony?
No, my
lord. It is
matrimonial.
Where section I am for the respondent.
My lord, in compliance with your lordship, previous order dated, I am filing, my lord, the supplementary affidavit.
My lord,
what is the matter about?
I being a husband got an expertise degree.
Who is the appellant? You tell us what is the appeal against?
The appellant wife, my lord, has preferred this, my lord, appeal.
Don't be so shy about it. You have a right to prefer an appeal. Divorce degree obtained by husband.
Yes, my lord.
You are the wife. You preferred an appeal against that.
The first previous matrimonial suit.
Section 5 was allowed.
No, my lord. That is why, my lord, your lordship were pleased.
Supplementary affidavit. You did not give sufficient reasons there.
Yes, my lord. Sufficient.
What is the delay?
Delay, my lord.
Copy of the supplementary has been given to you previously.
My lord, yes. The order dated 16/9/2025. Your lordship granted me liberty to use composite reply of the original CAN application as well as the supplementary. Lord, this is my opposition. My lord, what has happened? Mistake on my part. My lord, what has happened? I being an husband filed a suit for divorce. I obtained ex parte. During the course of hearing of section 5 before this honorable court, they come up with a facts that I already filed a suit which was in subsistence during the second, my lord, match suit. My lord, I took instruction from my client, though, my lord, I am aware that the reason what he is telling has no...
No, you filed a second suit for?
Divorce.
Against third only?
Yes, my lord. Because
during pendency of the first suit for divorce?
Pendency of the first suit. Because, my lord, I took...
This ex parte degree has been passed in which one? First one or second?
Second one.
First suit was also dismissed for non-prosecution. On the present suit, the second suit where I obtained decree is on 12/12/2024. The earlier suit was dismissed for default on 13/12/2024. Well, it's completely mistake on my
So
part.
this decree could not have been obtained then. It is barred by Order 9, Rule 9.
Before your lordship would be that, my lord, I would not much legs to stand before.
And then we will set aside the entire thing, and because why prolong the agony for both of you? If you set aside, you can file another divorce suit and proceed accordingly. Or is there any chance of settling the matter?
My lord, my client does not want to stay with her.
Any child?
My lord,
Yes, sir.
child is
Two
there,
children.
Two children.
How old?
My lord, one is major and one is minor. One is studying at college, and one is
college means not able to take care of themselves.
They are living, my lord, in same premises.
I am not saying much.
No, we are not sitting in value judgment over your moralities. Not at all. Legally, if you are entitled to a divorce, you will get it. Otherwise, not. So, but if what you are saying is right, then probably the second suit.
Opposition, I also admitted that yes. But the reason what my client provides, my lord, I am aware that
We'll take it up today. This will take some time. We'll
Yes,
hear
madam.
this. This will retain its position.
Can you record, my lord? I filed my
Affidavit in opposition.
Supplementary affidavit, ma.
Supplementary affidavit filed by the appellant and affidavit in opposition, composite affidavit in opposition filed by the respondent today be kept on record. Full stop. Due to paucity of time, the matter cannot be concluded. The hearing cannot be concluded today. Full stop. Accordingly, let the matters be listed. Let the applications be listed tomorrow for hearing.
great.
Obligation.
Wonderful.